raised this matter, and for instance, I've raised it with the Chinese ambassador to London in the past. The Foreign Secretary has raised it with her counterpart, and the Prime Minister as well. So we regularly raise these issues.
Andrew Gwynne.
I refer to my register entry. Mr. Speaker, the latest reports from Xinjiang confirm what we already know, that appalling human rights abuses, genocide and crimes are happening to the Uyghur people. I want to return to the issue of security being used in this country, because the Minister can't just say that this is an issue of commercial nature or security considerations. She's the Minister. This security equipment and these companies are being used by the British government, their agencies and their public bodies. She can say today, we're not going to use them. Why doesn't she?
Minister.
As we've said before, we take the security of our citizens, our systems and our establishments incredibly seriously, and we have a range of measures in place to scrutinise the integrity of our arrangements. But it is the long-standing policy that we don't comment on the details of those arrangements.
We now come to the next urgent question. I now call Tulip Siddiq.
Here. To ask the Secretary of State for Foreign, Commonwealth and Development Affairs if she will make a statement on my constituent Nazanin Zaghari-Ratcliffe's forced confession.
Minister.
Thank you, Mr. Speaker. The treatment of Nazanin by the Islamic Republic of Iran has been horrendous. Her ordeal was exacerbated when Iran made clear they would not allow her to leave Tehran airport unless Nazanin signed a document. A UK official was present to help facilitate both Nazanin and Anousheh Azori's departure and passed on the message from the IRGC that she needed to sign a confession. Given the situation Iran put Nazanin in at the airport, she took the decision to sign the document. No UK official forced Nazanin to do so. Iran has a practice of insisting that detainees sign documents before they are released. Nothing about the cruel treatment by Iran of detainees can be described as acceptable, including at the point of release. We will continue to raise human rights concerns with the Islamic Republic of Iran, including over its detention of foreign nationals. The government of Iran must end its practice of unfairly detaining British and other foreign nationals, and we will continue to work with like-minded international partners to achieve this end.
Thank you, Mr. Speaker, very much for granting this question. And every time I ask the question, I hope it's behind me. And when we celebrated Nazanin's return in the chamber, I thought I was on my final urgent question. But this is my 9th urgent question on Nazanin Zaghari-Ratcliffe after the shocking revelation that she was forced to sign a confession under duress before she boarded the plane back to the UK from Iran. For days in the run-up to her release, the Iranian Revolutionary Guard had tried to make Nazanin write out and sign a document listing the crimes she was wrongly accused of, admitting guilt for them, requesting clemency and promising not to sue or criticise the Iranian government. At Tehran airport on 16 March, on the day she was eventually allowed to fly back to the UK, she was asked again to do this by Iran, but instead she tore up the piece of paper. It was only when a UK official told her that she had to sign it if she was going to board the plane that was waiting to take her home that she finally caved and gave Iran what they wanted. Nazanin returned home, but the toll this took on my constituent after 6 years of detention is unimaginable and unacceptable, and I do not accept what the Minister is saying, that no one forced her. Nazanin knew she could not get on that plane if the UK official had told her she had to sign that document to board the plane. The human rights organisation Redress has this week written to the Foreign Secretary setting out the view that the forced confession was, and I quote, part and parcel of the pattern of torture Mrs. Zaghari-Ratcliffe has suffered since she was first detained in 2016 as it involves further infliction of severe suffering, and that by telling her to sign the forced confession, it appears that UK officials were complicit in an unlawful act by the Iranian authorities in violation of government policy. I do not have to tell the Minister and anyone else in this House how serious an allegation this is, and one that Redress and Nazneen's family, including her husband, who is in the gallery today, argue is part of a systemic failure to respond to torture British citizens by foreign governments and hold them to account. I would like to ask the Minister the following questions. What was the reason that my constituent was required to sign a forced confession? Did the Foreign Secretary or the Prime Minister personally authorise UK officials to advise Nazneen to sign the forced confession, or was that decision taken by officials without their knowledge? What is the legal status of the forced confession and Nazneen's 2 convictions in Iran in UK law, and how can they be annulled? Is there any link between the UK's government's refusal to accompany Nazneen to her trial in 2021 and the forced confession? And finally, will the Minister acknowledge and denounce Nazneen's torture in Iran and commission an independent review of the UK's approach to torture of British citizens in Iran?
Minister.
Thank you, Mr. Speaker. And I thank the honourable member for her questions, and also that she's raised Nazneen's case so many times in this place. As I said in my opening remarks, the Iranian authorities made clear at the airport that they would not allow Nazneen to leave unless she signed a document. I also said that the UK official present passed on the message to Nazneen, and given the situation Iran put her in, she agreed to sign it. The UK official did not force Nazneen to do so. And I just on this, Iran put Nazneen through a cruel and intolerable ordeal, and FCDO officials raised allegations of torture with the Iranian authorities at the time. We've not received a response on these, but Iran is under no doubt our concern at their treatment and our human rights concerns more generally.
Robert Gently.
Thank you, Mr. Speaker. The news that Nazanin Zaghari-Ratcliffe was forced to sign this so-called confession is just the latest evidence of contemptible, despicable treatment of her by the Iranian authorities. Can I ask the Minister, in light of that and all the other malign activities of the Iranian regime that we know of, why is it that British officials in Vienna are currently supporting an agreement that would remove the IRGC from the foreign terrorists list?
Shocking.
Are those reports correct? And if so, will the Minister give me an assurance the United Kingdom government will not put its name to any such agreement?
Minister.
Answer.
So I think, what I would say in response to the negotiations in Vienna, we have kind of reached the end of talks in Vienna to restore the nuclear deal. The deal on the table would return Iran to full compliance with its JCPOA commitments and return the US to the deal. The deal represents a significant, comprehensive and fair offer to Iran, which would benefit the Iranian people. Iran should urgently take the offer on the table, because there will not be a better one.
We now come to the Shadow Foreign Secretary, David Lammy.
Well, I'm very grateful to you, Mr. Speaker, for granting this urgent question, and I think the whole House is hugely grateful to the tenacity of the member for Hampstead and Kilburn. It's right that this whole House celebrated when Nazanin Zaghari-Ratcliffe was finally released after 4.5 years in unlawful and cruel detention by Iranian authorities, but it remains the case that this government, and particularly the Prime Minister, have serious questions to answer over its gross mishandling of the detention of her and other British nationals in Iran. As Nazanin said herself, Boris Johnson's mistakes had a lasting impact, and she lived in their shadow for 4.5 years. We recognise the sensitive and difficult negotiations that led the agreement for Nazanin's release, but it is incredibly concerning that she was forced to sign a last-minute false confession as a condition of her release. Did the UK government agree to this condition? And if so, was it the Foreign Secretary or another official who signed it off? And what is the government's assessment of how the confession could be used by the Iranian government against Nazanin in the future? Mr. Speaker, the government must also answer on its failure to secure the release of the British-Iranian Morad Tarbaz, who remains languishing in an Iranian jail. Tarbaz's family were repeatedly told by senior politicians and officials at the Foreign Office that he would be included in any release deal. Clearly, this did not happen. And in the House on Wednesday the 16th, when I asked the Foreign Secretary about this case, she said, "We've secured his release on furlough. He is now at home." However, Tarbaz's family have been clear that this is untrue. He was released for a mere 48 hours and has since been returned to an abhorrent and appalling conditions in prison. It's shameful that Iran continue to use him as a pawn. I wrote to the Foreign Secretary about it. I received a response this morning. I thank her for that response in the last hour, but we must have transparency. So can the Minister tell us why Morad Tarbaz has not been able to return home to the UK alongside Nazanin and Anoush Shakuri and his family as was promised? What progress is being made to secure his release? What progress has been there on securing his release to the UK as previously promised and privately promised? And what is the progress on securing a visa for his wife to get through this travel ban?
Minister.
I thank the right honourable gentleman for his questions. I think I've already set out in response to a number of other questions the situation in terms of Nazanin and the situation she found herself in. And Iran does have a practice of insisting that detainees sign documents before releasing them. But be clear, the UK official did not force Nazanin to do so. I did want to also pick up on his questions relating to Morad Tarbaz. The Iranian government committed to releasing Morad from prison on indefinite furlough. Iran has failed to honour that commitment, and we continue to urge Iranian authorities at every opportunity to release him immediately.
Carmichael.
Thank you, Mr. Speaker. The revelations today just add to the horror that we all feel about the continuing treatment of Nazanin. But she's not the only UK dual national, either in Iran or elsewhere, to suffer this. Can I bring to the Minister's attention the case of Ala Abdel Fattah, a UK-Egypt dual national currently detained in Egypt, who's been tortured and who is on hunger strike and has been for 53 days. Will the Minister meet his family and make representations to the government of Egypt, hopefully with the same vigour that she has done in relation to Nazanin?
Minister.
I'm grateful to the honourable gentleman for raising that particular case, and I would like to reassure him that the FCO is supporting Mr El Fattah and are urgently seeking consular access to him. We are in contact with Egyptian authorities about his case and have raised it at the highest levels.
We now come to SNP spokesperson Alan Smith. Sorry.
Thank you, Mr. Speaker. I'd commend the member for bringing this question forward, and yourself, Mr. Speaker, for granting it. I'll confess I hoped we'd spoken about Nazanin for the last time in this House, but I very much agree this really does need to be dug into properly, and I would salute Nazanin and Richard's bravery and indeed dignity, an ongoing dignity, and it's a great failure on all of our parts that we're still needing to look at this. But I think this boils down for me to a really quite fundamental point. Whether this last-minute confession was a surprise to the FCDO officials, it was certainly a surprise to Nazanin. Was this part of the deal? The Minister said today that Iran has a long-standing policy of demanding, extracting last-minute phony confessions. So was this part of the FCDO deal? And I acknowledge that these deals aren't whiter than white. I don't think any of us are naive on that point. But was this part, this phony confession, this illegal phony confession, part of the deal? And if it was, who in the FCDO signed it off? Because the fact that the UK FCDO is complicit in that illegality, and I'll happily be told that's not the case, will surely give deep moral hazard for other hostages elsewhere, and indeed the credibility of the UK government anywhere in any talks at all. If it was a surprise, and this was bounced on the FCDO official at the last minute, then what protest has been made since? And what assessment has there been in terms of, for Nazanin's family still in Iran, what this phony confession will do for their security and their situation, given that this will be used as a tool by the Iranian government against them?
Thank you, Mr. Speaker. As I set out in an earlier answer, the Iranian authorities made it clear at the airports that they would not let Nazanin leave unless she signed a document. And the UK official passed on the message to Nazanin, and given the situation that Iran had put her in, she agreed to sign it.
Rachel Maskell.
Thank you, Mr. Speaker. While the Iranian regime is fully responsible for the plight of what's happened for 6 years to Nazanin Zaghari-Ratcliffe and Anousheh Ashouri, it is clear that the actions of the Foreign Office has not helped at many steps of their journey. Therefore, can we have an independent inquiry as to the actions and inactions of the Foreign Office, which has hindered much of the progress that was wanted to be made?
Minister.
I think what I would say in answer to that question is that diplomats within the Foreign Office, civil service within the Foreign Office work day and night, and they have worked day and night to secure the release of Nazanin and Anousheh, and also in many cases, consular cases across the world.
Thank you, Mr. Speaker. The Minister's been asked twice, so I'm trying a third time. Did the Foreign Secretary or the Prime Minister personally authorise UK officials to advise Nazanin to sign the forced confession at the airport in the way she has described? Or was that decision taken by officials without their knowledge?
Minister.
As I've made clear on several occasions now, the Iranian authorities made clear at the airport they would not allow Nazanin to leave unless she signed a document. And as I say, the official passed on the message to Nazanin, but the UK official did not force Nazanin to do so.
Christine Jardine.
Thank you very much, Mr. Speaker. What we've heard today is just the latest horror of 6 years of mistreatment of Nazanin Zaghari-Ratcliffe by the Iranian government. And no one is suggesting that the officials in the Foreign Office have not done everything they possibly could. But what we've heard today also adds to the suspicion that we do need assurances about the British government's actions and whether or not they contributed in any way to the difficulty in getting Nazanin home. So can we please have that independent inquiry so we can be reassured?
Minister.
As I said in earlier answers, the officials and ministers over all the time that Nazanin was detained and with the horrific experience that she went through, worked tirelessly to secure her release.
Thank you very much, Mr. Speaker. In 2017, the Prime Minister said that Nazanin was teaching people journalism in Iran. And she now says she lived in the shadow of his words for the rest of her time in prison. He has never retracted those words. He has never apologised for the harm he personally caused Nazanin and her family. Can the Minister tell us why?
I think, first of all, it was always in Iran's gift to release Nazanin and Anousheh. And the UK will never accept our nationals being used for diplomatic leverage. But the Prime Minister has previously apologised for comments made about the case in 2017.
Anna Bardell.
Thank you very much, Mr. Speaker. I'm grateful, and I am delighted to see Nazanin home and pay tribute to the work and the dedication of her husband Richard, who I've met a number of times as the chair of the all-party group on deaths abroad and consular services, and nobody is disputing the great work that the staff in the Foreign Service do. But the reality is the cuts that this government are bringing to bear and the behaviour of the Prime Minister and his words, as the member previously said, put a huge amount of pressure and did a huge amount of damage to Nazanin's situation. So we need to understand the details of the forced confession, but we also need to understand what this government is going to do to make sure that British citizens abroad who are incarcerated or who die in suspicious circumstances get the help and the support that they deserve.
Minister.
I'm grateful to the Honourable Lady for actually kind of making the point that our officials and diplomats kind of do work tirelessly on consular cases and ensuring that those who are unfairly detained are released. But they are working across the globe to ensure that we support our British nationals.
James Shannon.
Thank you, Mr. Speaker. Can I thank the Minister for her reply to the UQ? Can I also commend the Honourable Lady for Hampstead and Kilbourne for all that she does. She quite inspires us in this chamber, and we thank her for coming for every case that she comes for, and thank her for that. Does the Minister not agree that the media story and confirmation of this forced confession is a serious one, because it seems to be signed under protest? And the thought that one of our diplomatic officers, with great respect, was present is a sobering thought that must be used to improve the service provided to our citizens overseas. So how does the Minister believe we can improve support for our citizens of this great United Kingdom of Great Britain and Northern Ireland?
Minister.
I think I've answered the questions in relation to the circumstances itself. But I think what I would say is, we stand ready to work with Parliament and the Foreign Affairs Committee in terms of its inquiry.
That completes the urgent question. The clerk will now proceed to read the orders of the day.
Northern Ireland Troubles.
Sorry, there's a point of order, Jamie Stone.
Thank you very much, Mr. Speaker. On a point of order, on Thursday as last week, the 19th of May, the Secretary of State for Digital, Culture, Media and Sport misrepresented several official statistics during a DCMS committee meeting. The Secretary of State made incorrect claims about the level of public support for the privatisation of Channel 4, about how much revenue the independent production sector earns from Channel 4, about Channel 4's contributions to levelling up in comparison with other public sector broadcasters, and about Channel 4's current and projected financial position. Mr. Speaker, I do ask that the Secretary of State comes to the Chamber to correct the record of the above and any other misrepresentations that were made during the DCMS committee meeting last week.
The Chair is not responsible for the accuracy of members' statements made in the Chamber or in committees. It is, of course, important that committees get accurate responses from ministers and others. There are opportunities for the committee to pursue the issue if they believe inaccurate answers have been given, and I am sure they will consider whether and how to pursue that matter. I know the honourable member won't leave it here, and he will pursue through other channels that are available to him to make sure that the record will suit what he desires, no doubt. Right, we'll try again. The clerk will now proceed to read the orders of the day.
Northern Ireland Troubles Legacy and Reconciliation Bill, second reading.
Now. Marvellous. The reason amendment has not been selected, so therefore I will call the Minister to move second reading. Secretary of State.
Thank you, Mr. Speaker, and I do beg to move that the bill now be read a second time. The Troubles represented a terrible period in Northern Ireland's past and of these islands as a whole. It claimed the lives of some 3,500 people in Northern Ireland, across Great Britain and in Ireland. It left tens of thousands injured and impacted all aspects of our society. Many across the whole of our country still bear the scars, both visible and invisible today. That Northern Ireland in 2022 has come so far in so many ways is a testament to the spirit and strength of its people and the vision, bravery and determination of those who forged the Belfast Good Friday Agreement. It is also testament to the sacrifice of those men and women who went out each morning to uphold democracy and save lives, rather than those who went out to take them. Looking around today, I see many wonderful examples of a transformed, inclusive, peaceful Northern Ireland. Yet despite this exceptional progress, the Troubles do continue to cast a shadow over all those impacted and wider society. Community tensions and divisive politics can undermine stability. This legacy of the Troubles is an issue that successive governments have attempted but ultimately been unable to resolve, because it does concern one of the most complex, sensitive and difficult periods in our country's history. But what we cannot do is, as a result of that, stand by and do nothing. We cannot let the status quo continue. To do that would be a dereliction of our duty to the people of Northern Ireland and to those who served their country during that dark period. It would be a dereliction of duty to families across the United Kingdom who still seek answers about what happened to their loved ones, in some cases over 50 years ago. This government recognises the huge challenges involved in seeking to address Northern Ireland's past. And we have a responsibility to ensure that future generations do not suffer in the same way as those who have gone before them. Every year that goes by, the opportunity to obtain answers for those who lost loved ones in the Troubles diminishes further. We have a responsibility to ensure that children can grow up together, be educated together, and to understand all aspects of our shared past, a past that at times was bitter, difficult, and inordinately painful for everyone involved. The current system is broken. It is delivering neither justice nor information to the vast majority of families. The lengthy, adversarial and complex legal processes do not offer the most effective route to information recovery, nor do they foster understanding, acknowledgement or reconciliation. Faith in the criminal justice model to deal with legacy cases has been undermined. The high standard of proof required to secure successful prosecution, combined with the passage of time and the difficulty in securing sufficient evidence, means that victims and their families very rarely, if ever, obtain the outcome that they seek from that process. I'll just make a little bit more progress, then I'll give way. We need to be honest about the limitations of focusing on criminal justice as a means to secure truth and accountability in relation to what happened to those who were killed or injured. It is arguably cruel to perpetrate false hope, whilst presenting no viable alternative to deliver the information that so many families and their survivors seek. That's why we are introducing legislation that seeks to address this most difficult and sensitive of issues. Happy to give way.
For giving way. Secretary of State, you mentioned earlier on the fact that those who served in uniform and did so. Can I just remind the Secretary of State very gently, but very kindly, but very seriously as well, Kenneth Smith, my cousin, Daniel McCormick, his friend, both in UDR, neither of them were able to. Excuse me. No IRA man was ever made accountable for their murders 51 years ago. Stuart Montgomery, 20-year-old wee police officer, murdered, I say, Pomeroy. No IRA man was ever made accountable for his murder. The 4 UDR men killed at Ballydugan, John Birch, Stephen Smart, John Bradley and Michael Adams. 4 men who served in their uniform for this country. No one was made accountable for their murders. Secretary of State, you can understand the angst and the agony that I have for my constituents on behalf of that. I want to have the justice that they have been denied for over 50 years, and in the case of the 4 UDR men for 32 years, Sunday past. Secretary of State, what are you doing to make sure that happens?
Well, the honourable gentleman, I think, gives a very powerful and clear outline of the difficulty and the pain that people feel, as he showed just there, with what is a very complex and sensitive area. And I think he's made that point better than almost anybody else could do with the way he's outlined that. That is exactly why, and what he's touched on is the very issue of the challenge we have about the ability, as we've seen over this last few decades, the failure of the current system to be able to bring that accountability, that understanding, that truth for people. As I'll outline over the next few minutes, that's exactly what we want to achieve with this legislation, is an outcome that means that people get the truth, and with that does come accountability. And he's absolutely right to be focused on that for his constituents. I'll give way to the honourable gentleman.
Like the matter of offence for Strangford, I've met many victims of the violence, or anyway the loved ones of those who died. They still want the Stormont House Agreement to be implemented, because the Secretary of State, Madam Deputy Speaker, has got to account for this. The civil proceedings in the Ormo Road events revealed a lot of detail. The Kingsmill inquest, the Ballymurphy inquest, all revealed truths that had not been known. That, what he describes as adversarial style of justice, seeking justice, actually does work. This, it will disappear, and he's got to account for that.
Oh, well, look, I was just saying to Honourable Gentleman, it's not going to disappear. What we're looking to do is actually have a full, independent, investigative Article 2 compliant process, but I will touch on that as I go through over the next few minutes. I'm just going to make a bit of progress, and then I'll take some more interventions. Drawing its core principles from the important work, and the Honourable Gentleman mentioned Stormont House, the principles of Stormont House, this legislation is focused on exactly that point: effective and timely information recovery, providing answers and accountability that comes with that, both to families and to survivors, as well as aiding reconciliation and helping society move forward. It would deliver on our manifesto commitment to the veterans of our armed forces, security services and the Royal Ulster Constabulary, providing the men and women who served in Northern Ireland to protect life with the certainty that they also deserve, and many of them, of course, also victims and friends and family of victims as well. No longer will our veterans, the vast majority of whom served in Northern Ireland with distinction and honour, have to live in perpetual fear of getting a knock at the door for actions taken in the protection of the rule of law many decades ago. With this bill, our veterans can have the certainty that they deserve, and we will fulfil our manifesto pledge to end the cycle of investigations that has plagued too many of them for too long. Madam Deputy Speaker, I want to acknowledge the many honourable and right honourable members across this House, in particular the honourable members for Rayleigh and Wickford and Plymouth Moorview, as well as right honourable members for Chingford and Woodford Green and New Forest, and the honourable member for Barnsley Central, who have campaigned tirelessly on this issue and with great dignity. Indeed, I recognise that many victims and veterans groups more widely across Northern Ireland and Great Britain have campaigned for a long time for better outcomes for victims and survivors. We were clear when we published our command paper last July that we would listen to feedback with an open mind. Over the last 10 months, my team and I have done just that, hearing the pain and perspectives of people from all viewpoints and communities. During those conversations, we have repeatedly had to confront what is a very painful reality, that with more than 2/3 of trouble-related cases now 40 years old, the prospect of successful prosecutions is vanishingly small. And that's why this legislation does mark a definitive shift in focus to put information recovery for families at its core in recognition of that.
The Secretary of State for giving way, and in all candour, I really do not envy him his task here. He's described it as painful and difficult and sensitive, and all these words are absolutely correct. But this is not the first time that we have been in this situation, and since the days of John Major and Tony Blair, the only way we have been able to make progress is to get everybody together, build the consensus and then bring the legislation. It is surely apparent already from today's debate that he doesn't have that consensus, so what does he hope to achieve by bringing forward the legislation?
Thank you, Madam. Look, the Honourable Gentleman makes a reasonable point, and this is, as I've said, as he rightly acknowledged, a very difficult and painful area, an area that there hasn't been consensus. Even with Stormont House, of course, there wasn't cross-party full consensus. And that's why there are times like this, where listening to everybody and listening to the parties, the victims groups, as well as veterans groups and political parties, it is sometimes for us in government to take those difficult decisions, to find a way forward that can deliver a better outcome for people as we move forward in the future. Give way to the Right Honourable Gentleman.
Grateful to the Secretary of State for giving way, and I think I heard my name in the list that he read out earlier. The Defence Committee, as early as April 2017, recommended a statute of limitation combined with the truth recovery process. And one reason we felt able to recommend this was that the 1998 Sentences Act meant that no one, no matter how many murders they'd committed, could face a jail sentence of longer than 2 years, which meant being released in 1 year or 18 months at most. So there's no question of punishment fitting the crime. and there's no question of it not being the same for service personnel and terrorists. That Act already established that. So the question is, what will stop the process? Because the process of trying elderly veterans is the punishment rather than the sentence.
My right honourable friend makes an important point. Yes, I'm very aware the Select Committee made 2 reports into this area, which I think is something well worth people reading through and looking at, and recognises the changes that there have been. That means that the criminal justice system around this is not like the criminal justice system for other types of crimes across the United Kingdom. And I'll touch on this in a few moments. The reality is, after the Belfast Good Friday Agreement, we did have the Sentencing Act. We have had decommissioning, among other things that I'll touch on in a moment, which means that there is this point at which, for us in government, it's looking at what can we do based on the reality of where we are, with a very difficult, imperfect situation that has developed through difficult decisions made in the past to deliver a better outcome in the future. And it also is about, I'm just going to make a bit of progress, then I will give way some more. And it is also about understanding that, regrettably, there has been a distorted narrative of the past developing over a period of time. This legislation will help ensure that more victims and survivors, some 90% of whom, of course, are victims of terrorist violence, are able to obtain answers about those who caused them. Yes, absolutely.
For giving way. Alexei Cummins, who was murdered in Serban, the person who killed him escaped across the border with an on-the-run letter. So can I ask the Secretary of State, where's the justice for Alexei Cummins' family when it comes to when he has an on-the-run letter and gets away with it and has a very prominent position, very prominent role in a political party across the border? Where's the justice, Secretary of State?
If the honourable gentleman will bear with me just a few minutes, I will answer that very question very specifically, and I'll just give way to my honourable friend.
Secretary of State, I applaud the intent of this bill, and I want to see the end of the harassing of our veterans, people who have served this country well in uniform. But he mentions accountability, he talks of accountability a lot. Where is the accountability in the granting of immunity to people who have murdered or seriously maimed other people?
One of the things that's been very clear, my honourable friend makes a very important point. One of the things that's been very clear in talking to victims groups, and obviously one of the challenges with this issue is different people, even within the same families, can often have very different views about what they see as a successful outcome in terms of finding a resolution for their family, or information and understanding, and with accountability. And with that information, as the bill will outline, can come accountability. And he's absolutely right. It is right that we have accountability, but as my right honourable friend, who was chairman of the Defence Select Committee, outlined in his report, of course we can't have that kind of justice in the sense of the punishment fitting the crime following what was done in the Sentencing Act. And I'll touch on that in a few moments. Yes, I'll give way to him.
I'm grateful to my honourable friend, and I'm listening very carefully. Can I just ask him a linked question? The first is that isn't one of the problems that we've got here is that those who can be pursued through the courts tend to be those who are working on behalf of the government, because there are records well kept and of huge detail. Those who were committing terrorist acts, or whichever side of the community they were, there's very little in the way of records. So the question I ask is, what in general terms, and then specific, will happen to the letters of comfort which have caused such chaos in many of those cases?
My right honourable friend makes the same point, and I will deal with that issue very, very specifically in just a few moments. My message, I would just say to victims and survivors, many of whom have engaged with us since we published the command paper last year, is that we have listened, and carefully. We understand that no matter how small the prospects of a successful criminal justice outcome, that possibility is something they don't want to see removed entirely. And I know that despite the changes we have made, this legislation will nonetheless remain challenging for some. I want to say directly to all those individuals and their families, we as a government respect the personal tragedies that drive their determination to seek the truth and accountability for the losses they have suffered. I share that determination. The government is not, and would never ask them to forget what they have been through in the name of reconciliation. This is about finding a way to obtain information and provide accountability more quickly and more comprehensively than the current system, and in a way that does aid reconciliation both for them and for the whole of Northern Ireland. In a few moments, I'm just going to make a little bit of progress, but I will give way some more. I'm immensely grateful to the many people who have engaged with us, sharing their deeply moving experiences and to helping us understand the sheer frustration and hurt that they feel over the loss of loved ones. Every tragedy remains raw, as we've seen even already this afternoon in this chamber, with the pain of many as strong today as it was on the day it happened.
The Secretary of State giving way. It's a question specifically on the point around engagement. There was engagement around the command paper, and the Secretary of State will know that virtually every victims group in Northern Ireland and every political party had major concerns around that. But in terms of this revised legislation, can the Secretary of State actually tell us with whom has he and his officials engaged with around the details of this bill? Because as far as I can see, not a single victims group in Northern Ireland has been engaged with on the details, never mind actually supports it. Yeah. The Northern Ireland Human Rights Commission, with whom the government has a statutory duty to consult, have not been engaged with. The political parties in Northern Ireland have not been engaged with. So who exactly has the government engaged with around the bill before us today specifically?
Well, look, I don't recognise that I say, description of events from the honourable gentleman. There has been wide engagement on this, both with political parties, including his own, just last week, as well as parties more widely as well. And I'll just turn to the contents of the bill itself. The first part of the bill provides that for the purposes of this legislation, the period of the Troubles is defined as beginning on the 1st of January 1966 and ending with 10th of April 1998, the date of the signing of the Belfast Good Friday Agreement. Part 2 of the bill provides for the establishment of a new independent commission for information recovery tasked with carrying out robust, effective and thorough investigations into the death and injuries that occurred during the Troubles for the primary purpose of information recovery. We do recognise the importance of this new commission being able to deliver its functions with absolute independence, and that this will be crucial to gaining the trust of families, survivors and individuals who decide to engage in the information recovery process. And that is why the UK Government will have absolutely no involvement in the Commission's decision-making process. The new Commission will have all the necessary policing powers to conduct its own thorough investigations, including the ability to compel witnesses and test forensics. Just one moment, I will. The body will be supported for the first time by a legal requirement of full disclosure from UK Government departments, security services and arm's-length bodies to make sure that it can gather all of the evidence it needs to establish what happened in each case.
I recognise that my right honourable friend and the Government are doing their level best in good faith to deal with a sensitive and intractable situation. Will he recognise that the establishment of the Goldstone Commission in South Africa, where it is not an exact parallel but there are similarities, was itself beset by considerable controversy at the beginning, but that its ultimate success was largely due to the stature and integrity of Justice Richard Goldstone as its chair. He was a former Supreme Court judge of South Africa and a former prosecutor of the international tribunals in both Yugoslavia and Rwanda, therefore a man of impeccable integrity and independence. Will my right honourable friend make sure that when we look for someone to be the Chief Commissioner, that's exactly the sort of person we need to be looking for, someone experienced in these jurisdictions, but not necessarily even from the UK's jurisdiction, but someone of that level of standing? That's going to be critical, isn't it, for the credibility of the decisions that the Commission will be entrusted with.
My right honourable friend is absolutely right. Both in the example he gives and another one which I will reference later as well, is the way that Operation Canova has been so successfully led. That was also had some scepticism in the beginning, but has shown that a piece of work, if properly done by the right people, is able to gain that credibility and acceptance and understanding from people. And I think he gives a very good outline of exactly how this can be taken forward in a successful way for people. And we as a government do accept that, yes.
It's great to my right, my friend. Can I too commend the government for doing all that it can to deal with this very, very sensitive, as we've seen today. And having served out there on 3 tours, I quite understand where this sensitivity comes from. The question I would like to ask is if this commission is going to find the truth. The likelihood is, as my right honourable friend has said, from the soldiers' side, the evidence is there. On the other side, on both counts, the terrorists on both sides of the divide, it's not. So how are the victims going to get this peace that we all want them to have when the truth is unlikely ever to be found?
Well, my honourable friend makes a a very good and important point, and he's quite right. And one of the challenges that we've seen is this balance point that I made a few moments ago. And one of the things that I think is important as we go forward is, firstly, obviously, the records that people have access to are going to be made available in a way that they've not been made before, going beyond what we've done before with a legal duty for the first time on government departments and agencies and bodies. That means there will be a whole range of information for the body to look at. And of course, if people are coming forward with information, that does mean, particularly with the demand-led process, as I said, as I'll be outlining in a few moments, we have a process that means there is an opportunity for people to be able to seek, with an investigatory body with those kind of powers, the ability to look into these crimes that were committed, as I said, but in vast majority of cases, as he has rightly outlined, by those who went out to do harm, by terrorists in Northern Ireland. And we as a government do accept on that point that as part of this process there will be information released into the public domain that may well be uncomfortable for everybody. It is important that we as government acknowledge our shortcomings, as we have done previously during that immensely challenging period. It is also important, as honourable friends have already said this afternoon, it is also important that others do the same. Some families have told us they do not want to revisit the past, and we must also respect that. The new Commission will therefore be demand-led, taking forward investigations if requested to do so by survivors or the families of those who lost their lives. And the Secretary of State will be able to also request a review, ensuring that the government is able to fulfil its obligations with regards to the European Convention on Human Rights. Happy to give one.
I thank the Secretary of State for giving way. He made the very interesting phrase that others must play their part. In the Northern Ireland Affairs Select Committee, we have heard evidence that hundreds of people were murdered along the border between Northern Ireland and the Republic of Ireland, that those terrorists then fled for sanctuary to the safety of the Republic of Ireland and stayed there. What assistance, if any, has been given by the Republic of Ireland? Or will any evidence that is gathered there never be made available to this situation in Northern Ireland? And will we therefore have a blind-sided, one-sided process that doesn't allow for the Republic of Ireland to be held to account for its covering over and hiding of those terrorists for decades?
Well, I know there are cases that colleagues, the honourable gentleman and others have raised in the past, both with myself and with the Irish Government. And one of the things we outlined in the papers that were signed off and agreed by myself and the Minister for Foreign Affairs of the Irish Government about a year ago, actually coming up for a year ago, the Irish Government also committed to bringing forward legislation potentially in Ireland as well about information recovery to deal with that very point. I haven't seen that yet. I do hope that we will see something on that from the Irish Government soon to ensure that we are working in both jurisdictions to ensure that people have as much access to that information as possible. Written reports of the Commission's findings will be provided to the families or survivors who request an investigation. These reports will also be made publicly available, ensuring that wider society can access the Commission's findings and understand and acknowledge the events of the past, therefore giving accountability. Since publishing our command paper, many individuals and organisations told us that an unconditional statute of limitations for all troubles-related offences was just too painful to accept. They said we mustn't close the door on the possibility of prosecutions, however remote those chances may be. And we have heard those in our veterans community as well, who are uncomfortable with any perceived moral equivalence between those who went out to protect life and uphold the rule of law and terrorists intent on causing harm. And of course, there never could be a moral equivalence of that type. And that is why we've adjusted our approach to a conditional model. To gain immunity, individuals must provide an account to the new Commission of their involvement, if asked, which is true to the best of their knowledge and belief. That draws parallels with aspects of the Truth and Reconciliation Commission implemented, as my right honourable friend outlined, in South Africa. The Commission will require individuals to acknowledge their involvement in serious trouble-related incidents and to reveal what they know. And turning to a point that a couple of members, my honourable friend and others, have made already this afternoon, these provisions will also apply to individuals who have previously been provided with the so-called on-the-run letters, letters of comfort. These letters, when issued, confirmed whether or not an individual was wanted by the police based on evidence held at that time. However, I want to be crystal clear that these letters have absolutely no legal standing and cannot be used to prevent prosecution under this new approach.
Thank the Secretary of State for giving way. Just on the issue that he's now raising on the OTR letters, would he agree with me that some of us have stated at the time and since that the only way the people of Northern Ireland and across the UK can understand and believe that the OTR letters are null and void is when the person in receipt of that letter stands in a court of law and the judge says, irrelevant, case proceeds with.
Well, I take the honourable gentleman's point, and that's why I make the point here, and I'll repeat it, because I do want to be absolutely clear about this. These letters have no legal standing. They cannot and will not be accepted, and they cannot be used to prevent prosecution under this new approach. This body's investigations will continue regardless of people holding those kind of letters. And it is crucial, I'm just going to make a bit of progress, it is crucial that people with the right level of expertise take these important decisions, as my right honourable friend outlined. And that's why a judge-led panel will be making the decisions about whether immunity should be awarded, aided by guidance that we will publish prior to any of these decisions being made. Madam Deputy Speaker, the introduction of this legislation is firmly in the context of the Belfast Good Friday Agreement, and the decisions taken as a result of that agreement, as others have outlined already this afternoon, in the name of peace and reconciliation, that fundamentally have already altered the criminal justice model in Northern Ireland for Troubles-related offences. Yes, absolutely.
On that point, I'm grateful to him giving way. Let me just ask him a very specific question. So somebody goes in front of this truth and reconciliation process. Let's say it's somebody who committed a terrorist act. And during the course of that, they talk a lot about what happened and name names. Somebody else who is involved in a similar crime with them, who refuses to give evidence to the Truth and Reconciliation Committee, will the courts then use the evidence provided in the Truth and Reconciliation process to prosecute the individual who refuses to give any testimony to the Truth and Reconciliation Committee?
Yes. And I'll go further. People will not be able to take benefit, as we will outline in guidance from this, if they come at the last moment. They have to engage at the point they're asked. But the short answer to the honourable gentleman's question is yes. And I'm just going to make a bit of progress. Yes, I'll give way to my honourable friend, and then.
I welcome the fact that after 4 years and 2 general election manifestos, the government have finally brought forward the bill that they have been promising this House for so long. But can the Secretary of State reassure me and my colleagues on one very important point? There are suggestions that this reconciliation process could take 5 years or longer. Many of our veterans are in the autumn of their lives, many are in poor health, some may well pass away before we get to that point. So can he reassure me and the House that whereas this was advertised as bringing vexatious prosecutions to an end, what he's not actually doing is institutionalising precisely that?
Yes, I can give that reassurance, and as we'll see through the passage bill, we are absolutely determined that this does not institutionalise the kind of problem we're actually seeking to resolve, as well as obviously looking to deliver for the people of Northern Ireland. So I can give him that reassurance, and I'll take one more intervention, then I'll make a fair bit of progress, Madam Deputy Speaker.
I thank the Secretary of State for allowing this intervention. On the matter of the on-the-runs, can I confirm that Rita O'Hare, therefore, is still wanted by the authorities for her deeds in a murder of British personnel? And can he confirm that an elected representative in Northern Ireland holds an OTR letter?
Well, I'm sure the honourable gentleman would appreciate I'm not going to comment on particular cases, but I will say again that the so-called on-the-run letters have no basis in law and will not prevent or play a part in the process that we're outlining in this legislation. If somebody is in possession of one of those letters, they will still be subject to this legislation and potential prosecution. And as I've outlined, we are in a situation where we have already, as a country, fundamentally altered the criminal justice model in Northern Ireland for troubles-related offences. We've seen the early release of prisoners with the Sentencing Act, the process of secretly decommissioning weapons, and of course there is already effectively an amnesty for those who provide information to the Independent Commission for the location of victims' remains. While the government believes that the difficult decisions taken at those points were absolutely right for the peace process, the overall approach to addressing legacy issues has not since been adjusted to reflect those very decisions. We cannot simply pretend those things didn't happen, or that these challenging compromises rightly weren't made. The context in which we're approaching these issues is fundamentally different to any other crime across the country as a result of that. This legislation does strike a balance between a focus on information recovery through an investigative process compliant with international obligations, whilst ensuring that those who choose not to engage will remain liable to prosecution should the evidence exist. Madam Deputy Speaker, these provisions will apply to everybody equally. Part 3 of the bill details the impact of these proposals on ongoing and future proceedings within the current criminal civil inquest and police complaint systems. From the date this bill comes into force, no other organisation within the UK, apart from this new Information Recovery Commission, will be able to take forward a criminal investigation into a Troubles-related incident. In just a moment. Any existing cases where a decision has been taken to prosecute will be allowed to continue to their conclusion. Future prosecutions will remain a possibility for those involved in offences connected to a death or serious injury if they do not actively come forward. We have also listened to the concerns expressed following publication of our command paper regarding civil claims and inquests, and that's why we're no longer proposing to bring these to an immediate end. Civil claims that had already been filed with the courts before this bill was introduced will be allowed to continue, but new cases will be barred. With regards to inquests, those that have reached an advanced stage by the 1st of May next year, or the date on which the new Commission becomes operational, will continue. New and existing inquests which have not reached an advanced stage by that point will not continue in the coronial system, but will be referred to the Judge-led Commission for investigation. Good point to my honourable friend.
I'm grateful again to the Secretary of State, and can you just help me on two matters relating to this? First of all, and it harks back to my right honourable friend, the member for Chingford for Greens point, can he explain a little more how he envisages the interaction between Clause 7, which is the limitations on admissibility of certain material in criminal prosecutions, will work with the provision in Clause 22, which is the power of the Commission to refer material. Obviously, by the sound of it, compelled and other types of material will be excluded from that in meeting what I take it will be the full code test, what then will be applied by the relevant prosecuting authority. First part. Secondly, has he assessed what risk there may be of satellite litigation by means of legal challenge to the decisions of the Commission to make that referral? And how will that be dealt with?
Yes, look, my honourable friend, as ever, makes insightful points. And these are things that we are cognisant of, and indeed will be fleshed out and we'll go through the committee stages as well as through the guidance that we will issue. It's why it's very important, referring to his earlier point actually, that this is a commission that is judge-led with very highly respected investigative individuals involved in that process. Madam Deputy Speaker, whilst addressing the legacy of the past, rightly focuses on those most directly affected. It is a sad fact that the Troubles have touched the lives of everyone in Northern Ireland and across, indeed, the rest of these islands in different ways, including many of those who are now born after the Belfast Good Friday Agreement was signed. It's therefore important that we think of reconciliation and remembering in a societal sense as well as an individual context. And that's why under Part 4 of the bill, an expert-led memorialisation strategy will lay the groundwork for inclusive new structures and initiatives to commemorate the tragic events of the past, to help us all collectively remember those lost and ensure that the lessons of the past are not forgotten. I'm going to make some progress now. A major new oral history initiative will be launched. We will want to make this one of the most ambitious and comprehensive approaches to oral history that has ever been attempted, drawn on international models and concentrating on collating lived experiences and testimony and setting them within their appropriate historical context. The public, including academics and historians, will have access to more information than ever before. As well as opening up archives and a major digitisation project, rigorous new academic research commissions will allow for a fuller examination of the conflict than has ever been possible. This will be supported by a new official history led by independent historians with unprecedented access to the UK documentary record. Consistent with the Stormont House Agreement, these provisions will create opportunities for people from all backgrounds, and in particular those who may not have been heard before, to share their experiences and perspectives relating to the Troubles, and to learn about those of others. The legislation we are bringing forward will implement a legally robust and effective information recovery process that will provide answers for families, uphold our commitments to those who served in Northern Ireland, and help society to look forward, while also importantly recognising that those who chose or do choose not to reveal what they know should remain indefinitely liable to the threat of prosecution. We must recognise that notwithstanding the important changes we have made to the proposals as set out in July last year, this legislation, I accept, will be very challenging for many. Happy to give them.
Deputy Speaker, I thank the Secretary of State for giving way, and my honourable friend, the member for East Belfast, will, I think, home in and focus on in more detail in his contribution. But there's one point I want to raise. One of the most difficult aspects of the Belfast Agreement was the decision that if someone was convicted of a terrorist-related offence, they would serve a maximum of 2 years in prison. Under the bill proposed, that will now be reduced to zero tariff, no time spent in prison. Where is the incentive in all of this for someone to come forward and cooperate in a possible prosecution process when they know at the end of the day, if they just hunker down for the next 5 years and say nothing, there is no downside to them because they'll never go to prison anyway?
Exactly right. Well, look, I appreciate the point the right honourable gentleman makes. I know this is a point that he wants to explore over the period, and his colleagues want to explore over the period ahead, and I look forward to discussing this with them. I would say, of course, there is a very big difference in the sense of somebody having a criminal prosecution in itself, and one of the things that's been fed through, and one of the comments that's been made to us in a number of engagements with different groups and parties, has been this point about it's not necessarily about somebody serving time in prison, which of course, as honourable colleagues and right honourable friends have said this afternoon, no longer fits necessarily some of the heinous crimes that were committed by terrorists during that period, but it is about that accountability that comes with a prosecution if one is successful. But I do recognise the point that he has made. And I have to say that trust and confidence in the new Commission will need to be earned through its actions. As a commendable work, I have to say, of John Boucher and Operation Canova has proven, this can be done and has been done successfully in that example. As the historic Belfast Good Friday Agreement approaches its 25th anniversary, now is the moment to move forward in dealing with the terrible legacy left by the Troubles, to find answers for families who seek it, accountability for the wrongs done on all sides, and ultimately to bring understanding for the next generation so they can move forward in peace in a society that has reconciled itself with the horrors of the past. This is a hugely significant step towards enabling true reconciliation. To enable society to look forward with confidence, letting the status quo continue, is just not good enough. Compassion and commitment does require honesty about these painful realities, about the difficult compromises we've already had to make and that we need to make going forward. And the moment has come, I think, for all of us to face these head on for the sake of the next generation. Madam Deputy Speaker, the Northern Ireland office itself has recently relocated to offices in the centre of Belfast itself. Another sign of progress and something that would have perhaps seemed unthinkable 20 years ago. And on the building literally opposite our entrance, there is a quote on the wall that some colleagues will have seen as they walk past or maybe even visit that establishment. And that quote reads, "A nation that keeps one eye on the past is wise. A nation that keeps two eyes on the past is blind." This is our challenge. It's a challenge to see how we can provide families and society with a way to remember and reconcile, but also enable all of us to look forward and to focus on a better future for all. Madam Deputy Speaker, I commend this bill to the House.
The question is that the bill be now read a second time. Before I call the Shadow Secretary of State, I'm sure colleagues will be aware that there are a lot of people who want to speak on this extremely important bill. And in order to avoid having to put a time limit on, I would encourage colleagues to keep their remarks from the backbenches to about 10 minutes. Shadow Secretary of State Peter Kyle.
Thank you, Madam Deputy Speaker. I'm grateful for the Secretary of State for setting out the measures in this bill. I'd like to say before I start that since this bill was deemed incoming, I have taken the approach of trying to find ways that we can find common ground in order to move forward, because people who have been affected by the subject covered by this bill deserve it. I have not tried at any point to tribalise or to party politicise the issues here, and I wanted to have that approach on the record before I go on, because I am certainly going to be criticising aspects of the bill, but that is certainly not what I've set out to do in the first place. And I'd also like to thank the Secretary of State's officials for coming last week to brief me on contents of the bill, unfortunately before the bill was published, but I was nonetheless very grateful. We all agree in this House that we must find a way to resolve the outstanding legacy issues from the Troubles. The conflict touched every family in Northern Ireland. More than 300,000 people lost their lives and tens of thousands were injured, among a population of fewer than 2 million. 1,000 of those killed were members of the security forces, terrorist atrocities. I'll give way in just 1 second. 1,000 of those killed by members of the security forces. Terrorist atrocities were also committed in British cities from Birmingham to Brighton. I'll give way.
My friend, who I have huge respect for, misspoke. 300,000 people did not die in the trouble. 300,000 veterans served in Northern Ireland. It's 3,500 people who actually lost their lives, and I'm sure he'll welcome the chance to correct the record on that.
I'm extremely grateful to the Honourable Gentleman for correcting the record. 3,000 and more lost their lives in the Troubles, and I obviously apologise to the House for getting a zero in the wrong place. The Belfast Good Friday Agreement sets out that we must never forget those who have died or been injured and their families. But in truth, victims and their families were left out, with a clear path to address the personal tragedies through the peace process. The Good Friday Agreement was a staggering achievement, but is ambiguous as to how to eventually address the killings committed during the Troubles. While this was necessary to reach an agreement to end the conflict, it left victims' families wanting. Following years of failings, in 2015, the 5 main political parties in Northern Ireland and the UK and Irish governments signed the Stormont House Agreement. The result of months of painstaking negotiations, it provided a comprehensive way forward on dealing with the past. Its centrepiece was the establishment of an independent historic investigations unit with full policing powers to work through, in chronological order, outstanding Troubles-related cases and a separate independent commission on information retrieval. Despite Stormont securing the support of all elected parties at the time in Northern Ireland, regrettably, this bill jettisons that approach. Northern Ireland deserves to look forward to a bright future rather than live in the shadow of its past. This can only happen when those who have lost loved ones can no longer have to spend countless hours searching for answers. The UK government has a critical role to play in building a brighter future by building trust and acting as an honest broker to find a way forward. Unfortunately, the bill does not provide victims' families with a process they can trust. In fact, it deepens their pain and trauma. The provisions of the bill would set up a new body, the Independent Commission for Reconciliation and Information Recovery, to provide answers to families about what happened to their loved ones during the Troubles. All criminal investigations, all inquests that have not at the very advanced stage, and all civil actions would cease and be folded into the new body. The government argue that, due to the passage of time, we have a duty to empower this body to grant immunity to killers in return for information they have about their actions. There is still the possibility of prosecution for those who fail to provide an account of their actions to the Commission, but the bar for immunity is set so low it is hard to see prosecutions happening in practice. This Commission must grant immunity if 3 conditions are met. They are that the perpetrator requests immunity, they then give an account to the body which is true to the best of their knowledge and belief, and that the conduct they describe would otherwise have exposed them to criminal investigation or prosecution. I need to be blunt. Such a low bar to attaining immunity is offensive to the families who have lost loved ones, and in many cases waited decades for answers. Let me illustrate this concern with an example. Raymond McCord was murdered by loyalist paramilitaries in November 1997. His father joins us today in the public gallery. There was no coroner's inquest into Raymond's murder, no police investigation that involved or reported to his family, and no public inquiry. Raymond Sr. went through 2 court cases in order to have information regarding his son's death released. He won. But when he received all the information, he found out that out of 303 pages of information, 296 were redacted. At the same time, his son's gravestone has been repeatedly vandalised, clearly intended to deepen the pain felt by his family. Across the House today, we must consider if this bill offers Raymond's family as many new rights as it does for his murderer. I don't believe it does. Under this legislation, Raymond's murderer has the right to come forward, and should he tell a basic but realistic account of his crime, he must be given immunity from prosecution. An immunity that stands even if in future it is proved false. He could even go through and write a book about it and wave at the victims' families in the street as they pass. These are the rights given to Raymond's murderer. Yet nothing in the bill says that the Independent Commission must listen to victims, communicate with the victims, or take measures to protect their dignity and health. These seem pretty basic rights to me, and even that low threshold is not met. The situation I've just outlined is not hypothetical. These are real fears that are frequently felt by victims and cause crippling anxiety. We must be on their side. Just as disturbingly, this bill does not prohibit anyone who has committed acts of sexual violence during the conflict or has covered it up from seeking immunity. Maria Cahill, who is the victim of years of sexual abuse at the hands of the IRA, has said the following: "This bill is quite simply disgraceful. The government say they take sexual violence seriously, yet they are prepared to grant amnesty to those accused of conflict-related sexual offences, either in Northern Ireland or England. It is an affront to the victims, to justice, and is a gross hypocrisy." Let's be clear about what we're talking about here. This bill could well lead to someone that's committed rape immunity from prosecution. None of us can even imagine the impact that such a thing would have on the victim. I'm going to return to this theme, but before I do, I want to talk about the way the government has approached this bill in the wider sense, namely the staggering lack of consultation and care the government has taken on this incredibly sensitive issue, and in the way that this new bill was conceived, drafted, and is now being legislated. For reference, in 2018, the government ran a public consultation on the previous legacy proposals, which ran for 21 weeks and received 17,000 responses. That was the right way to handle this issue. And I agree with the words of this government back in 2018. They stated, and I quote, "In order to build consensus on workable proposals that have widespread support, we must listen to the concerns of victims, survivors, and other interested parties." In comparison, the process for this bill, with its unprecedented policy of granting immunity for murder and serious violence, has lacked any meaningful consultation at all. The government published the bill a mere 7 days ago. It's 90 pages long and, in the words of one victims group, heavily legal. Yet, regrettably, the Northern Ireland office has refused to give a detailed briefings to victims groups until the debate today. This has caused hurt, but also confusion about what the bill is actually offering. It damages rather than builds trust. There seems to be a dismissive attitude towards pre-legislative scrutiny of this bill. Take the Northern Ireland Human Rights Commission. This commission was set up by the the Belfast Good Friday Agreement, specifically to safeguard rights in Northern Ireland. They were not asked advice on this bill, and yesterday announced that it appears incompatible with our human rights commitments. They read the bill at the same time last week as the rest of us did. Had they been consulted before, which is, after all, part of the purpose for why they were founded, the bill before us could have avoided some of the stinging criticism that it is currently receiving. Similarly, this bill will have material consequences for the police service in Northern Ireland and the judiciary, for whom both currently manage legacy cases. Yet neither seem to have been given advance notice that the government was planning to strip them of their role with almost immediate effect. The Irish government, our partners in the peace process and the co-signatories of the Belfast Good Friday Agreement, did not see the bill until it was published. They have now said they cannot support it in its current form. With the greatest of respect to the Secretary of State, consistent polling has shown that the UK government is now the least trusted actor in Northern Ireland. Rushing these proposals into Parliament here in Westminster has already damaged the reconciliation we are all aiming for. I understand that the Secretary of State is trying his best to find a way forward, but any proposal to deal with legacy must have victims and communities in Northern Ireland at its heart. I'll give way first.
Thank you very much. I'm very grateful. I just wanted to build on the point that the Right Honourable Gentleman from Bromley made earlier on. The South African Truth and Reconciliation Committee dealt with many of these concerns and fears, a country I used to live in, and have heard first-hand testimony from people that participated in it. What struck me as being incredibly important during that setup was the leadership and the sponsorship of some greats like Mandela or Tutu or other members of the community gave. I mean, whilst there are, I've listened very carefully to what he's saying, and it feels very down in the detail, but can he encourage those leaders in the different communities to give it that sponsorship and get people to give it a chance? The truth is a nebulous as well as a legal concept.
I'm very grateful for her intervention. The Truth and Reconciliation Commission is something that I have a small amount of understanding of. I actually was studying in South Africa for my doctorate at the time when it was running. I followed it very, very closely. The figures that she mentioned weren't just involved in running it, they were all involved in conceiving it. And the figures who lead communities in Northern Ireland, some here in the House with us today, some not, were not involved in this bill. They were not consulted in this bill. The only process which was the Stormont House agreement, which has been jettisoned by this current approach, and sadly, the key learnings from it have not made it into the current bill. So I understand the point she's making about moral leadership and political leadership. Unfortunately, in South Africa, where there was a huge concerted effort to bring forward support from all communities, right now this is coming from Westminster into Northern Ireland, where it should be birthed in Northern Ireland and then coming out down here into Westminster. Did the honourable gentleman still want to give way?
I thank the honourable member for giving way, and I don't want to preempt the rest of your speech. And where you've said it's vital that the Northern Ireland,
his speech.
Sorry, in his speech, and it's vital that victim groups are at the heart of this. I think you're going to come on to it. Well, just checking. What about the veterans? They play a key part of this. They should surely be at the heart of this as well.
I'm extremely grateful for his intervention, and indeed he is prefacing the speech I'm about to, the remaining parts of the speech, which of course I'll get onto as quickly as I can, and he's very free to catch my eye at that point, because he raises an incredibly important point. What we need from government, what we needed from government in the run-up to this process, was empathy. It requires listening. It requires real care in the face of the most terrible tragedies. Take the case of John Malloy. John was walking home in North Belfast in 1996 when he was stabbed to death in a brutal sectarian attack. He was just 18 years old. John's mother, Linda, wanted me to put her response to the bill on the record and ask the House the following question. Why is it that John's sectarian murder in Belfast is different from a racially motivated murder in London? If this legislation goes through, whoever murdered John could simply get away with it. It is just wrong that perpetrators will be able to get on with their lives officially, given amnesty by the state, while we are left to cope with devastation. We brought our children up to believe in law and order, and it is so wrong that the rule of law can be overridden in this way. The hurt never goes away. Of course.
Very grateful for the honourable member giving way. Would he agree with me that justice is just a word if it doesn't come to fruition? And the current system is not leading to claims being successful for the overwhelming majority of those who are affected. There has to come a time, surely, when we have to try a better way. And more than 50 years on from the start of the Troubles, surely that time is now.
I'm very grateful for his intervention. We're not talking about here about whether we don't want to move forward versus people who do want to move forward. What the important thing is, we move forward in the right way. We know that investigations are absolutely central to families being able to move forward and to justice being able to be delivered. You'll notice in the bill, which I'm sure he's read in great detail, that the word investigations is mostly replaced by review. We have concerns that the emphasis that has proven successful in the past, with the emphasis from the Stormont Agreement right through to the Canova investigations that are currently ongoing, have been able to provide, in limited circumstances, the kind of reconciliation, truth and justice that victims have requested. That is where I believe, and we believe, the future should be. There are currently 32 files with the Prosecution Service of Northern Ireland as a result of the Canova investigations. Not one has been picked up because the Prosecution Service doesn't have the resources to do so. So there has been progress, and if they had and the Prosecution Service in Northern Ireland had the right resources, I am sure the justice we're talking about could be dispensed. You want to give way?
For giving way, I don't necessarily disagree with his line of reasoning at all. But on immunity, will he not accept that that ship sailed in 1998? A concept, of course, that his party needs to take quite a lot of responsibility for. So in terms of justice, which he's talking about being denied, and I have some sympathy with that, will he accept that justice has been denied for over 20 years, but that the result of that has, to be fair, been 20 years plus of peace in Northern Ireland?
Since the signing of the Belfast Good Friday Agreement, there's been large periods where politics has been functional and there's been huge progress that was inconceivable before. Its achievement was totemic. I've already said in this speech that the commitments and aspirations in the Good Friday Agreement with regards to victims has not been realised, and we do need to make effort because the generation that's being affected by this, we are losing, has been said in contributions by other members, and we need to get on with it, but we need to get it right. To proceed with this bill, I will give way, of course, yeah.
For giving way. And I appreciate the spirit of what he's seeking to achieve, but can I just put this to him, and it follows on from the earlier intervention. I get the sense that he's suggesting that we should return to allowing the normal criminal justice process where possible to take its course. But isn't the difficulty that once immunities have been given, for whatever reason, there had been a departure from the norms in any event, and therefore we're not in exactly the same territory as we would be in relation to other offences in other places? That being the case, what is the alternative that the opposition posit as a solution to this?
The alternative clearly was there in the Stormont House Agreement, plus the additional learning that we've had from John Boucher's work on the Canova files and the Canova investigations and inquiries that he's undertaken, plus the real desire there is amongst victims to make progress. Of course, victims are realistic about the chances of prosecution in some cases. What a lot of them want is often quite different. But the great thing that I have seen from talking to families who have been subject to investigations by John Boucher under the Canova system has been that it's been quite tailored to the needs and very sensitive to the needs of victims, whereas also being quite realistic about the progress of prosecution. These are the sorts of things that we need to. I'm going to make some progress with the speech because others do want to get in. I'm very aware of the Deputy Speaker's desire for us to get on, but when I make some progress, I'll keep my eye open. To proceed with this bill, we must be able to answer Linda's question from the quote I read just a moment ago, and be sure that we are not promoting reconciliation, whether we are promoting reconciliation and not further division. Quite simply, the test for a way forward is that it must provide more benefits for victims than those who committed acts of terror. In so doing, it would also offer greater fairness to our armed forces and veterans. Last year, the government suggested a blanket amnesty for everyone involved in the Troubles. The vast majority of those who benefited from it would have been Republican or Loyalist paramilitaries, but it also would have stopped any further prosecutions for veterans of our armed forces. The origins of these proposals can be found in the Conservative Manifesto of 2019. It promised, "We will continue to seek better ways of dealing with legacy issues that provide better outcomes for victims and survivors and do more to give veterans the protections they deserve." The vast majority of those who served in our armed forces in Northern Ireland should feel proud of their service. I'm going to finish the point about our service and then I will take more interventions. Over 250,000 personnel were involved in Operation Banner and 722 were killed by terrorist actions. We cannot forget, and we do remain grateful for their service, but it is clear not every action met the standards we set because a very small minority did not. From 250,000 personnel, the Director of Public Prosecutions in Northern Ireland has brought cases against 6 former military personnel for offences committed during the Troubles. The vast majority of our veterans deserve the chance to talk about their service with pride. They do not need to be granted immunity. In fact, the very assumption that they might need it creates a toxic moral equivalence between military service and acts of terror. What has caused so much anger amongst the Northern Ireland veterans community is the idea there is no fairness in who is being investigated. The bill fails to provide a fair and balanced system for veterans that recognises their service, addresses reinvestigations and provides welfare support. Delivering a bill which provides more benefit to terrorists than veterans or victims is not fair to anyone. I'll give way.
Madam Deputy Speaker, the Shadow Minister has spent some time admiring the problem, but I believe that he's very light on the solution. What message might he have for our security forces, our armed forces and our veterans if his party votes today against this bill?
My party will be voting against this bill today because of the equivalence that it gives to people who served in the armed forces, to those who committed acts of terror, for the incredibly low threshold, and remembering that 722 service people lost their lives by acts of terror, and the people who committed that against our armed forces could get immunity from prosecution with the very lowest of possible thresholds. That is what we will be voting against today, and in terms of a better process, it would start by listening rather than forcing the solutions on people. And I'll give way to the Right Honourable Member for Chingford and Woodgate Green.
Can I say I served in Northern Ireland and I don't feel in any degree that there was equivalence of what I was doing, what terrorists were doing. But can I just ask the honourable gentleman just to try and clarify a point for me? He's spoken about some victims and quoted them, and particularly one that wanted to know the balance of what makes this work or not work. And he talked about there being this equivalence, but whether a terrorist, whatever, is it about punishment? Is it about investigation? Or is it about knowledge? Where does that balance for him lie in this? Because this is important. Instead of dancing around what they complain about, where does he think that the balance of what would suit somebody who is a victim?
With his intervention, I've been very clear. I want to make sure that the rights of victims and veterans equals the rights of terrorists and people who committed crime in the era of the Troubles. This bill doesn't achieve that. Proper scrutiny, proper preparation would have delivered a bill that does. The provisions of this bill, I'm going to make progress, the provisions of this bill will also have the Independent Commission carrying out so-called reviews into deaths and serious injury. The bill does provide that the Independent Commission officers can be designated as having police powers. However, it is unclear when or how such powers are to be exercised, nor is it clear if the reviews the Independent Commission carries out will in fact uncover anything new, any new information. In addition, in the additional notes of this bill, the government set out their view that, and I quote, for the ICRC to conduct successful information recovery investigations, which will in turn significantly aid reconciliation in the long term, it is essential for the possibility of a prosecution outcome to be restricted to those who fail to participate effectively in the truth recovery process. We have concerns about how much truth is going to come from this immunity scheme. Immunity will be retained even in circumstances where the account given is deemed as being truthful by the perpetrator themselves, but is subsequently found not to be in accordance with the accepted historical account. The Immunity Requests Panel are also not obliged to seek information from anyone other than the person coming forward in order to verify the truth of the perpetrator's account. It comes back to the point I made earlier about the lack of investigatory work going on before leading this process. It should be leading the process. I want to again put on record how this bill is affecting victims whose loved ones were killed by terrorists. Jean Caldwell's husband, Cecil, was one of 8 workmen killed by an IRA landmine in Teban in January 1992. Today, Jean says, "I want justice." All of this talk of amnesty has brought it all back to the fore again. What they, the IRA bombers, tell that will be of any benefit to me. What will it be? It is so deeply unfair. My blood runs cold. There is no amnesty for victims. I will give way.
The Honourable Gentleman for giving way. In his opening remarks, the Honourable Gentleman suggested that rape or sexual offences committed in conflict during the Troubles would be subject to immunity. This is not the case at all. Only offences relating to a death or a serious injury will be eligible for immunity. Is he happy to correct the record?
I think the Honourable Gentleman needs to read the bill for himself. And the fact that there could well be, there are circumstances where people have committed rape and other crimes, and the whole lot will be subject for immunity. Now, these are things that we have taken advice on before saying here in the Commons today. These are things which are now accepted by a great number of people who have studied this with prosecutorial background and are absolutely clear that this bill does not give the right measures to make sure. And at no point in this bill is there an exemption for people who have committed sexual crimes. And that is something that he should look for. And if he can point to a point in this bill where sexual offences and rape is excluded from immunity, then I look forward to seeing it. The bill also contains the laudable aims of establishing oral history, memorialisation and academic research on the conflict. However, it is the Secretary of State who decides the designated persons to take forward the programme. There is also a more fundamental issue that with such widespread opposition to this bill from victims and survivors, there is a danger they refuse to participate in any historical projects that come from it. On these, I'm going to make a bit of progress. Thanks. On these benches, we really wanted to work with the government to find a way forward on legacy issues. But the government's approach is to bulldoze its plans through without addressing the needs of victims and survivors. Alternative options, such as Operation Canova, have shown that there is a way to handle legacy issues in a sensitive manner which delivers for victims, the security forces and wider society. The government has the numbers to get this bill through today, but I would urge ministers to reflect on what's been said in the chamber today and will be said, and the reaction this bill has received on the island of Ireland. Reconciliation is difficult. And as the peace process has shown us, it requires compromise. This bill is uncompromising and therefore lost the legitimacy that it could have had. Thank you, Madam Deputy Speaker.
Chairman of the Select Committee, Simon Hall.
Madam Deputy Speaker. Just the first 2 front-bench speeches and interventions from across the House clearly show the thorniness of these issues, their long-standing and the polarising nature which they have in views and interpretation, and indeed with coming up with solutions. At the start, Madam Deputy Speaker, can I thank my right honourable friend, the Secretary of State, the Minister of State, and the Secretary of State's office for their courtesy and their engagement with me as these proposals have been brought forward. This bill, because these issues, is uncomfortable. It's uncomfortable in its tricky politics. We'd all like, I agree with many of you, we'd all like the majesty of the law to run its course in the normal way as we all understand that. But that hasn't happened up until now, and evidence that my committee has taken from the PSNI and others clearly indicates that there's simply a lack of investigatory resource and court time to deal with all of these cases in a way which could be even reasonably defined as timely. When we use the phrase "the troubles," it's a word that we all use, isn't it just too euphemistic? It's the sort of wording that we might use to a sort of slightly embarrassing medical ailment. But let's remind ourselves it was blood. It was a period of fear, of people being maimed, of death. It was horror. And so we need to deal with these things in a serious way. Is this bill perfect? No, of course it's not, and no legislation is. But let's not lose the good, or at least the intent to achieve the good, in pursuit of perfection. The government does need to be clear, and this is a key test I would suggest for anybody, irrespective of which side of the argument they are coming from and their own personal experience. The House needs to be assured that the proposals before us are fully Article 2 compliant. And without setting a precedent, I would urge the Treasury bench to give active consideration to putting Treasury Counsel's advice on this matter in the library of the House, so that all of us can be persuaded, if on no other point, than on this. Of course.
Very briefly, he is right. Many of us on these benches served in Northern Ireland during the Troubles. I think he will accept that what we tend to underestimate in this place is the pain caused for many families for not knowing what happened to their relatives, the victims, and some of which disappeared altogether. And although we should always also remember that actually there has been a dearth of prosecution since the Good Friday Agreement. It's not as though we've made great strides in that again, and we should balance those two factors very carefully in the consideration of this bill.
Very good. My honourable friend is right, and it's a sadness that there has been that dearth. And I think that has led to huge frustration and has compounded the sadness and the agony. And I think he's also right to remind the House that each individual, victim or survivor, victim's family, will respond to these things in different ways. They will have different requirements from this process. And we should be very careful not to resort to the language of "this now delivers closure" or "this draws a line." It will only deliver closure, it will only answer questions, it will only draw lines when that person is satisfied, and there will be a myriad of ways that people will be looking for that satisfaction. The government is to be congratulated for the tangible policy evolution since what I think many of us recognise was the rather ill-judged and certainly wrongly toned written ministerial statement of March 2020. But let's be in no doubt, the Secretary of State and the government is to be congratulated for facing into this issue. If there were easy solutions, by God, they would have been delivered by now. If we want this to work, we have to make sure that this too long neglected issue is dealt with, and it has to be through this bill. So much time has been spent on it, so many years have been discussing the issues. I can't envisage, I could be wrong, I usually am or often am, but I can't envisage, Madam Deputy Speaker, there's no need for such endorsement of that from my honourable friend, the member for East Londonderry, but there we go. It's nice to see the collegiate nature of the Select Committee burgeoning out on the floor of the House. But I can't envisage this or any other government or any other Secretary of State devoting future time and energy to trying to resolve it. So I'm tempted to say, whilst it needs some amendment, it is going to be this or it's going to be nothing at all. As we know, the politics of Northern Ireland can be different and difficult and testing. I'm inclined to think And this may be a strange way of looking at it, or the peculiar end of the telescope, but I'm inclined to think that it's possibly a good thing that no one and no constituency of interest within Northern Ireland is claiming absolute victory or absolute defeat. That, to me, would have suggested that the government had got it wrong. There is the potential for something for everybody who has an interest and a legitimate interest in this within this bill. Let me turn just to a couple of specific points, if I may, Madam Deputy Speaker, just with regards to the programme motion. 8 hours for committee, albeit on the floor of the House, and 1 hour, as I understand it, for third reading is simply not enough. Physically, this is not a huge bill in clause number terms, but it's a mammoth bill in terms of history and issues. A sceptical Northern Irish audience needs to be given full comfort that full scrutiny is to be given to this bill and indeed proposed amendments to it. And I would suggest to the business managers, my humble friend for Mid Dorset and North Poole is on the Treasury bench, as much to the Secretary of State, that at least 4 days of committee is given over to this bill and half a day to third reading. That, I think, would give comfort to those people who want to make sure that this solution is properly scrutinised. My committee is going to be looking at this bill, so I don't want to prejudice our deliberations, but could I just make a few observatory suggestions? The Secretary of State appoints to the Independent Commission for Reconciliation and Information Recovery. I would like to see a parliamentary vote affirming that appointment. Those appointments, it would give extra legitimacy to it. On the Commissioners, I would certainly like to see a seat reserved for an international participant. I agree with my honourable friend, the Chairman of the Justice Select Committee. He's referenced South Africa, but there's lots of people with United Nations experience as well, who again will add credibility to this, independence, a new voice and a perspective, which should give extra help to those people who are looking to get these proposals over the line and to invest their faith in it. There also needs to be an oversight panel to the Commission, just as we have with Canova, and that could include groups representing victims, the Veterans Commissioner and others. We need to accept, Madam Deputy Speaker, with regret, I'm perfectly honest about this, that Stormont House is dead. We can flog it as much as we like, but it's a horse that's not going to get out of the stable. It's gone. It's that ex-parrot. It's unfortunate, but it's true. But the need for coalition building remains alive. The need for the government to take people with us is as strong as ever. Clearly, as the Honourable Member for North Antrim referenced, this bill is going to work better if the Republic is engaged and on side. And I agree with the Honourable Member for North Antrim. North and South are two sides of the same coin on this. There is equal weight and responsibility to bring forward solutions which are binding and can command support and confidence. And I do hope that the Irish government, I would urge them to try and meet in the middle on this, to try and build that consensus and joint approach. Would he? Yes, of course. I don't.
I'm very quick, because it's a very quick one. Building on that point, given the importance of our relationship with the Republic, does he agree that actually reinforces the importance of the quality and international nature of the membership of the Commission, given that the Republic itself adheres to the same common law jurisdictions and same approach to criminal jurisprudence as we ourselves do? That would be a means of surely rebuilding trust in that regard.
I agree fundamentally with my honourable friend, Madam Deputy Speaker, and I would urge my right honourable friend, the Secretary of State, to continue his conversations with Minister Coveney, and it may be a step in the right direction to say that one of the commissioners could be or should be a nominee of the Irish government. Now, that would be contentious for some, I know, but in trying to build that consensus and to share the obligation, it may, there's no guarantee, but it may pay a dividend. Of course, I'll give way to the honourable gentleman.
The member for giving way. Could we reflect somewhat on what the Secretary of State actually said from the dispatch box about the Republic of Ireland, that over a year ago they indicated they would bring forward something, and they've brought forward absolutely nothing from the Republic of Ireland. I don't think it augurs well. I think the Republic of Ireland is going to turn a blind eye to this for as long as possible and do nothing, because I think if the veil is lifted on their legacy of the Troubles, it will not be a pretty sight.
Well, Madam Deputy Speaker, as my right honourable friend along with his place has referenced, this bill has taken 2 general elections in 4 years to bring it to fruition, so I'm not entirely sure we're in a position necessarily to lecture from a point of entire innocence on that point. But as we all know, heaven rejoiceth when a sinner repenteth, and it's not too late for both sides to build that consensus and to either bring forward conjoined proposals and, or separate but mutually corresponding. That would be, I think, a good thing. Just on Clause 5, Madam Deputy Speaker, which relates to the full disclosure, Section 1 of Clause 5 is absolutely right. A relevant authority must make available, and then it lists what it must, but Section 2 says a relevant authority may also make available. And that very much depends upon interpretation, because the relevant authority could have some information which they think might be important, might be of relevance to an inquiry, but it hasn't been specifically asked for. It may actually be unhelpful to that authority, and they may therefore hold it back. I would like to see the compelling nature of must in both Clause 1 and 2, and I'm certain that amendments will come forward probably to address that. The bill needs to give further thought to how the PSNI interlinks to the Commission, and I hope that the PSNI would allocate the current round about £30 million for legacy purposes which they spend currently to invest in providing resource and support to this new process. So in summary, this bill is not perfect. Of course I could my right on
I've listened intently, Madam Deputy Speaker, to my honourable friend, the Chair of the Select Committee, and I don't think he's really mentioned veterans very much in his speech, if at all. And the one thing, as we approach the anniversary of Captain Robert Nyrek's death in the hands of the IRA on the 15th of May, perhaps, and I know there will be other colleagues in the House that also served in Northern Ireland, perhaps we should have more talk about the veterans as well as the victims, which both of them are equally as important.
Well, of course, my right honourable friend is probably right, but of course there are many veterans who were also victims and their families, because as we've heard of the figures, those who died, were injured, were maimed and lost their lives. We will not help this debate, can I just say this gently to my right honourable friend, if we characterise it as a one side is more important than the other. And I know he's not doing that. I know he's not doing that.
Words in my mouth.
And I'm not putting words into his mouth, as he says, from a secondary position. I referenced that the Veterans Commission. I did reference that the Veterans Commissioner could be on the observatory panel and the advisory panel, the scrutiny panel to the Commission. That would be important. But it is important, I suggest, and I know that he knows this, to get that absolute balance right. There's a difference in view amongst the veterans community. Some have been arguing for a sort of blanket clearance from day one. Others have told the committee, they don't want to see that, because they want to make sure that those who did wrong, and of course there are some who did wrong, the terrorists did everything wrong, but some of the police did wrong and some of the military did wrong. They don't want to see everybody sort of tarred with the same brush. So there's a difference of view in the veterans community on how we deal with this. I think the bill broadly gets it right by making sure that one side isn't favoured over the other. But as I say, the bill is not perfect, but it does create a framework that can and could help. We do need more time to consider it in this place, which is why I make the plea for revision to the programme motion. Something, Madam Deputy Speaker, after all of these years needs to be done. And to try to ensure that progress is made, this is the bill to do it. We need to be driven, I suggest, by this imperative. And if nothing can unite the House in this debate, I'd suggest it might well be this point. That what we should be seeking to achieve in this bill is to ensure that future generations are not infected by the poison of this too long neglected and running sore.
SNP spokesman Richard Thompson.
Thank you, Madam Deputy Speaker. And could I begin by thanking the Minister of State in particular for the time he took to brief me on the contents of this bill, and allow me to say I very much appreciate what's been attempted here and the sentiment behind it. But I would say we certainly owe it to the memory of all those who lost their lives during the Troubles, to the tens of thousands of those who were injured, and to the families and relatives and friends to make sure that we approach this in the right way to get the right outcomes. Now, on the 14th of July 2021, the Secretary of State addressed the House on the legacy of Northern Ireland's past, and the view that the Secretary of State then expressed clearly was that the current system for dealing with the legacy of the Troubles was, quote, not working. Now, the paper that was published that day achieved something quite unique, I think, in Northern Irish politics, in that it united every single spectrum of opinion in opposition to what was being proposed in criticism. And we've yet to hear the substantive contributions of the members who are elected to this place from constituencies in Northern Ireland who take their seats. But I suspect that, notwithstanding the changes that have been made in approaches by the government since then, that the government might be about to achieve the same feat once again. Yes.
Given the length of time that this has all gone on, isn't it quite clear that there's no way that there's a single solution around which consensus can be built? And therefore the government is left with two choices: either do nothing and carry on as has been happening, or come forward with the best solution it can come up with, in the full knowledge that everybody who's been fighting amongst themselves without reaching a solution will find something to object to in it. So the fact that they are all objecting to it by no means means that this is wrong. It is the only way forward other than doing nothing.
I thank the honourable member for New Forest East for his intervention. He's certainly correct, I think, that this is a very difficult and intractable set of issues that need to be navigated through. But if he really imagines that by tabling this bill the government is in some way cutting open the Gordian knot that's here, I think he is very sadly mistaken, and I do not think that that kind of approach is the one that could yield the greatest amount of fruit in here, because, Madam Deputy Speaker, I do not believe that it needed to be the case that this was the outcome. Now, Stormont House was not agreed by everybody, but nevertheless it did provide a platform for a potential route forward, and by failing to try and establish and build on what consensus that there was in that, I think we're highly unlikely to either reveal truth satisfactorily and certainly not create the sets of conditions whereby reconciliation might be achieved. And I think it is very fair to say, certainly from the representations that I have received, particularly over the last 48 to 72 hours from groups in civil society in Northern Ireland, from those who take an interest in the law and its application, I think it's very fair to say that confidence in this process, in this legislation, is low. And it is not being helped by the fact that we're here to discuss it at second reading just a matter of days after it was announced formally in the Queen's speech. And to only have 2 days in committee here, I think, is thoroughly inadequate for the parliamentary scrutiny that a bill of this kind deserves. But certainly it certainly does not pay the respect, I believe, that is due to victims groups and those with a stake in the outcomes here in and across the island of Ireland and in the veterans' communities in order to try and get us to a place of closer consensus. Now, in responding to that statement on the 14th of July, I was very clear myself that I felt ministers needed to think again about introducing any statutes of limitations or effective amnesties. I was also clear that whatever proposals were eventually brought to the House, that where independent prosecutors considered that there was a sufficiency of evidence and that there was a likelihood of a successful conviction, and most importantly of all, where they believed that it was in the public interest to do so, that they would still be able to bring those prosecutions. Because it's not simply, in terms of achieving truth and perhaps closure. It's not necessarily about a prosecution resulting in a conviction. That investigative process and that testing of facts in a court of law, but even just simply the investigative process undertaken by the authorities, can, in and of itself, help to provide some of the closure that is required by the families. Yes, I will.
I thank the Honourable Gentleman for giving way. Actually, make a very interesting point about closure, and I don't think so far in this debate there has been enough conversation or debate about the closure. Because convictions are important, but you also need to make sure the families of the victims have the facts to bring the closure, whether it's where the bodies are buried and disappeared, how their loved ones got murdered, did they have a glass of water before they were executed. Does he not agree that this bill will actually make it more likely that some of these terrorists and people will come forward to give those details which will try and bring closure to the victims' families?
I thank the honourable member for Rother Valley for that intervention. No, I don't agree, and I will go on to explain in a bit more detail why I don't agree that. Now, the bill, as I said, clearly makes some provisions which would make that kind of continuation of that judicial process and process of investigation impossible. So the question, Madam Deputy Speaker, that I've been wrestling with is whether or not the approach that's set out in this bill is one which can work. And if it can, whether or not the potential benefits of doing so outweigh the very negative and real consequences of bypassing the normal processes of the rule of law. And I have to say that I've reached the conclusion, and my group has reached the conclusion, that it does not. We have very deep concerns about the manner in which somebody might be granted immunity. There's a very real danger that the process that has been set out in the bill as it stands actually puts more power in the hands of the perpetrators of past crimes and atrocities than it does in the victims. And the bar, as has been set out by the Labour Shadow Secretary, is extraordinarily low in this respect. Simply to say that to give somebody immunity they have to request it, but that what they then say has to be true to the best of their knowledge, is not the sort of standard that we should be hoping for in a completely open and accountable process of reconciliation and truth-telling, because it means that there's absolutely no compulsion in there to tell the truth, the whole truth, and nothing but the truth. And even if you did wish to remove this from a purely judicial setting, surely somebody seeking amnesty for their crimes, surely it is the very least that we should expect that they would, in front of such a panel or tribunal, tell the truth, the whole truth, and nothing but the truth in that process. I also have concerns, and I'd be interested in what the Minister of State has to say in summing up about the exemptions that are to be granted on the grounds of national security in terms of what the Independent Commission should and should not do. Now, quite clearly, you wouldn't want the Commission to do anything which would imperil national security, but I think we can all see the potential conflict between revealing information that is held on file and then the suspicion that not all is being, or the national security clause is being used as a means of drawing a veil over that. Because this process of reconciliation is going to require some hard truths, not just of the UK government, but also, I suspect, from the records of the government of the Irish Republic. And it potentially, having that prohibition in the legislation, it potentially represents a further tilting of the balance away from revealing the truth and delivering justice. But I think perhaps one of the most pernicious aspects of this is the very nature in which it still seeks to bring down the shutters, almost, on those families which are already engaged in inquiries or are engaged in the process preparatory to inquiries taking place, and to remove the right of individuals to pursue criminal or civil remedy seems to me to be in clear breach of Article 2 of the European Convention on Human Rights, and with it, since it's hardwired into it, breaching aspects of the Good Friday Agreement in that regard. So, Madam Deputy Speaker, my reasons for opposing this bill are ones of principle and articulated by those with a care for the legal and constitutional implications of what's before us, but as well as the many strong and clear voices of those who have been affected by the Troubles. And in light of those very real concerns, I remain unpersuaded that the goal of truth and reconciliation is going to be more likely to be achieved by this process, or that it justifies setting aside the norms of the rule of law and the fundamental rights of the individual to seek recourse through law in order to uphold their rights. I'm also bound, I think, in drawing my remarks to a conclusion, to observe the dismay that there has been from the Irish Government at these proposals. And at a time when open dialogue and goodwill are in greater demand than perhaps they ever have been where this present UK Government is concerned, to try and go about this process in this way, rather than in trying to find a way whereby both sets of government's records could be made available and to open up a process which was applicable to all victims on both sides of the border, I think is risks representing a very missed opportunity. Operation Canova, as we've heard, shows what can be done, or shows the potential for what could be done when police investigations into historical inquiries are allowed to take place. And I think that the backlog that there is in the PSNI Historical Inquiry Unit, it's not good enough to point to that as a reason for the process, for introducing the processes that are laid out in the bill. That's surely an argument for adequately resourcing the PSNI in order to have the Historical Inquiry Unit complete the work that it was tasked with going ahead with. Madam Deputy Speaker, I don't think that reconciliation is something that can ever be imposed. It's something that has to be achieved. What we're seeing before us today with this legislation as it stands is something which is being imposed to the great distress of many. And I believe that that is unnecessary. And I would regret to say that while this bill remains as it is not something that I or my group are in a position to be able to support.
Julian Smith.
Madam Deputy Speaker, the issues that this bill seeks to address are some of the most sensitive and challenging in our nation's history. Drawing a line under the past in Northern Ireland is a challenge successive governments here have sought to address. As we've heard, recent work has been based on agreement between the UK and Irish governments and the Northern Ireland parties, with a commitment that law and justice matters are devolved and dealt with locally. This was confirmed by the Saltburn House Agreement in 2014, which almost all Northern Ireland parties signed up to, along with the UK and Irish governments. This bill, driven from Westminster, overrides both the policy of Saltburn House but also the focus on consent present in that international agreement. Madam Deputy Speaker, I'm deeply uncomfortable by the idea of voting for a bill that will formalise immunity for those who have committed murder and other crimes. But I do, however, acknowledge that in the range of policy options that the government is faced with, none are straightforward. I want to focus my remarks on the fact that in the substantial policy shift that has occurred since Stormont House, now crystallised by this bill, that victims and survivors today are deeply concerned that they not only have to deal with accepting amnesties, but also fear that as a result of this bill, they will have to accept less rigorous reviews of their cases, rather than robust, evidence-based judicial investigations. Throughout the bill, there is reference to reviews, not investigations. These victims point to the fact that the powers in the bill to compel testimony are weak, that there is a focus on existing rather than exhaustively looking for new evidence, and that prior investigations cannot be reconsidered. They're extremely wary that the UK government will be the arbiter for every aspect of the process, from the choice of commissioners to decisions on what government information is shared with the new body. In speaking to victims' families and survivors, Madam Deputy Speaker, there is a consistent theme, a burning desire to know what happened to their loved ones. Take Shauna, who was just 10 years of age when her mother, Caroline Morland, was abducted by the IRA and held for 15 days before being shot dead at the border, just weeks before the IRA ceasefire in 1994. She said, "Without this investigation, we would have never got answers. Operation Canova has been important as someone else thought that my mum's life was worth something." Everyone has the right to an investigation. Or take Kathleen Gillespie's husband, Patsy, who worked as a chef in an army base in the city of Derry. On the 24th of October 1990, Patsy, who was 42 years of age, was abducted by the IRA from his family home. Patsy was chained to a lorry containing a large bomb and forced to drive to an army checkpoint. He shouted a warning to the soldiers just as the IRA detonated the bomb. It killed Patsy and 5 young soldiers from the King's Regiment. The IRA opened fire from across the border. Many soldiers were injured, but many were saved because of Patsy's warning. Kathleen has never had a full investigation. She's devastated that the men and women who did this to her husband will now walk free. Madam Deputy Speaker, today many victims feel that they have been hit by a double whammy with this bill. Their route to justice cut off, and at the same time their route to the truth restricted. I will give way.
Madam Deputy Speaker, I really appreciate the contribution that the former Secretary of State is making, and I know that he is deeply invested from his time in Northern Ireland in finding solutions to this, and we appreciate the work that he has done. As someone who served in the armed forces and who lost comrades who were murdered by the IRA, does he agree with me that it isn't simply a matter of black and white, and that as President of the Regimental Association of the Ulster Defence Regiment, I speak to many UDR widows who are crying out for justice and who want to see the opportunity to have the murder of their loved ones properly investigated in an Article 2 compliant investigation.
Absolutely agree with my right honourable friend's point, and I think the widows of the RUC members are, I think, at the very centre of our thoughts, along with other victims' groups, as we debate this bill today. Madam Deputy Speaker, lawyers, victims' groups, Liberty, Amnesty, Northern Ireland Human Rights Commission and experts at Queen's University also fear that these proposals will not meet the requirements under ECHR, under Article 2, and that they will breach both the UK's international obligations and the Human Rights Act, which requires independent and effective investigations. If these fears are right, the bill risks leading to ongoing legal challenge and a highly unstable environment for victims. Worse, many argue, than the patchwork system of troubles justice in place in Northern Ireland today. I urge the Government to look again at the independence and investigatory powers of this body to ensure that it can guarantee victims a full and thorough investigation of their case that is legally compliant. The shutting down of civil cases and of inquests and the way it is done through this bill is also a source of much anger and worry, Madam Deputy Speaker. Civil actions have provided an effective mechanism for victims to obtain discovery and reparations. As recently as 2021, the MOD had to pay significant damages with regard to the Miami show band attack. In 2021, there was a review of inquest cases and a 5-year plan for when each case will be heard. Many families now have the commitment from the justice system that their case will proceed. Inquests provide next of kin with substantial disclosure and provide families with information, answers and results previously denied. With this bill, families who have been promised inquests will take place risk having them thwarted just because of their place in the queue. These inquests have been shining a spotlight on new evidence. The long-running inquest, for example, into the IRA murder of 10 Protestant civilians at Kingsmill has involved the largest volume of intelligence material that has been disclosed in the context of any inquest that has run in this jurisdiction. We saw recently, through the Ballymurphy inquest completed in July 2021, after 100 days of evidence, that the verdicts and findings of Mrs Justice Keegan were that the 10 victims were entirely innocent and the force used by the British Army was not justified. It is important to acknowledge that the inquest system has sucked up significant resource, often without conclusions. But, Madam Deputy Speaker, I urge the Government to also look at this. There must be a fairer way of at least completing the current work programme and avoiding such an unfair cut-off point. Returning, Madam Deputy Speaker, to the shift from the Stormont House Agreement to this bill today, many victims have also had their confidence shaken by the lack of support for these proposals from NI political parties, Ireland and the US. The policy content aside, key to Stormont House was agreement, buy-in and consent. Consent is vital when dealing with legacy. At a practical level, for cross-jurisdictional cases that need to be solved and need assistance from Ireland. Consent also has an impact on the ground in Northern Ireland today. This bill is about the past, but it's also about the present. Paramilitarism is still a key feature of Northern Ireland society. How issues of the past are dealt with feeds into those groups and organisations that are traumatising Northern Ireland society today. Balance and an even hand are vital. I'm sorry, I'm not going to give way. Above all, consent builds trust, which in turn increases the acknowledgement required for resolution. Madam Deputy Speaker, when the Right Honourable David Cameron made his statement on the Savile inquiry in this place in 2010, he spoke about the long commitment and service of those who served in Operation Banner. But at the same time, he acknowledged the wrongs of that day. Bloody Sunday was unjustified and unjustifiable. When you stand, Madam Deputy Speaker, in the Museum of Free Derry and you see a copy of the former Prime Minister's speech in the display cabinet next to the bloody clothes of those who were killed, and then you hear what it meant to the people in Derry that the UK government finally apologised, there is a real sense that this particular UK acknowledgement has made a tangible difference to reconciliation. In the brilliant Derry Girls finale, which I'm sure all of my colleagues have watched on Channel 4 last week, the lead character Erin's monologue on coming of age in Northern Ireland was set to clips of Bloody Sunday and, more importantly, David Cameron's apology. A clear modern reflection of the importance of that acknowledgement of the past. Victims' payment legislation has provided a further form of acknowledgement. When I visited the victims group WAVE 2 years ago, I was struck by the significance and appreciation of these acknowledgements to the patient and amazingly resilient victims who had lived with the most horrendous injuries over a decade, some of whom I met on that day are now dead. Madam Deputy Speaker, for Northern Ireland to come to terms with its past, there is a need for acknowledgement from all sides. From the IRA for the thousands of murders, from loyalists for the hundreds of killings, from the Irish government for its role in the Troubles, and for the killings and collusion of UK forces. I genuinely believe, having spoken to many in Northern Ireland, that there is the potential for achieving these acknowledgements. Acknowledgements will allow victims and families and Northern Ireland as a whole to come to terms with the past, to deal with the present, and to give hope to future generations, rather than passing on the pain and the hurt of the past. On investigations and on inquests, I therefore urge the Government to pause and to listen to the voices of our valued Irish partners in the GFA, to Northern Ireland parties, and to the victims and survivors. And I hope too that the Government will reflect on how it can reframe this bill in order to gain the trust required to help deliver a resolution to this fragile and unique part of our country.
Tony Lloyd.
Madam Deputy Speaker, can I just say to my right honourable friend, the member for Skipton Ripon, that his remarks, I hope, will echo not simply around this chamber, but around these islands, because the tone he struck is the one that I wish, and I'd say this not in a personalised sense, I wish it were the one that were coming from the government front bench. The points he made about reconciliation are absolutely fundamental. I, like many honourable members of this House, have met many, many victims of the violence, the loved ones of those who were killed. And it's very hard to listen to victims without recognising the tremendous hurt that is already, that will continue to be there, the need for them to go through the process of knowledge, knowledge that's so fundamental in terms of their own ability not to reconcile, because in a way that's a very difficult thing to lose a loved one, but to accept that at least the state, as the arbiter of these things, has taken every conceivable effort to make sure that their pain is a pain that is recognised and moved through. And victims, I can think of none of them who will be satisfied by this bill that comes before the House today. None of them can the Secretary of State, nor did he even try to suggest, are in favour of this piece of legislation. I know many of the victims would say to me that the limitation of sentences of 2 years is already a betrayal of what they would seek, and I have genuine sympathy with that. We can balance that almost certainly with the fact that that process led to peace, and different people have different views on this. But nevertheless, even with that 2-year sentence, it isn't even about the magnitude of the sentence. It's about a recognition that somebody has been held to account for the crimes that took their loved ones away or changed their individual lives. And that is so important. Now, is this then a victim-centred process that we have before us today? And the answer, Madam Deputy Speaker, is simply, it is not. And I regret that, and I really do regret it. Yes, it's an improvement from the absolutism of the amnesty that we had before us only a few months ago. But even that is a very limited improvement, because in 5 years' time, in any case, de facto, we will have that amnesty. Even though in the short term, because of the very low bar, as my honourable friend Verhove has already pointed out, in terms of the granting of immunity, the near certainty is that immunity will become, the amnesty will become the de facto process that applies. Now, I've got to say to honourable members opposite who campaign in terms of the rights of veterans, it is worth reflecting on the over 700 veterans who died during the conflict, because they, as victims, also have rights. I think the Right Honourable Member for Lagan Valley made exactly that point about those with whom he'd served in the UDR, and we can take that across different parts of our armed forces. So there is a genuine issue about victims, but victims who were those former serving soldiers. But I do have to make this point as well, that I've listened to this debate over many years. And one of the things that I do find intriguing is that when I talk to former members of the RUC, the PSNI, when I talk to some former members of the armed forces, they will say to me very directly that those who were culpable of criminal acts should be prosecuted, because they offer no credit to those who serve with themselves under the law and served in that sense in protection of the people of Northern Ireland. So the idea that we pit the rights of veterans in some way is in opposition to the rights of victims is simply a dangerous fiction, and one that we've got to dispense with, because frankly that lies very much at the heart of this bill. And the reality is this: the Secretary of State has given in to what he perceives to be the demand coming from his own backbenches, but at the expense of the many people who could have been served by a much better bill. And that's got to be recognised. Look, we can go through, and we should go through, and we will need to go through. Yes, of course.
I think, if he doesn't mind me saying so, I think he's mischaracterising what the concern is about those of us who have served and those who remember what others went through. No one has ever asked for immunity. Everybody has always said that those guilty of a crime must face the normal judicial process. So that is an established fact. The problem is, for them, is that because they're the ones on which information exists, There's been like a fishing expedition going on without any real evidence to start this process. Then there's an inquiry and it goes on and on for people without end. And that is the problem. It is this process that is actually the penalty, not the prosecution.
Well, I wouldn't want to mischaracterise the Right Honourable gentleman's remarks, because I heard him say that before. And I've always welcomed the fact the Defence Secretary has made the same point, and he is a very well-respected former serving soldier, that there is no demand for an absolute amnesty, that those who broke the law should face the consequences of the law, whether from a paramilitary organisation, whether within those who claimed it was there to serve the public good. And that's right and proper. And I recognise that this is the position he's always taken. But nevertheless, there has been the demand elsewhere for amnesty as a way simply of saying, let's move on. But this is precisely what this bill will do. In 5 years' time, there will be an absolute amnesty. De facto, there will be an effective amnesty under the provisions of the bill. We need to look at the question of whether this legislation is compliant with the European Convention of Human Rights. I know for some on the benches opposite that is a contentious view in its own right, but nevertheless we should be compliant with the European Convention. There is considerable opinion that the bill doesn't conform to either Article 2 or Article 3 of that convention, but in terms of the need for proper investigation and the need to investigate particularly in terms of torture and to make sure there is adequate redress. Almost certainly this bill is not compliant, but in a way that is a lawyer's point, and important though it is, what lies behind the lawyer's point is delivering justice to the people who suffered during that period of violence. There are other defects in this bill that have to be established, because any system of justice, if it is going to satisfy victims, has got to have enough of transparency, enough sense of independence. Now, this simply has neither of those. When the Secretary of State will appoint the commissioners, that process is already undermined because it's open to political manipulation. When the Secretary of State can direct the commissioner in areas, for example, like the grant of immunity, then we have a very dangerous political precedent with this. And the idea this is equivalent to the South African Truth and Reconciliation process is frankly simply a joke. There was a very different process in South Africa, one that was independent of politicians, and that was important, and one of itself that did allow for challenge of the evidence brought forward by those who came seeking the amnesty process, and that's why only 17% of those in South Africa were given that were allowed that form of immunity from prosecution. Now, in that context, we've got to recognise that these minimally are things that must change as this bill goes through its committee stage in the House. But in the end, we've got to deliver something that is trusted, because these words, reconciliation, do depend on trust. These words on reconciliation do need, for example, that those who think and rightly think that, as the Right Honourable Gentleman for Skipton, Ripon and Skipton said a few moments ago, that all parties, the IRA, the loyalist paramilitaries, the Irish government, our own government, have got to stand up and accept that things went wrong, not simply went wrong not with their name, but went wrong in their name. And that process is important to reconciliation. That's not there in this bill. What is important, though, in the end, is that there is trust in the justice process that, frankly, will not be there, already is not there, because victims groups, politicians across the piece in Northern Ireland just don't accept that this is the legislation that will move things on. Unless we have that trust, quite frankly, we do not move further on down the road of reconciliation. So, Deputy Speaker, we'll finish at this point because of time to let others speak. I hope the Secretary of State will now listen to the voices coming here. This is not a party political division. This isn't a division on ideological grounds. It's a division because this now is a bad bill that won't deliver the justice either to veterans or to victims, but doesn't deliver the capacity for Northern Ireland to move on down that road of reconciliation.
Dr. Julian Lewis.
Madam Deputy Speaker, and I would be inclined to agree with many of the speeches made from the opposition benches, not least the eloquent one from the Honourable Member for Rochdale just now, if it were not for one salient fact, and that is that as part of the peace superstructure in 1998, the Northern Ireland Sentences Bill was passed. And that bill puts an end to the argument about we must not treat terrorists on the same level as security forces, because it did in one sense only, which is everybody is treated equally before the law. And it was often said at the time that, oh, security forces could go to prison for life, but terrorists could not be sentenced for more than 2 years in jail, no matter how many people they'd killed. And I had a meeting with MPs from both sides of the divide in Northern Ireland, including Sinn Féin MPs, who pointed out to me that as far as they knew, it applied to the security forces just as much as it applied to the IRA. And you know what? They were right. It does. So I must say that I think the Defence Committee was, if not the first, one of the first organisations to introduce this concept of a statute of limitation into the current debate. And we did that in 2017 with our first report. But I had heard of the concept of the statute of limitation some 50 or 60 years ago. And I heard of it in the context of Nazi war criminals who were escaping justice because a certain number of decades had elapsed since they'd committed their crimes. As it happens, a few years before I was born, the vast majority of my family in Nazi-occupied Poland was murdered for nothing more than the crime of being Jewish. And I felt then, as I'm sure the victims' families feel now, that it would be outrageous for the perpetrators to get off simply because a certain amount of time had elapsed. But there was a difference then. And the difference then was that legislation had not been passed, as it was felt necessary to pass it in 1998 in this context, to say that no matter how many people you had killed, you could not be sentenced to more than 2 years in jail, and you would not serve more than a derisory few months of that sentence. So the pass has already been sold on the question of getting justice for heinous crimes. And then it gets to the question, well, it's not so much the length of the sentence that matters, it's that we should have our day in court. Well, there's another problem here, and that is all these years have elapsed, and they have not had the day in court because there has not been enough evidence adduced. Of course, I give way.
I'm grateful. This is the point that I try to raise with the opposition. I pose to everybody. What is it that people want? Do they want the knowledge of what happened, or do they want the prosecution and the punishment? As he says, the punishment is pretty much gone. The point of the prosecution is also gone, unless it's only about the knowledge, in which case, how do we get about getting the knowledge? That's clearly what seems to be settling down, if people are honest about it.
That's exactly the central point. And so there are two ways of getting that knowledge, perhaps. One is to go on as we've been going on, trying to investigate these things piecemeal, with everybody trying to hide everything to a maximum because they fear they're going to be prosecuted. And the other is to bring in a truth recovery mechanism, which in return for the granting of immunity maximizes the possibility that the truth may come out. Yes, of course.
The member giving way, would he actually concede There's actually a middle path through this, which is actually what a lot of the commentary in Northern Ireland is focusing on, which is actually investigations rather than reviews. There's a very limited prospect of prosecutions actually happening, but what victims are actually looking for is the interrogation of evidence and a challenge that happens through a proper investigation rather than simply a desktop review.
Well, that is precisely what the truth recovery process is meant to achieve. One more time, but I would like to develop my own argument. Fascinating though these interventions are.
I apologise for this, but I just want to pick this point up. Isn't then this the development of the point? That in actual fact, in the bill, it is to change it and to tighten that process, if that is what the key element is, to make it happen in an interrogative manner, surely, in which case that would be the way forward.
I can happily live with that compromise if the honourable gentleman who spoke penultimately can do the same. So we approached this question in our inquiry in 2016 to 17. We approached it from the point of view of the fact that serving and ex-service personnel were being dragged into court, not because we were worried that guilty service personnel might be found guilty, but that innocent service personnel would be found innocent, but only after they had gone through a horrendous process of trial, investigation, re-investigation, on and on and on. And there are numerous cases of perfectly blameless personnel who, as a result of vexatious litigation, have found themselves being investigated over and over and over again. So we have heard much of the trauma of the victim's family, and I empathise with that totally, not least because of what I've said about my own family history, but we have not heard enough about the trauma of innocent service personnel and security forces who were being investigated over and over and over again. I'm delighted that I hear murmurings of support from my colleague from Plymouth Moorview, who knows more about this than most, and of course I give way.
I thank my friend. But it's also not about those that were dragged through the courts. It was those that were at home years and years and years after. When I first served in 1976, worrying about whether the letter going to come through the box, whether they're going to be dragged up there. So it's the fear for innocent people as well as those being dragged through.
Yes, absolutely right. This is all about protecting innocent service personnel from the vexatious use of the legal process. As I said in my intervention earlier on, it is not the punishment, it is the process. Indeed, the process is the punishment. And in the course of our inquiry, we were fortunate to be able to discuss how applicable a statute of limitation would be with 4 eminent professors. And of course, I do not attribute my views to any of them, but I nevertheless record the gratitude of the then Defence Committee to Professor Sands, Professor Rowe, Professor McAvoy and Professor Eakins. And what they made very clear to us was that any statute of limitation had to apply to everybody. It had to apply to everybody or to nobody. You could not legislate for state impunity. And what they also made clear to us, was that international law required not that a prosecution take place, but that an adequate investigation takes place, and that investigation requirement could be met by a truth recovery process. So the one concession I will make to those people who have been criticising the bill is the government needs to be absolutely sure that the truth recovery process that it is proposing will stand up to the test of meeting international law. And I'm glad to see both ministers nodding on that point, because it's essential that it should do so. So therefore, I come back to what I said in conclusion to what I said in a later intervention, and that is this. You can either do what the parties on the opposition benches want to do, which is to go on more or less as we are, investigating cases ad infinitum, with very, very few prosecutions and even fewer convictions, with a whole miasma of fear percolating those people who know themselves to be innocent, particularly people who served with distinction in the armed forces, but who feel that sort of legal, vexatious persecution hanging over them. We can go on with that process in the almost certainly vain hope of convicting a few more murderers, or we can protect those people. But the only way to protect them is to protect everyone. And we did it before with the 1998 Sentences Act, and that's why I must say the Labour opposition, who rightly supported and indeed brought that act in, have no basis for criticising these proposals, which are proposing to do exactly the same thing for the same reason. And that is to put an end to this persecution and to perhaps increase the possibility that the families will find out through the truth recovery process more about what happened to their loved ones. Because one thing's certain, they're unlikely ever to see the person who killed their loved ones successfully brought to court, and they're even less likely to see them convicted, and if they did see them convicted, they'd serve only a few months in jail. And I say, although it is a sacrifice that those bereaved families are being asked to make, they are being asked to make it on behalf of a huge number of former soldiers and other security forces who deserve to be protected from vexatious pursuit through the courts, and that's what this bill is intended to do.
In Robinson.
Mr Deputy Speaker, and can I say it is a pleasure to follow the Right Honourable Member for New Forest East. He and I have parsed the course on this issue and the myriad of alternatives within legacy over many years. And I served on the committee with him in the 1617 inquiry and the latter inquiry, which published around 2018. We don't agree, and I'm not sure that was a fair synopsis of the four academics in total. But I will come back to this issue in my contribution, Mr Deputy Speaker. Before I do move on, can I just say that I think the contribution from the Right Honourable Member for Skipton and Ripon was the most powerful contribution that we are likely to hear this afternoon. I think it was motivated not out of prejudice or political aspiration for one hue or another, but solely from his emotionally charged and personal experience in Northern Ireland. I think it was rooted very much in principle. And I thank him very much for the contribution that he has made. When I think back to one of the debates we had in Westminster Hall around proposals for legacy, and I was reading some of the Hansard contributions this morning, I recalled an interview that I heard on the morning of that debate that day. And Alan McBride, a victim's campaigner and a victim himself from Northern Ireland, was on the radio that morning. And he was talking about a day of reflection in Northern Ireland and Belfast for victims. And he said, when we were thinking of a day of reflection in Belfast, we tried to find one day, one date, where nobody died. And they couldn't find one. They could not find a single day in the calendar that somebody had not been killed in Northern Ireland. No date which was not attached to a victim. And they chose the 21st of June as summer solstice because that day heralds a new dawn, that day heralds a new season, that day heralds warmth and aspiration. And when I think of our party's approach, and in fairness the majority of parties from Northern Ireland's approach to the issue of legacies, we can't detach ourselves easily from victims or their experiences or their hurt or the lingering fears and doubts that pervade our society. We can't do that. And I know it is easier for others in this chamber to take a more singular view, a singular constituency-based view, a single veterans view. It is easier to do that. We can't do that. The principle we have applied throughout the myriad of decades of consideration around legacy has been one that keeps open the hope of justice, no matter how easily those contributing this afternoon have tried to detach us from it, to keep open the pursuit of justice. That this state recognises that what happened to their loved ones was wrong, and that natural justice and the rule of law in this country still matters, still counts, and should still run through our system. That is something that we have attached to every proposal that has been brought before us. Secondly, and I don't attach this to other parties, we have never wanted to see an equivalence between people who either lived innocent, peaceful and wholesome lives and were cut down in their prime as a result of terrorists, or those who stepped forward and stepped up to protect all of us, to give us the freedom that we can stand in this chamber and political chambers throughout Northern Ireland and stand up for what's right and what's true. No equivalence between those brave women and men and those who went out to destroy and wreak havoc in our society. And I'm afraid on those two principles this bill fails. And I take no joy in saying that. I know there are members in this chamber that think, for goodness sake, Northern Ireland legacy again, can't they just agree? Well, we all do agree in Northern Ireland that this bill is wrong. That this bill will not command support. That this bill drives a coach and horses through the pursuit of justice. And I take no pride in that, Mr. Deputy Speaker. We've been through discussions around the statute of limitations, and I chided the Right Honourable Member earlier about his revisionism, perhaps his fair rehearsal of the approach from the four academics before us, and I do say it fondly because I have huge admiration for him. He is right to say, and the academics were right to say, that should anything be brought forward, principled, detailed as a statute of limitations, it would have to apply equally. But the landscape in Northern Ireland is not equal. We always advance the argument that nobody who broke the law can escape the law, nobody who deserves justice should evade justice. But for those who served our state, for those who put on the brave uniform of our armed forces or the Royal Ulster Constabulary, the UDR and other organisations, for those who did that and were involved in incidents that led to a killing, there will have been an investigation. And we know that post-1973, those investigations were Article 2 compliant. And we've always advanced the argument that where our state can demonstrate that it has discharged its duty, then you should be able to move on. No re-investigations, no trauma, no fear of that knocked door because the state has done what is required of it under the European Convention of Human Rights. And for whatever reason, there were too few within their system of government that wanted to embrace that argument. And I say the situation and the landscape was uneven in Northern Ireland because where the state was involved, an investigation duly followed. When the state wasn't involved, I'm afraid there are far too many deaths in Northern Ireland for which there was no investigation. And that's how that principle could have been applied. 2 years has been mentioned. Good Friday Agreement, early release of prisoners and the maximum sentence of 2 years. It's been bandied about today as that's just the way it is. That was proposed by the Labour government, that was passed by a referendum in Northern Ireland, that was ultimately put through this chamber. I'm not going to be shy in saying I found it obtuse and offensive then, and I find it offensive to this day. 2 years. That's all. If you've served it, out you go. It's not justice. There were no cheerleaders for that proposal in Northern Ireland. There were some accepted it as a compromise as part of the Good Friday Agreement. There are others who didn't. How many times have we heard in this debate this afternoon, 2 years isn't what we're talking about here? Read Schedule 11 of this bill and it still won't tell you that this bill will remove those provisions. Not 2 years in jail. Nothing. No jail time whatsoever. Whether you engage in this process and you seek immunity from prosecution and you tell the truth, or you don't. If you sit outside the system, if you offer no answers for relatives of victims and their loved ones, if you decide that this process in this bill is not for you, it doesn't matter because the British government in this Parliament are seeking our support for legislation that reduces your time in jail to nothing. Who could be proud of that proposal? Read Schedule 11, it doesn't even spell it out. It doesn't even spell it out, but that's the ramifications of this bill. Engage, don't engage. It doesn't matter. You'll serve no time.
Will the honourable member?
Certainly.
I think my honourable friend, Mr Deputy Speaker, is making a very powerful point. And does he agree with me that these provisions are not just something remote in the sense that they apply only to incidents that occurred in Northern Ireland, but in fact the provisions of the Sentences Act apply to terrorist incidents that occurred in Great Britain and elsewhere, and include the murder of British citizens in this city, in Birmingham and Manchester, and indeed in many of the constituencies represented by honourable and right honourable members opposite. And they need to understand that this injustice does not just apply to the people we represent. It applies to every single family in this United Kingdom whose loved ones were cut down in cold blood by terrorists, and that capacity in this country remains to this day.
I agree absolutely, and I hope that the point is not lost. No time, no intended time, no consequence. With no consequence for not engaging in this process, there's no inducement to engage in it. I heard the Right Honourable Member for Chingford and Woodford Green, who again I think has been fair in his contributions on this legacy issue over many years, ask the question, well, what is it people want? Do they want time served in jail or do they want answers? There isn't a singular answer to that question. There are many victims, and it's said in here, people just want to know the truth. There are victims up and down the length and breadth of Northern Ireland who know exactly who killed their loved one and who see the perpetrator walking freely through their town on a daily or weekly basis. And as they walk that lonely path to the graveside to see their loved one, the person they know responsible for the death of their loved one walks free through the streets with their family. But that person still walks, and there hasn't been an effective investigation. To bring it into this House, how often do members walk through those double doors? And how often do they look at the plaques right above? There's commonality between each of those three plaques. Each gentleman stood for election to this House. Each gentleman believed in democracy and the rule of law. Each gentleman was murdered by terrorists related to the Northern Ireland Troubles. The Reverend Robert Bradford was murdered in his constituency surgery in South Belfast by the IRA. Ari Nave was murdered in his car with an under-car booby-trap bomb by the INLA in 1979. And Ian Gow, 1981, murdered by the IRA again with an under-car booby-trap bomb. Colleagues of ours, predecessors of ours, people who stood up for democracy in this country but were cut down in their prime. And what else connects them? Nobody has been made available or amenable for those crimes. The perpetrators have evaded justice. Of course,
Again, Mr Deputy Speaker, my honourable friend makes a powerful point. And is he aware that the chief suspect in the murder of Ari Neve in the precincts of this House is currently operating a bar in Spain, has eluded justice, and under the provisions of this bill will never have justice served upon him?
That's exactly why, and I'm grateful to my right honourable friend, it's exactly why I raise these issues. I want members to know that this isn't just about cold cases that have never got a prospect of success in the courts. There are people out there today guilty of the most heinous crimes during the Northern Ireland Troubles against our state, against our citizens, against our neighbours, across the communities in Northern Ireland and right throughout Great Britain. And they have evaded justice. They have fought extradition. They have squirreled themselves off in the Irish Republic and under the political offence exemption stayed there. And some of them live in the United States of America, and our government has sought extradition of these individuals because they know they are responsible and they want to bring them to justice, and yet they stay in their safe havens. And some freely walk the streets of Northern Ireland in exactly the same position. Those perpetrators of violence, be they Republican or Loyalist, will be able to sleep soundly in their beds once this bill is passed. They will know they never have to spend a day in jail. They will know that the focus will be on those state cases for which there is information that will naturally run through the information recovery process. They won't engage in this, and there is no consequence for them not doing so. I say it with as much respect as I can in the circumstances that the idea that our government, that this Parliament is going to pass legislation that allows the perpetrators of violence who have evaded justice to retire in dignity is a disgrace. It is a disgrace, and retire they will. This Parliament has considered on the runs legislation where our government, at a request from Republicans, was going to pass legislation to say those that were on the run and evading justice could come home and get away scot-free. It was going to be passed by the Labour government until Sinn Féin realised it would apply to soldiers as well, and they pulled their support. And then after the on the runs legislation, we had the letters of comfort. And I'm glad the Secretary of State did rule out the application of letters of comfort applying today. But John Downey walked free from court as a result of letters of comfort. They weren't issued by the Conservative government, it just came to light after 2010. But John Downey was responsible for the Hyde Park bombing. Killed 11 service personnel and 7 horses that were working alongside them. And when he stood in the Old Bailey, he produced a letter that said, "You are not currently or actively sought for investigation." So this Parliament has a history of bidding for the wrong people, in my view. And our view will always be based on those who have suffered the most in Northern Ireland. And I do want to say to the government, and I'm sure they've got the impression that we're not going to be with you on second reading on this bill, but these issues are far too important for us to say we can't have any part of it and therefore not engage. I want the government to hear us loudly and clearly that we will be bringing forward amendments, and we will seek as much cross-party and cross-community support for those amendments as possible. And if we do that in a spirit of goodwill and cooperation, then I do hope the government will engage in these thoughtful considerations about sentencing, about time served, because getting a conviction and being out on licence and having all the freedoms you enjoy and your victims don't just simply isn't sufficient. On the ability of people who have actively evaded justice, who the government have sought through extradition proceedings to come home and retire with dignity, we need to rule that out. And I do hope we'll get a willing ear. Mr Deputy Speaker. Thank you.
Just to say, we have speeches lasting 16, 17 minutes. We're not going to get everybody in. Guidance was given earlier on about looking towards 10 minutes, and I hope that people will now start to look to do that. Going a shade over is not too bad, but I just want to get as many people in as I possibly can. Johnny Mercer.
Thank you very much, Mr Deputy Speaker. And I've huge respect for a great deal of my colleagues in this House and have listened intently to what has been said today on all sides on this issue, on a path which I've walked down for 7 or 8 years now, whether it's Iraq, Afghanistan and Northern Ireland, and the unique intricacies of Northern Ireland. But the difficulty around this issue. And I've seen it laid bare today, and I was the minister who brought in the Overseas Operations Act that brought to a close the Iraq Historical Allegations Team, and so on and so forth. Everybody understands that if you commit a crime, you want to see someone go to prison. If you see someone commit a crime, you want them to go to prison. Everybody wants accountability. Everybody wants that. And to pretend otherwise is a huge disservice to those victims and to those who serve in the security forces. And that is approaching the world and this whole problem, as it has done for the last 25 years, which is not as it actually is, but as we would like to see it. Okay, because we would all like to see those things. We would all like to see decent investigations from back in the day that would withstand ECHR challenge now, that families could genuinely have a hope and an understanding of what had gone on and have answers to their problems. But there is nothing we can do about that now. There is nothing we can do. And that's not my opinion. That has been tested to destruction in the courts in Northern Ireland, in the justice system in Northern Ireland. And in the process of testing that to destruction, that process has destroyed the lives of some of our people who sacrificed the most for the freedoms and privileges that are enjoyed in that part of the United Kingdom today. And I'm afraid colleagues in this space have to get real and stick to the truth and the facts, because what has been said today in a number of occasions, I'm afraid, is not true. And the opposite bench, you know, I love my honourable friend dearly. He's a great friend of mine. But what he said around sexual offences is not true. It's written in the bill. It is written in the bill. And members can read in this House. My honourable friend for Ripton made an incredibly powerful speech, but he mentioned collusion. Collusion has never been proved. Collusion has never been proved in a court of law. If anybody would like to challenge that, please do now. It has never been proved in a court of law. And that is incredibly offensive to those who went up there to try and sustain the peace. So I would just urge colleagues to, you know, there are no winners here. There are no winners in this space. There are going to be no winners. There's no social media clips you're going to clip, send out to the people who vote for you, and they're going to suddenly think you're the best thing since sliced bread and you'll get in at the next election. There are no winners in legacy. It's a mess. The whole thing is a disaster. But we have to do what we can to bring some sort of end and finality and truth to this process for the victims. And that's what I want colleagues to focus on. I've always been clear, okay, and some members opposite in the press have consistently said that, you know, people want individuals to get away with murder and all the rest of it. It's a total load of garbage. Okay, I've always been clear, and I'll say so again from the outset. All I've asked was fairness, okay, and that is all that this government is looking to introduce, is fairness to all sides. I've never argued for those who have operated outside the law to be unaccountable. The complete opposite, because it's a foundation of our society. Those who continue this argument, I come out to Northern Ireland to these trials, and they ask why I don't engage with them. It's because they are deliberately propelling a false narrative for political ends. Okay, that has gone on too long in Northern Ireland, and it has failed too many people, and I'm afraid I will not be part of it. I say to them again today, as I said many times before, uniform in particular, is no place for those who cannot adhere to the standards set and maintained by the vast majority of those who serve in Britain's armed forces. And you will find that most espoused by the operators themselves. The core of the problem, as I've said, is that people see this not as it actually is, which is a complete mess where the state has failed families and failed veterans, but as they want to see it, and as they want their world to be. Because actually, to be honest with people, to be totally honest and say, do you know what? You're not going to get the evidence up to a criminal threshold that means we will convict someone for your son's murder. And I'll tell you why they haven't done that, because that requires a level of integrity and courage that has eluded so many politicians in Northern Ireland. Because that is the reality that is being tested to destruction every day in the courts at the moment. It is often said it's not justice they seek, but their version of justice. It's not my opinion. It's been proven a number of times. The evidence gathering was terrible. Okay, if it was my family member, I'd be leaping. I'd be jumping up and down. I'd be absolutely furious. If my brother, sister, father, mother was killed in some of these investigations that went on by the British state, the soldiers were not interviewed by the police. Okay, they spoke to the RMB. Some of the statements pre-written. It's a disgrace, right? It's a disgrace, and I accept that. And people will get away with things they should not get away with, right? We can bemoan that all we like. We can make speeches. We can, speak to, our home crowd as much as we like. It's never going to change, right? It's never going to change. And everybody, I tell you now, everybody knows it's true. The judges who sit on these cases, the prosecutors who promise convictions for bereaved and vulnerable families, the so-called community leaders who pump out this rhetoric without a care in the world for the damage they do to the families of those who are looking for answers. And of course, the veterans. This must end. As they hound old men in courts over in Northern Ireland, 2 weeks ago, I was listening over to what exactly the drills were on a GPMG weapon system at a particular moment in time, 40 years ago. There's an old man on the stand. He simply has no recollection of that. It is a farce. And I tell you now, it looks appalling for Northern Ireland. It looks ridiculous for Northern Ireland. And it loses the kind of credibility required to bring anybody with you in this process. And for people like me, I'm afraid, who, I reiterate again, are not protectors of those who break the law in uniform, it fatally weakens the cause. Attitudes have changed. We cannot let history's notoriously heavy hand be an impediment to reconciliation, peace and opportunities in Northern Ireland for the greater good. Truth about the past has an important role to play, but as I've said today and pointed out to individual members, it is the truth, not their version of the truth, the truth. And all the uncomfortable and messy and bloody and disgraceful actions that occurred as well, it has to be the truth, not their version of the truth. So I'm afraid I focus my remarks on two key groups, and that is the families of the civilians who died and those who sought to uphold the law in the security services. I'll come on to the veterans in a minute, because they're the real they're the real people in this debate. Okay, they're not trying to get elected all the time. They're not saying ridiculous things in the chamber, like British soldiers went to my town to murder civilians. They're not saying that sort of thing just to get social media clicks. That's precisely what the honourable member said. That's exactly what the honourable member said. It's an absolute disgrace. And he is a disgrace to this House. Because there are real people here, not like that. There are real people without answers, without parents, siblings or loved ones, and of course some under threat of almost interminable prosecutions. The bill does need work, and I accept that. The government has to overcompensate. It has to overcompensate for the failures of the past in transparency. Okay, we cannot just blanket rule out people finding out what happened to their loved one based on national security when that has been the situation for too long, and the truth has not come out, and time has passed, and we're in this situation now. We must hand this over to the chief protagonist. But chief amongst has been said time and again. Okay, Opcanova, John Boucher. The government has to bend over backwards to show that what he is doing in that investigation, which has been lauded by all sides of this House, okay, which is a really difficult skill, that is replicated, absolutely replicated, in what is going forward in this commission, so that victims absolutely have confidence in what they're doing. I recognise that many have come out against this bill. Okay, it's been in the public domain for 48, 72 hours, and I genuinely think it's a mistake, because this is an incredibly difficult space. This is probably a generational opportunity to get this right. But look, legacy is not an amateur sport where, my side of the House, this side of the House has been as guilty of this as anybody else, of coming out and just saying slogans, and think you can throw slogans at it, it's going to go away. It's not going to happen. It is deeply misleading. So the critical success of this is how these ministers handle this bill. And I encourage ministers in this endeavour. I pay tribute to the Secretary of State for what he has done, because the command paper came out. It was clearly rejected. I was against the command paper. One of the only ones against the command paper on this side of the House. Okay? And he has had the character to look at that, come back, with more realistic and better proposals in my views, and he should be commended for that, I believe. But finally, look, Mr. Speaker, I do want to address veterans, because the Good Friday Agreement was an incredible piece of work, and it ended years of bloodshed in Northern Ireland. But there is no doubt about it, and I've spoken to the protagonists at the time. Okay, veterans were left on the table. Veterans were left on the table. And there are some of us who will never, never accept that. We're not asking for favours, we're asking for fairness.
Will they never give way?
Yes, of course.
Mr. Deputy Speaker, I thank the honourable member for giving way, and I know that he speaks passionately on behalf of many veterans, and I understand that. He spoke of the government responding to his concerns. Would he agree with me that when the Minister of State rises to respond to this debate later, that what we want to hear is a willingness from the government to consider carefully reasoned amendments to this bill that take account of very real and genuine concerns that we have about this process?
Absolutely 100%. Okay, and we have a job here to go down that route and get to a place. You know, for example, right, it must be abundantly clear to families in particular that the powers to information held by the security forces sits with the Commission, not the NIO, the Commission, which has unfettered access to that material. Any evidence that exists must be allowed to have modern techniques applied to it, as it is under Canova, to ensure the truest accounts, not a version of the truth, but the truest accounts are given to the families. And the Commission must have the right to speak to anyone. The barman in Spain, they must have the right to speak to anyone who is still alive and could shed light. But look, finally, I do want to address the veterans who are, you know, this chamber is not packed today. This chamber is not packed. And I tell you now, there is no other country in the world that will treat its veterans like this. I totally get the emotion in people's voices, in people's speeches. I genuinely do. But the way this is carried on over the last 25 years is an absolute disgrace. I promised veterans I would do whatever it took before I was in government and when I was in government to not allow you to be left behind on that negotiating table and left in the too difficult column, as it has been for decades. Decades that have seen lives ruined, ended prematurely, and the whole premise of a generation's sacrifice in Northern Ireland questioned openly with almost no defence, save a few honourable members, some of whom are here today. I never served in Northern Ireland. I have no relation to that wonderful part of the United Kingdom. But I do know the institution that shaped me. Whilst I know the UK's armed forces will always have its challenging individuals like any organisation, and we must do better to hold them to account. The overwhelming sense is one of deep professionalism, humility, courage, integrity and self-sacrifice. These values have been tested to destruction and beyond. I have personally seen men die in the upholding of those values. In this journey, one of the most affecting testimonies I've heard, I realise I'm going slightly over 10 minutes, Mr. Speaker, but this is important. Okay, so I just want these soldiers' voices to be heard at the end of this. But we talked about the 2 years and the pain that has caused. But look, finally, veterans aren't stupid. Okay, we understand the need for difficult compromise. Peace must prevail and endure. It's ultimately why we sign up in the first place, to protect the peace. But allowing these veteran sacrifices to be used as pawns in this political settlement, it has to end. I couldn't believe it when I came to this place, the ease with which these sacrifices were being trashed. The ease with which political leaders abandoned those veterans to their foes, who now invited into government in Northern Ireland, with the full utility of the levers of the state at their disposal. Never again must we allow them to rewrite history in their favour. The nation is deeply proud of your role in securing a peace in Northern Ireland and profoundly grateful for your sacrifice. And whatever happens in the process of this bill, and I urge colleagues from all sides to work with ministers and ministers to bend over backwards to get this through, I hope veterans begin to understand there are some of us in this place who will do whatever it takes to get there in the end. Thank you very much.
There again, just to remind people, 10 minutes is the target that we're looking at. Otherwise, I will introduce a time limit, and temperate language, please, to one another throughout the debate. Colm Eastwood.
Thank you, Mr. Deputy Speaker. Can I just point one thing out at the outset? Whilst I'm sitting with colleagues from Northern Ireland around me who we and we rarely agree on very much. I think they'll agree with that. We agree on this. We're coming at it from different perspectives. We will make different types of speeches, but we agree that this piece of legislation goes absolutely against the wishes of the people of Northern Ireland and absolutely against the interests of the victims in Northern Ireland. And nobody on these benches is interested in social media clips or dipping out in and out of an issue every couple of months. We've been doing this for a long time, and we speak to every single victims group, and we try our best to represent them. Some people may not like that in this House, Mr Deputy Speaker, but we will continue to do it as well. The Chairman of the Select Committee is somebody I have great respect for, but he did say in his remarks that there's something in this for everyone. Well, let me tell you, Mr Deputy Speaker, and I say this with great respect, there's absolutely nothing in this bill for the victims and those people who've been left behind by all those perpetrators who destroyed lives and families over many years. And I was interested to listen to the member for New Forest East's intervention at one point, where he intimated that we've all been fighting with each other and we needed the British government to come in and sort out this problem for us. There's a fundamental misunderstanding of what happened in Northern Ireland over many years and many centuries. Mr Deputy Speaker, the British government is no neutral observer in what happened here. We cannot be allowed to make the decisions on behalf of the people of Northern Ireland. We've already agreed how to resolve this issue. It's called the Stormont House Agreement. As difficult as that is, as complicated as it has been, that is the route. It is the only route that has buy-in from all the political parties and two governments. At least it used to have. Before I came into this chamber, Mr Deputy Speaker, I went for a cup of tea with a man called Michael O'Hare. His sister was called Magella. She was 12 years old in 1976. She was walking with her friends to the chapel. She was shot twice in the back by a British Army parachute regiment member. Michael doesn't want an amnesty for anybody. And I was reminded very much of another case in my own constituency by the fantastic and heartfelt speech from the member for Skippon and Ripon, when he talked about Patsy Gillespie. The IRA abducted Patsy Gillespie from his house, left his wife Kathleen and family at home. Patsy was somebody who worked in a British Army base. He was chained to a van full of explosives and forced to drive in to that Army base on the Buncrana Road in Derry. Patsy was killed along with 5 British soldiers. The people who carried that out will be freed from any concern as a result of this legislation. I also wondered about the Ballymurphy families, who in August 1971, 11 people were killed by the British Army, by the parachute regiment again. Daniel Taggart was one of those victims. His daughter is called Alice Harper. This is what she had to say recently. We identified my daddy by his curly hair. 14 times they shot him. The next day they blackened his name and called him a gunman. 2 years later, my brother Bernard, with a mental age of 9, was killed by the IRA. We want no amnesty for anyone, says Alice. The Ballymurphy families would never have seen the truth that the world got to see about what happened on Ballymurphy if these proposals had been brought in before they got the result of that inquest. And we hear that this new system is going to provide truth for people. Well, Columba McVeigh was 17, Donegal, County Tyrone. He was abducted and killed by the IRA and his body was disappeared. His body has still not been found, despite the fact that the Independent Commission for the Location of Victims' Remains allows for immunity in these cases. It would have allowed for the IRA to come forward and tell Columba's family exactly where that body was buried. They haven't done it. That's the point. The idea that this will bring truth to families is absolute nonsense. The pretense from this government that this is about victims or reconciliation is frankly an out-and-out lie. This is about politics. This is about a manifesto commitment. This is about protecting the state, as it always is. And it will protect every single perpetrator who committed those crimes in Northern Ireland. I can't find anybody, apart from the members opposite, who believes that this legislation is the way forward. The Queen's Law School Model Bill team have described it as unworkable. It breaches international law. Alison Kilpatrick, the Chief Human Rights Commissioner in Northern Ireland, said, "We are sure that this bill is substantially, if not fatally, flawed." This is an overt attempt, Mr Deputy Speaker, to close down access to truth and justice for the victims of our conflict. It rips up the Stormont House Agreement, an agreement that people have bought into, and it does not have the support of the parties in Northern Ireland. It has absolutely no support from victims groups in Northern Ireland, many of whom have told us in the past few days that they will boycott these processes if they become law. But what this proposal is about, and others have said there's no such thing as collusion, I can't believe we're still saying that today. Given the number of times the Police Ombudsman has uncovered the fact that there has been collusion in Northern Ireland between the state and paramilitary organisations, do you know what? I won't. This bill is attempting to close down the Police Ombudsman's opportunity to investigate issues of the past. I wonder why. It's also closing down access to the civil route for families. And what happened last Tuesday, Mr Deputy Speaker? The Secretary of State announced that there will be no new civil cases after that day. And what we had was families who were told they're supposed to be at the centre of this, families running around with their lawyers trying to get access to the courts before the courts closed that day. That's some way to treat the people who have suffered the most. It's all right for all the rest of us who are still here, who are doing quite well out of this peace process. The people who have been left behind have been treated shoddily by this government just as recently as last week. We have people who have waited decades for inquests, who are now in the queue for inquests, and they're being told that they won't have any opportunity to get the proper truth of what they deserve. If this is about truth, why are we afraid of inquests? I just do not understand it. This legislation is riddled with government overdrive. There's nothing independent about the way this organisation will be constituted. There's no meaningful Article 2 compliant investigations. It is a recipe, frankly, Mr Deputy Speaker, for impunity. And I've heard the reference to Canova. This is not Canova. This is nothing like Canova. Canova allowed proper judicial processes, proper investigation processes, so that families could get access to the truth, and so the rest of us could get access to the truth. South Africa, equally, Mr Deputy Speaker, this is not. It has been well debunked, that argument. And the government here telling us that they want to see access to truth. Well, let me tell you about two cases that I know well. Paul Witters was 15 years old in 1981. He was shot by a police officer in the head by a plastic bullet. Despite promises from this government given to me, his file has been closed for a further number of years. Do you know when that file is going to be opened, apparently, Mr Deputy Speaker? 2084. He was 15 years old. Julie Livingston in West Belfast and Lenadoon, 14 years old in the same year, 1981. The British Army fired a plastic bullet which killed her. Her file won't be opened until 2062. These are the people who are telling us that they want truth for an access to reconciliation for victims. Every single thing that they've done, whether it's in this, whether it's a Ballymurphy inquest, whether it's in a Bloody Sunday inquiry, everything they've done has been to protect the state, to deny access to truth, and to deny access for justice for those people who don't have the same ability to protect themselves. And I heard we have a new shiny headquarters for the NIO in Belfast. Well, victims were standing outside it today, Mr Speaker, protesting these proposals. They were also in Derry and they were also at Downing Street because they believe, to a man and woman in my experience, that these proposals are absolutely wrong. Raymond McCord is in the public gallery. He's somebody who's had to fight tooth and nail against the state, against loyalist paramilitaries, to try and find truth and justice for his son, Raymond. I mean, the question is, does this government really care about Raymond and all of those victims, or do they simply care about fulfilling a manifesto commitment and protecting the state and protecting paramilitary killers, because that is exactly what this piece of legislation will do if it's passed.
Thank you very much for keeping within the unofficial but really fairly official limit. Ian Duncan-Smith.
Mr Deputy Speaker, I rise really on this because I've had a long interest in Northern Ireland. I served in Northern Ireland in 1975. I can remember the billboards at Christmas saying 7 years will have been too much. To be honest with you, Mr Speaker, I just hated every moment of it. I didn't ask or volunteer to go there. I didn't want to be doing something which I didn't really think I was ever trained to do, although we did carry out training. It struck me as a real problem. And I also just want to say one other word about it, because quite often it's bandied around that political parties over here don't really get it. But the Conservative Party has lost a large number of people to terrorism. The Brighton bombings alone, and also the killings, as you can see there, their coats of arms up on the wall. And I want to say my predecessor, Norman Tebbit, has had a lifelong period of pain. His wife was disabled. She is now dead, sadly, God rest her soul. And she put up with a lot as a result of her husband being in politics. And the sadness is, as he leaves politics now, is that he bears that all the way through. And he had to watch, after the Good Friday Agreement, those who he knew had done it walk away. They walked away under the agreement that reduced everything to 2 years, and the pain he and his wife must have suffered was enormous. I know it was. So I say this with a certain amount of humility here, as much as I do about my own service. The truth is, I want to talk about one particular person, Captain Robert Nyrak. He was a good friend. He was passionate about going to Northern Ireland as a Catholic. I'm a Catholic myself. He thought he could do something over there to help, and he would understand it. Robert was captured. He was, yes, my honourable friend, he served with him as well. The truth was, he was captured, he was taken, he was tortured, we understand. We think, was eventually executed after attempting to escape, but we don't know full circumstances. The point I want to make in all of this, the sadness that all of us have watched, is we want to know what happened. We want to get some closure on this. We've never understood what it was. Where is he buried? His parents went to their graves never knowing where he was. They could never go to that grave and say some words over it. So this is the reality of where we are today. So many people already suffer on this, and that is the point. And so the problem we've got here is, the truth is, this bill, I don't love this bill. I think it is, in many senses, imperfect. As it will be, it has problems and difficulties, and some of those were related earlier on. I think the problem that we need to face is what is it that we're really after in everything. If it is we want justice in terms of prosecution and eventual, if necessary, incarceration, then we need to deal with the reality that we now no longer have a bit of justice, because 2 years for murder most foul is not justice. It cannot be justice. So is it the prosecution that we want to raise information? And there we have this problem, that so many of the prosecutions that take place are actually taking place about those on which there are huge records of what they did, because they happen to be servicemen and women. And that is why, because the government has all these records, that these can be taken out. But for those who committed the terrorist acts, where there is very little information and very little in terms of their willingness to actually do something about giving evidence or have fled the country, they will remain a mystery. As I talked about Robert Nyrak, I have no idea who committed that murder. I have no idea how many of them were involved in his final demise. All I can say is, if it's about knowledge, then the system at the moment is imperfect. If it is about punishment and prosecution, then the system at the moment is imperfect. So what are we going to do? And that this bill, I understand, is a process of trying to get to that, Mr. Deputy Speaker. It is, I think, a genuine attempt on the government to try and find a way that allows families and victims of victims to know what happened and to at least understand that. My point here is that there are things that will have to change if we are to see any of this here. And I do say to the opposition with one small comment, which is I understand their position, but I would wish that they had said rather than no, they said maybe. Because we now engage in a process. And the question is, in that process, can we get some of these things right? That is the point. There was an exchange between my honourable friend, who's the chairman of the Intelligence Select Committee, and the honourable member about this, about what is exactly that we want to achieve at the end of this, and can this be made to achieve it. And it comes down to a couple of issues, and I want to deal with those now, Mr. Speaker. Number one, we have a problem in the process of the reconciliation. To allow someone just to come in and say, as far as I can recall, this happened and that's my lot, really. And then they say, well, that's okay, because now you can go away and you'll never be prosecuted for it, it's all right, don't worry. That doesn't work, really, for me, and I don't think it will work in this process. It has to be a much more interrogative process. It has to have people cross-examining the individual about just exactly how far their knowledge went. The second aspect, I would like that commission to decide, if we're going to go ahead with this, whether or not they consider on balance this individual has actually told the truth and is deserving of any kind of immunity from future prosecution. In other words, this needs to be tightened up, I think, a great deal. If those who have families of victims can get any faith in this, then they will need to understand that there was process, due process. I will indeed.
I'm very grateful to the right honourable gentleman. I think he touches on a good point, because of course they do consider what the individual seeking immunity says as to whether it is truthful, but they are not allowed under this bill to consider any other information whatsoever. Does that not strike him as odd that they have no ability to challenge the rigour or the integrity of what it is they are told?
I understand that, and that's why I said earlier on that I start with all humility to my colleagues from Northern Ireland of trying to find a way through. And I say that this is one of the problems of this, which, if it's about knowledge, then we have to meet that requirement somehow in here, because it's not happening out there. Because for all the talk about prosecutions and the knowledge, so few of those who actually carried out these heinous crimes have ever ended up in the courts and will ever end up in the courts. And so my question is, how can we manage to make that happen? The second bit of this is really about those who don't cooperate. Now, at the moment, I really did worry about the 2-year issue back in 1998. It did seem to me unfair. That is not really justice. If you blow somebody up, murder them, take away a family's father, brother, sister, or whatever, or a member of the armed forces who was there to try and protect you, then surely it must be that that is such a crime, murder most foul, that you must face the fullest penalty. I understand the compromise that was made at the time. I understand that. Many of us had to bite our lips, but we did understand it. My point is now, if you're going to open the door on the one hand to those who would entertain the possibility of coming to speak the truth, then you must also say at the same time, those who do not do this will now face the full penalty of the law for murder most foul. You will not be given an exemption. You will not end up with only 2 years. You will face a full prosecution if you are not part of this process. In other words, either you cooperate and you face the interrogation and you actually come out as whether you've told the truth, or else you go down the other road back into the justice system and you face full prosecution. To some degree, that would at least give balance to this. It would at least give an idea that somehow this was a process that not just sought the truth, but punished those who refused to partake in that process. And I simply end with this now, Mr. Deputy Speaker, on the basis that this will never satisfy everybody. I know that. And I know that families will feel very hurt by this process so far. But I think there is a way through. And the one thing that has characterised, in many senses, this House over Northern Ireland is somehow trying to find a way through the thicket of the different positions that people take. I, for one, want to see the process of trailing away over veterans where the information is there and they've given evidence previously and they've in fact faced interrogations. that this shouldn't go on because it is terrible, it's belittling at the same time, it also creates real problems for them at home. We want to find a way to settle that, but I don't want to settle it on the backs of those who still wait to find out what happened. And so if we can find a way through on this bill, imperfect as it is at the moment, I would like to say that I think that would be something worthy of effort, and I would encourage the opposition to engage as much as they possibly can, because this is too important an issue for us to divide in a very political sense. I want to see closure. I want to find out what happened to my friend Robert Nairac, because it troubles me every single day. I never got to say goodbye to him.
Colin Lockhart.
Thank you, Mr. Deputy Speaker. I'm very conscious that this debate is most likely being watched by victims and survivors in Northern Ireland, as well as those based here on the mainland. And I'm conscious of how painful this is for them. The hurt being inflicted, the trauma, indeed the sense of betrayal brought about by this bill. Mr. Deputy Speaker, I make no apology in stating that it is those innocent victims of terrorism who are front and centre in how I and my party approach dealing with the past. The past is still their present. They paid the greatest price. They didn't choose to pay that price. It was inflicted upon them by the bomb and the bullet, by the evil, wicked hand of terrorism. For the price paid, all they seek in return is justice, for the perpetrator to be held to account for their deathly actions. Whilst the widow and her young family stood at the graveside mourning the loss of the innocent husband and father, they crave that moment where the terrorist stands in the dock facing justice. As time has passed, that ray of hope has grown dimmer, but remained. Today, the government are extinguishing that hope. Mr. Deputy Speaker, as a party, we have consistently applied a number of tests to any proposal around legacy. The tests are as follows. There remains the opportunity for justice for victims, no amnesty, and that any process is fair and balanced. What we have before us today in the form of this bill fails all three tests. As far back as the Belfast Agreement, the DUP opposed the reduction in tariff for terrorist-related offences to a maximum of 2 years. We found such leniency towards those guilty of some of the most heinous crimes imaginable to be a perversion of justice. Yet what this bill proposes is even worse, for there is no custodial sentence whatsoever in these proposals, only a period on licence. To the on-the-run letters of comfort, add the freedom pass. How utterly repugnant. Mr. Deputy Speaker, we know how this process will work. In reality, a terrorist could come forward, tell whatever tale he or she contrives with no new evidence. On the balance of probabilities, some will get the reward of an amnesty for their tall tale. I am yet to decide if this is naivety or simply duplicitous of the government to suggest this bill will help address the legacy of the past. To do that, surely truth means something. For Sinn Féin, truth means concealing as much as it can about IRA terrorism. When he appeared before the Savile inquiry, Martin McGuinness, IRA godfather with the blood of many innocent dripping from his hands, stated that his IRA oath curtailed what he could say. He said the following, and the government ought to take note of this statement. I feel I cannot answer that question because there is a Republican code of honour. For me to identify who these people are would be a betrayal in my view. To do so would have been a gross act of betrayal. I have a duty, in my view, stretching back 30 years to those people, and I am not prepared to break my word to them under any circumstances. Despicable. Mr. Deputy Speaker, in the time I have left, let me raise one other issue, and that is in relation to our brave armed forces who stood against those intent on death and destruction. Mr. Deputy Speaker, we have seen the imbalance in resources and the ferocity at which answers have been sought in instances involving our armed forces vis-à-vis terrorism. It is not that long ago that I stood outside Belfast Courthouse with the late Dennis Hutchings and the Honourable Member from Plymouth and Merview, chased to his grave by those intent on the vexatious prosecution of soldiers. Dennis, like others, was placed in that position in rural Ulster, not through choice, but in response to a situation foisted upon our land. This country and this House put our young men and women in an incredibly dangerous position, and as part of their operational duties, they had to make very difficult operational decisions, sometimes with tragic outcomes. Mr. Deputy Speaker, it is appalling that they should then be subject to the full rigour of criminal investigation as proposed by this bill. And furthermore, it is scandalous that should a soldier tell his story and it is not completely corroborated by documentary evidence, that the burden of proof for the soldier is much higher than that of the terrorist for whom they were sent to defeat. Mr. Deputy Speaker, it was William Gladstone who famously said, "Justice delayed is justice denied." However, this bill, in our opinion, is much worse, for this bill is justice denied and justice destroyed. Thank you, Mr. Deputy Speaker.
Stuart Anderson.
Thank you, Mr. Deputy Speaker. I'm very honoured to speak in this debate, and I understand the sensitivities, the emotion and the hurt that many people in this chamber, through loved ones' personal experiences, will feel. And I try and temper what I speak when I talk throughout this debate. So my own personal experience, I served at the back end of the Troubles. I served 18 months, so I would be one of the youngest now that served during that time. My father served in the early days with the SAS in the 1970s in Northern Ireland. So I grew up in Hereford watching my dad search under cars. Why are you looking under the car, Dad? What you've dropped? It was a little thing we grew up with in my community. I lived about 2-3 roads from the SAS camp. The kids I went to school with, many of their fathers' family friends served over in Northern Ireland. So the whole community felt it. There was, regularly we would have the bomb threats around by the camp, and actually one more lighter note was when they started doing bomb threats at the schools, but these were hoaxes, and some of my friends realised that if they call up for a bomb hoax at a school, we got sent home for the day. After 3 days they said we'd be working at the weekend, so that stopped. But, well, at least the hoax ones did. So it was something in my community that we grew up understanding, and it was always there. You'd see it on the news throughout the early 80s when I was at school. And then when I left school, I went and joined the army. I joined the Royal Green Jackets, a regiment that has probably lost some of the most soldiers throughout the Troubles. And if you put that with the rifles now, without a doubt the light infantry as well would have lost more than anybody else. Every single loss of life is a tragedy in that experience. So as I joined at the depot, all of our instructors were Northern Ireland veterans. You couldn't have been an instructor, you have to have gone through that. You knew within a few years of passing out from the depot, you were going to serve in Northern Ireland, and everything was geared around that. So once, I think it was 12 months after getting out of the depot, getting shot, recovering, I then went on Northern Ireland training, and unlike my right honourable friend there, who didn't want to necessarily, or didn't look to enjoy it, I couldn't wait to go to Northern Ireland. I couldn't wait to serve my country as I wanted to do over there. I was looking forward to it, and I had extensive training. I knew right from wrong. I knew my rules of engagement. I knew under no uncertain terms what I could and couldn't do. I was tested to breaking point on the ranges, in scenarios, over and over again for several months. All of my colleagues were. And we took the experience from those who had served many times before, and I know there's quite a few people in this house who have served over there. During this process, we were shown what had happened to some of our colleagues that sadly never returned. In graphic detail, the loss of life from car bombs, from murders, videos, We knew if it went wrong for us, it really went wrong, and we knew what that was like. So as I was deploying, I remember getting into Belfast, and we're in the Wendy vehicles, like an armoured big truck, and I was looking through, looking out a gap, and I could see what looked like my home area. I saw streets. It wasn't a war zone as you'd sort of got in your head. It looked like a normal area. But I was afraid. I'm not afraid to admit that. I was nervous. I didn't know what to expect. I was a teenager and I was on an operational tour. Most of my colleagues hadn't been there before. It was only the corporals or above, I think, that had been there. So we were very wary. I initially went in the ceasefire, and when the Canary Wharf bomb went off at the beginning of '96, it changed what was happened. And I was there in Drumcree when we stopped the marching. In 1996, that summer, it changed. The whole province erupted. I think we had several RUC who were always outstanding, operating with us, shot four in one night. We had multiple attacks. People were getting burned out of houses. We were in riots, and we were on full-on attacked left, right and centre. That went on for a long time. After about 3-4 days, we realised that we hadn't slept through that process. We were tired, we were exhausted, we were getting bricked, people were getting shot at, petrol bombs. This was going on and on and on. But we knew what we could and what we couldn't do. We knew that. But you've got to weigh this up. In that scenario, every one of us had a split second to make a decision if that person running round the corner with something in his hand was running away from someone trying to attack them, or was running to us to attack us. We held then, at that very moment, life and death in our hands. If we took action, we took a life. If we didn't take action, we died or our colleagues died. And that was the scenario we're in. Now, I believe through all of my operational tours, people acted in the most professional manner. Now, there have been mistakes that have happened, and there have been wrongdoing by people in uniform, which is a stain on what the British Army represents. These are few and far between. But mistakes happen in the heat of the moment. Things do go wrong. Now, I'm 46 years of age. I sometimes struggle to remember what I did last week, let alone 25 years ago.
You're a young man.
I know, but there's people, you serve, the honourable member, my honourable friend served the year before I was born. There's many people will not, would not remember what exactly happened then. And those incidents I've described, there will be everyone in my patrol who will be able to describe it in a different way. This has been dragging people through the courts for what's happened, soldiers through the courts, is actually been a stain on what we've had. 1998, the Good Friday Agreement, the Belfast Agreement was put in place, and I can see why it's taken to now to get to where we are, because there is a lot of talk, there is a lot of reasons, and people always have a problem why something can't be done. And I want to take my hat off to the Secretary of State and the Minister of State for getting this here. And we have heard tonight, there is not everybody going to give unanimous support to this bill. We see that. Now, I look to my colleagues opposite, the members who serve in Northern Ireland, and as the member from Belfast East has said, that they don't agree and they're not supporting this, but they want to make some reasonable want to make some reasonable changes as this goes through. And I understand this is has a different impact for you and your communities than anybody else here. Many of us will be touched by this, but you still live in those communities. And it will be decades before that is changed. No bill is going to change the impact of what happened for the lives that were lost, or when people went over and served over there. People never are the same after. But I like to think that I'm quite a reasoned person, and I tend to measure things what I say. And I would say to the front bench opposite that when they came to the House, they have put one backbench member to debate this, and I find that an absolute dishonour on this House. I find it an insult, and Yes, I will.
Mr Deputy Speaker, does my honourable friend agree that Labour Party is the party of the armed forces?
No, I certainly don't. And as I said, I'm trying to temper this, but when I heard that you're going to vote against this, it is for political reasons. And if as you turn around and look, as the honourable members turn around and look, there is not one member of your party. There is not one member of your party. There has been a couple, I will give you that, but you can at least, the members can at least put a debate across of why you're not supporting this, not just the front bench. The members opposite will be voting against this without having put a reasonable debate, and I think that's completely unacceptable. Yeah. Words have happened too much in this House. We need to see action now, and I'm appalled.
I think my friend is making up on his own, but in the hand of friendship, it's his second reading, Mr Deputy Speaker. There are going to be amendments down at committee stage and at report stage. That's plainly obvious. We've heard it across the House. But at second reading, surely that the opposition would support something which is going to fundamentally change and then change it on committee in debate. There's been no debate from the backbenches, really. This is second reading. This gives a hand of friendship across this House that we can do something later on. But to vote against it now, not only is a slide against the victims, certainly a slide against the veterans that we served.
Thank you. As I wind up, I want to make clear this is not a personal attack against the honourable member. He is here, but nobody else from his party is here, and that is not acceptable. They could at least come and put a reasoned debate of why they're not supporting that. And that's where I leave this. I will be supporting this bill because it's the right thing to do moving forward.
Yeah. Stephen Farry.
Thank you very much, Mr Deputy Speaker. At the outset, can I just put on record that I think we can all be here in support of UK armed forces, but take a different opinion on what is the right thing to do in terms of this legislation. And certainly I stand here as someone who wants to restate my support for the work that the armed forces have done in Northern Ireland in the past, where they have served with great honour, distinction, integrity and indeed sacrifice, and indeed the work they're doing at places right around the world at present. And all of us are very clearly aware of the huge threats that exist in the international space at present. And I did want to pass on my thanks and appreciation to the previous speaker and indeed his colleagues personally for the service that they have made. The difficulty we have here is that this debate is based around a false narrative of vexatious investigations and prosecutions which simply does not stack up under scrutiny. And as a consequence of that, we are seeing the production of what is bad law, and indeed law that will prove to be utterly unworkable in the situation of Northern Ireland. Legacy is by far the most sensitive issue in our political space, and indeed there is a real prospect that what is happening with this legislation, including the manner in which it has been handled, is going to end up re-traumatising victims, because there has been no preparation done whatsoever for what's coming down the tracks, and people are seeing the potential prospects, slim as it may be, of justice being snuffed out over their heads, and that cuts really deep to their very sense of being, and that slim hope that they've been holding on to. Now, of course, the legacy process in Northern Ireland is fragmented and piecemeal. Outcomes are poor in terms of justice and reconciliation. There has been some notable exceptions where that has delivered results, not least in some of the recent inquests. But we look to the situation where we have the legacy investigations branch of the PSNI, the police ombudsman, the inquests and civil cases. So the need for a comprehensive approach to legacy is clear. But this bill does not represent that solution. It is unworkable and incompatible with the principles of justice, the rule of law, reconciliation, and is not compatible either with international human rights standards. The Stormont House Agreement of 2014 represented an agreement between the UK and Irish governments and most of the Northern Ireland parties. It also has the support of most victims groups and other stakeholders. But it's never been implemented. It was never even given a chance. So whenever people ask us, well, what's the alternative? The answer is clear. It's Stormont House. Return to it, give it a chance before you move on to something else. This bill isn't even consistent with the Stormont House Agreement in terms of its principles. Furthermore, it's even a breach of the New Decade New Approach Agreement, as recently as January 2020, under this current Prime Minister, when that agreement recommitted the government to Stormont House. Not a different process, it recommitted to Stormont House. It's there in black and white. The bill is not compatible with UK obligations under Article 2 of the European Convention on Human Rights, and there's already very significant case law on the requirements around the nature of investigations. The processes set out in the bill do not and cannot provide the necessary independence or effectiveness in terms of the necessary rigour in terms of interrogation of evidence to be Article 2 compliant. Now, we have had an interesting debate around how that can potentially be addressed. To do that, you have to recognise that what is a whole range of references to review in the bill will need to be stripped out and replaced with investigation. So you're talking surgery that is essentially select all, replace all, with that review coming out for investigation. And I want to reiterate the point. While we have to keep on the table the prospect of prosecutions happening in what may well be a small minority of cases, and that people will cling on to that hope, the important point around the investigations is the rigour of that investigation and the interrogation of evidence and the challenge that actually provides answers for people. That is what people have been looking for, and that's the type of process that has reached results in limited cases so far. That's what an inquest does, for example. But what we have on paper in this bill is not that interrogative approach. It is very, very far away from that. Indeed, given its failure to uphold the European Convention on Human Rights, you can actually argue this bill is actually a breach of the Good Friday Agreement itself. The Operation Canova model negates the government's argument that investigations with full investigative powers are not viable. Now, while there has not been any prosecutions, my understanding is that substantial files have been referred to the PPS in relation to that. And again, what is in this bill is nothing close to what was included in Operation Canova. Now, the process around this bill has been flawed. It is a top-down imposition. It doesn't reflect co-design with the key stakeholders. Indeed, there was no meaningful engagement with the Northern Ireland political parties or other stakeholders on this specific bill, and that includes the Northern Ireland Commission on Human Rights. It's driven by a narrative from the government and the Conservative Party more widely, based around vexatious claims and investigations against veterans. This does not stack up. Ministers cannot and will not cite examples of what they mean as vexatious. They've had plenty of opportunity to do so. They've never taken that up. Indeed, the Northern Ireland criminal justice system is rigorous. They have a high bar in terms of what is pursued through the courts. It self-polices any vexatious cases. And anyone who's claiming that there are vexatious claims in the system is actually attacking and undermining that existing criminal justice system. It's also worth bearing in mind that this legislation is opposed by virtually every single victims group in Northern Ireland, which begs the question, on whose behalf is this being done? That includes Amnesty International, the Committee on Administration of Justice, Relatives for Justice, the South East Fermanagh Foundation, the Pat Finucane Sector, WAVE, and the Northern Ireland Victims and Survivors Commission itself. Reference has been made to the Northern Ireland Human Rights Commission itself, which has said that they believe that the bill is substantially, in fact almost certainly, flawed, fatally flawed. The Irish Government are supposed to be a partner to this process and to managing the Good Friday Agreement. They have not been part of this phase of legacy deliberations, and they too see this bill as unworkable and incompatible with Article 2 of the Convention. Furthermore, much of this bill relates to matters which are essentially in the devolved space of Northern Ireland. The original understanding behind Stormont House was that the UK Parliament would take through the legislation covering both UK responsibilities and Northern Ireland responsibilities on a hybrid basis, with the active consent of the Assembly. That was the only technical way of getting this through in terms of a comprehensive package. As things stand, the Government are openly working outside the Sewell Convention on this most sensitive area. And contrary to the dominant narrative that the veterans support this bill, it's important that we recognise that those views are at least mixed, particularly from former army and police personnel based in Northern Ireland. The vast majority believe in the primacy of the rule of law and believe that the very small minority of their colleagues who potentially broke the law should be held accountable. Yet the measures in this bill risk drawing a false equivalence between them and the terrorist, in that special measures have to be put in place when there is no need for any protection to be given that sullies anyone's service. And for someone who's maybe invested 30 or 40 years of their life in terms of protecting the community, that twisting of the narrative as to behind the nature of their service, again, will cut very deep. In terms of some of the specifics of this bill, the bill grants the Secretary of State with direct control over the establishment and operation of all of the proposed mechanisms, undermining the independence of actors. This is particularly problematic when the state is one of those actors. The powers to compel testimony are weak, and it suggests that there is not the capacity to conduct effective investigations. The functions are weighted towards reviews rather than investigations, and the bar to re-examining previous investigations is also high. The conditional immunity approach amounts to a de facto amnesty, and we've seen a false equivalence drawn between what happened in terms of the early release of prisoners, decommissioning and victims' remains. Now, I was deeply uncomfortable with the early release of prisoners. It wasn't a part of the agreement I found particularly tasteful. But it's important to recognise that anyone who was subject to early release was out on licence and could have been reconvicted in the situation of another offence. Also, in terms of the victims' remain and decommissioning, there was immunity only for the evidence that led to the discovery of those remains or in relation to the handover of guns. There was no broad immunity given to the people responsible in that regard. So it's important to put that particular context in place. And also, in the rare cases where immunity will not be granted, which is a very subjective process, it's worth stressing, there's only a technical risk that will end up to a prosecution being taken forward, because who else is going to do the investigation? All other routes are being shut down. So there is a very, very real danger that people will simply choose to wait out the conclusion of the work of this body and simply therefore default to a blanket amnesty. Amnesties are increasingly regarded as problematic in post-conflict situations around the world, so this government is going against the trend, and they are particularly problematic in the context of the ECHR framework. The Marcus versus Croatia case is particularly relevant in this regard, and the lessons are very clear. If any amnesty was to even be remotely tenable, it would need to be either part of the peace agreement itself or agreed across the political parties. Neither of those tests are proven in this situation. I'm conscious I'm running out of time, Mr. Deputy Speaker. Just to make a couple of comments in conclusion. There are major concerns about shutting down civil cases, and also what is happening in terms of shutting down of inquests, particularly whenever the Lord Chief Justice previously and the current Lady Chief Justice are working through a programme of inquests where different inquests have been scheduled in a different order, which runs the risk that certain families will have their inquest completed and others will have their inquest sort of snuffed out. Finally, with reference to what's happening around oral history and memorials and academic research, these two are very centrally controlled, and they're being used to give a reconciliation veneer to what's happening. Now, reconciliation goes right to the heart of the DNA of my party, but you don't do reconciliation top-down and tell people to reconcile. This has to be done in an organic way, and this is not going to be the case. And just the final comment in terms of process, I do believe this bill is irredeemable. It's fatally flawed, which is why I will be opposing it. But even if the government are trying to offer some sort of offer that they can seek amendments to this, the fact we're doing this through a committee of the whole House over 2 days doesn't really give the space for proper consideration of any amendments. So the actions that are taken in terms of the further consideration of the bill belie any genuine attempt to actually fix any of the problems. Thank you very much.
Thank you. James Sunderland.
Mr. Deputy Speaker, thank you for calling me for the graveyard shift. There's been loads of passion and emotion this afternoon in this very important debate, but I want to give my view, please, as a relatively new member and, I hope, pragmatist. Today is about the past, the present and the future, and it's about people, many of whom were terribly caught up in the Troubles. It's already clear that this bill will not be a panacea, far from it, but it does have defined outcomes which I believe to be broadly positive for reasons that I'll outline. And nobody will pretend that this is at all easy or that it is a formality. I want to begin, if I may, by commending the Secretary of State and his staff at the NIO for acting throughout in good faith. This is legally very difficult, it's also politically very sensitive. But it's required strategic patience, it's required huge personal and professional resilience under pressure. And this is ultimately a no-win statute, because it won't bring people back, and it won't bring solace for victims and their families, and that those who we should be holding to account may now never be brought to justice. So I believe that the statute will ultimately provide some solace and some closure, but not a lot. And despite all of its imperfections, I believe that it will do what it says on the tin, as the least worst option. It's done the rounds. It has been through the Irish government, it's been the veterans groups, it has been the victims groups, and it's probably the missing chapter of the Good Friday Agreement 24 years ago. Therefore, it's no surprise to anybody that it's coming. And it has received, in my view, due diligence. It's taken longer than expected. And yes, the NIO has received criticism, not least from these benches, for the strategic pause that's been necessary. But it is a manifesto promise. It was in the Queen's speech, and it's finally been delivered. And it's now deliverable. But it's a heavy responsibility too for the government. What I really want to say about the bill is in relation, first of all, to veterans, veterans groups, and those who may still be serving. Do I think the bill is the right thing to do to protect veterans and vexatious complaints? The simple answer is yes. Why? Because it breaks the cycle, it ends the misery, it ends the knocks on the door at 3 o'clock in the morning, and we owe it to these people who served in good faith in Northern Ireland. And I want to commend, if I may, the good work of the member for Plymouth Moor View, and also for Chingford and Wood Green, and so many veterans groups have acted in this space. It's gone on for too long, and it needs to be killed now. But of course, you can't deliver legacy protection for veterans in isolation. It has to be able to withstand legal challenge. It has to be Article 2 compliant. It has to get through Strasbourg and the Human Rights Act. So the principle of legal equivalence underpins the statute because it has to. And therefore the premise of conditional amnesty is rightly pivotal. And it was right to move away from the original premise of what might be termed new and compelling evidence. Why? Who decides this? And how do you draw the line in law? It's impossible. The bottom line is that you cannot. So I can understand the logic of why a blanket statute limitations has been introduced and why I think it's now the right thing to do. What does the bill actually do? Well, we know it establishes the Independent Commission for Reconciliation and Information Recovery. So, in theory, it creates an environment of openness which may give answers and some closure. But I appreciate the flaws in the argument. It will grant immunity from prosecution to those who engage with the Commission. The important point here is that legal equivalence does not mean moral equivalence. So it's right that conditional amnesty is dependent on engagement. Absolutely the right thing to do. It will end troubles-based criminal investigations and protracted legal proceedings, the right thing to do. And it should commission a record of every troubles-related death from the ICRIR. And the list goes on. But, in the interest of balance, the PSNI has a caseload currently of at least 900 cases that are currently unsolved. Op Canada, mentioned earlier, for many has unfinished business. Victims and families will not get the resolution they seek. And I'm also acutely conscious of the concerns of those who believe that protagonists just won't engage. In my view, we've got to give this a chance, and it's important that we do. So, Mr. Deputy Speaker, just to finish if I can, this bill is divisive. We've heard it a lot today. And we have to go forward as carefully as we can, mindful of the particular sensitivity of victims' families. That is a given. But the time is now, 24 years on, for the Good Friday Agreement. We have no choice. We have to deliver the promise that was made, not least to our veterans. And lastly, if I may, I am absolutely bewildered personally and disappointed by Labour's decision today not to be here and to vote against the bill. Aside from doing the right thing for our security services and our veterans, this is ultimately about national politics, not party politics. And I hope that my colleagues on the opposite benches will do the right thing this afternoon.
I thank my honourable friend for giving way. I've certainly laboured the point, but it's a point that really does need labouring. Does he agree with me that Labour are no longer or are not the party for veterans, and actions tonight will be seen across the veteran community.
I thank my honourable friend for his intervention. My personal view, Mr Deputy Speaker, is that what we have to do is show the requisite support to our veterans, our armed forces and our security services. And this, ultimately today, is about two things. It's about drawing a line under vexatious complaints, but it's also about hoping that Northern Ireland can emerge for a peaceful and prosperous future. And I very much hope that happens. Mr Speaker, thank you.
Ian Paisley.
Thank you very much, Mr Deputy Speaker, for calling me in this debate. I think there's been a number of very helpful and interesting contributions to what is a difficult subject. I do say that, importantly, I think the member from Chingford and Woodford Green made a very interesting point whenever he identified to the House that there should be significant amendments to this. Those amendments, if indeed carried through in the way in which the member suggested, would actually change what this bill does, and I think we therefore do look forward to the amendments if they do come, in hope and indeed expectation, because change to this bill is necessary. It has been rightly said by many members across this House from Northern Ireland, representing all types of constituencies, representing all parties across this House, that they are opposed to it. So it has failed the Northern Ireland test of getting any sense of consensus whatsoever, and I think that it's important that that is placed in the record. It is disappointing that Labour have not contributed to this debate in the way that one would have expected them to do, given that it was in 1998 that the genie was actually let out of the bottle. The genie was let out of the bottle whenever all terrorist prisoners were released from jail, and it set on course a series of events that has told us that justice in Northern Ireland will be served up very, very differently for everyone. And I think that it's important that people recognise that from 1998 we've been served a catalogue of abuse to the justice process. When we consider the letters of comfort that were secretly issued, the OTR processes, which I think are an absolute and total disgrace. Even the way in which this has been characterised in the recent film Derry Girls. I watched with interest the other evening the two characters falling out with each other over the release of prisoners. You know, people from the same tradition, from similar families, falling out because your brother committed murder and he shouldn't be let out of jail. You know, that's how it affected all families in Northern Ireland, Protestant and Catholic, across the divide in Northern Ireland. It was appalling. Even the member from North Down, who supported the Belfast Agreement, indicated today in his comments how that jarred with him. And I think it is important that members recognise that when that genie was let out of the bottle, that's why we get here today with this piece of legislation that then says, well, you know, if we can do it once, we can do it again. We can undermine the rule of law again, because we did it once. Well, you know, that is what is unsatisfactory. And for some members, maybe that's why the Labour benches are empty today, for some members to stand on their high moral horse and read a lecture about the morality or immorality of this, maybe the fingers are pointing back that what they did in 1998 has finally come home to roost. And I think that that is an important point. I mentioned earlier, Mr Deputy Speaker, the case of Rita O'Hare. 51 years ago, she tried to kill a soldier. She tried to kill a soldier called Fraser Patton in Belfast. She evaded justice when she was given bail. She fled to the Irish Republic and she went on the run. She got a job in the United States of America. She's been the Sinn Féin Director of Publicity since the 1980s. She can't come back to Northern Ireland because of a warrant outstanding for her. Under this, she gets off that hook. What is she going to do? Read a little story to an inquiry tribunal and tell them what was actually happening? She will never serve a day in jail for that attempted murder. She will never serve a day in jail for possession of murder weapons. She will never serve a day in jail for maliciously wounding a soldier because of this piece of legislation. And I think we need to call it out for those reasons. On Sunday I had the privilege of standing in Ballymena Memorial Park as we unveiled a memorial to the Royal Ulster Constabulary George Cross Foundation. And as we stood there and we listened to the names of the fallen from County Antrim, it was very, very obvious that as the tears fell on widows' cheeks, and some of the orphans still standing around that memorial, and colleagues of the fallen, they recognised then that actually what is happening with this legislation is not the cri de coeur that some members would have us believe, that no one will be left behind, but the RUC will be left behind in this. The victims will be left behind in this. The member for Foyle quite rightly said that not one single victims group, not one single party, not one, for different reasons, not one single rights group in Northern Ireland, including the Northern Ireland Commission for Justice, accept this piece of legislation as even being Article 2 compliant with the European Convention of Human Rights. There are members of this House, Mr Deputy Speaker, who go to Europe on behalf of this House to uphold peace, to uphold the European Convention of Human Rights, to represent it there, who chide Russia at the present time for breaking the European Convention of Human Rights. Yet here we're going to put through this House a piece of legislation that damages the European Convention of Human Rights, and because it is not Article 2 compliant. It is perverse today that when we hear people in this House calling for war crimes to be identified in another part of Europe, here in the United Kingdom there's going to be an attempt to conceal and forget those very war crimes that we say people should be brought to justice for. No, I think those veterans who have been fed a diet this evening, I think an unfair diet that, this is going to be very good for veterans. It's not. They're getting a crumb off the table. And the crumb off the table is blue moulded and will not taste very good, because instead of veterans being able to hold their heads high and walk tall and proud for the great service that they gave to our nation in Northern Ireland, they actually will recognise that this marks them. This legislation marks them out, that they got some sort of dodgy special deal like 1998 all over again. It does not do them the justice that they are entitled to, or exonerate them in the way and manner that they ought to have received. For many years, members on this side of the House, and indeed across the House, have campaigned for justice following the Libyan-sponsored terrorism in Northern Ireland. The next time I hear a member saying that they want to see justice for victims across the United Kingdom who suffered at the hands of Libyan-sponsored explosive in the hands of the IRA, I must say I will take a double look at it, because this stops that in its tracks. My constituent Billy O'Flaherty, who lost his limbs in Ballymena as a police officer because of a Libya-sponsored bomb in the hands of the IRA, I have to go and tell him tonight, as a result of this piece of legislation, he's never going to get justice. He's never going to see the people put behind bars who tried to murder him and who murdered his colleague on the same day. This piece of legislation will not get us to a point where that will be brought to a point of justice. The review, Mr Deputy Speaker, and I'll finish on this point with regards to the review. If anyone in this House honestly thinks that somehow terrorists are going to walk into a review process and fess up to all the bad things they did and it'll all be forgotten, they're absolutely wrong. This is not about reconciliation. It is wrong to call this reconciliation, because it will not reconcile those differences. It will actually drive a stake further between them and leave communities, not a community, but communities in Northern Ireland, feel once again let down.
Scott Benton.
Thank you, Mr Deputy Speaker. May I begin by commending my honourable friend, the member for Great Yarmouth, for bringing forward this bill. Of course, governments and secretaries of state of all colours over the last 20+ years have grappled with the incredibly difficult question of how to provide better outcomes for victims and survivors of the Troubles. This has been fraught with political, legal and moral hurdles, many of which have often been considered insurmountable. And so the Secretary of State deserves immense credit for grasping the nettle and bringing forward these proposals when previous governments have all concluded that the easiest thing to do was simply to do nothing. There's long been broad agreement across Northern Ireland that the current system for addressing the legacy of the Troubles simply does not work. Victims, survivors and their families have waited far too long for answers, and in order to allow Northern Ireland and its people to look towards the future, the government is right in bringing forward this bill. The years of the Troubles were an awful period in the history of our United Kingdom, with tragic loss of life and severe injuries inflicted upon thousands of people. But it should always be remembered at this point that 90% of the deaths in the Troubles were deliberate killings by terrorists who set out to inflict untold misery in their pursuit of their perverse political agenda. Being in my early 30s, I am of course not old enough to remember the worst of the Troubles, but I do recall the Belfast Agreement being signed. This agreement has stood the test of time and has laid the foundations for peace and security in Northern Ireland over the last 20 years. However, it did come at a tremendous cost. In 1998, the prison gates were opened and terrorists guilty of horrific crimes were released without fully serving their sentences. One can only imagine the tremendous anger, distress and upset that this must have caused, not just to the victims and their families, but also to those communities who were devastated by the barbaric actions of terrorist groups such as the IRA. This, alongside the on-the-run letters, was a complete corruption of justice. Some members of this House opposed the Belfast Agreement at the time for this reason and many others, and it is easy to see why. However, we cannot look backwards, but we must try to deal with the present and how we can move Northern Ireland forward to protect the peace process, to create prosperity, and we must do so while seeking to provide some form of closure to victims and families who are understandably still hurting from the past. Victims of wrongdoing should always have access to justice for the atrocities committed during the Troubles. But the harsh reality is that these crimes occurred many decades ago, and the likelihood of successful prosecutions diminishes with every passing day, as we have seen with the recent collapse of several trials. It is obvious that the current system is failing. It delivers neither truth nor justice for the vast majority of families. The emphasis that this bill places upon information recovery will help many families who have waited far too long for answers and may help to bring some closure to the events of the past. This process will allow more information than ever before to be shed upon the circumstances of many of those crimes which resulted in horrific injuries and families losing loved ones. It will also provide certainty to those veterans who for far too long have faced the threat of reinvestigation, something which has, in a number of cases, destroyed the final decades of their lives and inflicted great anguish and pain on their lives and those of their loved ones. It is absolutely appalling that these veterans have been subject to suspicion and have had to live their life in fear of prosecution for so many years. Ending the cycle of vexatious criminal investigations and protracted legal proceedings finally delivers on our manifesto commitment to protect veterans, something that will be warmly welcomed by my constituents in Blackpool. I'm pleased that the government have listened to concerns about automatic access to immunity, which is why it will be granted on the basis of an individual's cooperation with the Commission's inquiries and acknowledgement of their role in trouble-related incidents. This gives our veterans the certainty and finality they deserve, but of course leaves open the door to the prosecution of those who do not cooperate or share information with the Commission. I also welcome the proposal to include an oral history initiative, which would create opportunities for people to share their experiences and perspectives relating to the Troubles. This initiative needs to be handled with the utmost care and sensitivity. There can never, under any circumstances, be a moral equivalence between those who perpetrated violence and those who tried to bring it to an end. An oral history archive can never be used to rewrite history from the perspective of those Republicans who inflicted so much misery on their innocent victims and on the people of Northern Ireland as a whole. We must never agree to a version of history which seeks to legitimise the indiscriminate and barbaric actions of terrorists such as the IRA.
Yes. Very grateful for giving way. Would he also agree with me that we must make sure, as important as it is as an initiative, that it shouldn't be twisted by either side to become, Mr. Deputy Speaker, a recruiting sergeant for future years?
I agree with the points my honourable friend made. Of course, it needs to be fair, balanced and proportionate and give an accurate side of events. It can't be whitewashed by either community. I think that's very important. It's extremely disappointing, Mr. Deputy Speaker, that the Labour Party will be opposing this legislation this evening. And as I look on the opposition benches, the fact that there's just one sitting Labour member in their place, I'm afraid two, I beg your pardon, says it all. In doing so, they will allow the continued harassment of our brave servicemen, seeing them dragged through the courts with unsubstantiated claims, causing pain and misery for their families. And I suspect the reason very few Labour members are in their place this evening is that they see straight through the ridiculous reason the opposition front bench have given for opposing this second reading, which of course is a tenuous argument of their objection to the so-called conditional amnesty, when it was that side of the House, I'm afraid, in the Labour government who opened the floodgates to dozens of terrorists being released 2 decades ago. Mr. Deputy Speaker, I'm pleased to support this bill, and once again I'd like to go on record as thanking the Secretary of State and the Minister of State for their brilliant work and having the guts to bring this bill forward this afternoon.
Gregory Campbell.
Thank you, Mr. Deputy Speaker. And I rise, like many of my colleagues, to explain our opposition to the bill as it currently stands. And it has been explained by several of my colleagues, the issue here is about justice and truth. This year, 2022, is the 50th anniversary of the worst year of Northern Ireland's Troubles. In 1972, almost 500 people died as a result of the Troubles, as we euphemistically call the period. And for that reason, just before Christmas last year, I went to an innocent victims group and asked them if they would organise an event that would commemorate the 50th anniversary, and they gladly did so. And I and some of my colleagues attended that event in St Columb's Cathedral in Londonderry just a couple of months ago. The reason I did that is because, and many of the other things that have occurred, is that there is a tendency throughout the Troubles, and since their ending, hopefully for good and for permanence, there is a tendency to equate perpetrators with victims. And unfortunately, we can trace that back to what happened after 1994. Very often in this House and outside, people keep on relating back to peace dropping slowly in 1998. When in fact what happened was, in 1994, the main perpetrators, by no means the only perpetrators, but the main perpetrators were the Provisional IRA, and they were riddled with informers, and they decided that they had to call a halt. And the Loyalist paramilitaries, who were also engaged in killing, followed suit. And they then engaged discussions and negotiations for a period of years, which then resulted in the Belfast Agreement, which, and I'm glad that some members have conceded this point, at that stage legitimised terror, brought terror into the heart of our political democracy. That's what happened in 1998. People might resile from that and may not like that being brought about, but that's what happened. That's what happened in 1998. We can't turn the clock back. We are where we are now. And I sympathise totally with the government. They are in a very, very difficult position to deal now with the issue of legacy in a way that is going to bring comfort, succour and support from all sides is going to be almost impossible. It is going to be, whatever they do, it is almost impossible. I will give way.
Thank you, Mr. Deputy Speaker, and I thank my good friend for allowing me to intervene. Would my good friend agree with me that in 1994 the Provisional IRA was substantially defeated, and the reason why 1998 occurred is because the Provisional IRA realised that all was lost militarily?
I thank my honourable friend and colleague for that observation, and there is a substantial degree of accuracy in his observation, and we see the outworking of that in the past 5 or 6 years. That is the case. But the problem, and I come back to the front bench of the government here, they are in a very invidious position. But what they have to do, Mr. Deputy Speaker, they have to come to the point where there are many people in Northern Ireland who accept the difficulties that the government are faced with. I don't meet many innocent victims who realistically hold out the prospect for a successful prosecution and limited jail term for the people who carried out the atrocity against their loved ones. I meet very, very few who say that. Most of them say there is a limited possibility, a minuscule possibility, that I will receive justice. But what they do say is, don't extinguish it. Don't put it out forever and a day. And that's what this bill does. Extinguishes it forever and a day. Justice gone, finished, and never coming back. That's why the government, I believe, have to listen to reasoned amendments to make this bill less unacceptable than it currently is, because I don't think we're going to get to the position where there will be an acceptable bill that will command support across the victims' divide and across the political divide. But there is a possibility, if they are open to reasonable amendments, that retain the possibility of justice if new evidence emerges, if it does emerge, that victims want to know that their loved one won't have died in vain. Yes, I will.
Very grateful to the honourable gentleman. Would he therefore agree with me that the envisaged programme motion timetable is woefully inadequate to have a proper debate about those reasoned amendments to try and address the concerns which he and his colleagues have been raising this afternoon?
I thank my honourable friend and chairman of the Northern Ireland Affairs Committee for that observation. We are in danger of agreeing too much today, and I do indeed agree with what he has just said. And maybe the proposed bill has done some good. But in all seriousness, Mr. Deputy Speaker, the issue is, and the Secretary of State made the comment, and I see it headlining on BBC News, that there is a diminishing possibility for prosecutions, and we understand that. But again, diminishing possibility is not the same of extinguishing it, and that's the difference that we have to maintain. I agree and believe that truth recovery can help contribute towards people moving on and accepting that what's done is done, that they would like to see justice, hold out the hope that they might, but at least if they have more information and knowledge about what happened to their loved ones, that would at least bring them some comfort. In closing, Mr. Deputy Speaker, a number of people have alluded to the case of a person whom I knew very, very slightly, the late Patsy Gillespie. He was what was called a human bomb. He was strapped into his own van, instructed to drive into an army camp in Londonderry, and it was exploded with him and 5 innocent soldiers also paying the price of the depravity that was organised by the late Martin McGuinness. He was a 2IC of the Provisional IRA at the time. I had an affinity with Patsy Gillespie because he was an MOD employee on one side of the river. I was an MOD employee on the other side. Just as I have an affinity with 2 of the 3 former members whose plaques are above the door. They died as a result of an undercar booby trap. My family, my wife, and 2 young children, one of them only 4 months old, were the victims of an undercar booby trap device, which, thankful to Almighty God, fell off before it exploded and killed a man, a woman, and 2 innocent children. Let us do work with this bill and try and improve it considerably, because as it currently stands, it is totally and utterly unacceptable.
Jerome Mayhew.
Thank you, Mr. Deputy Speaker. For far, far too long, for my life and beyond, Northern Ireland and the Republic and Great Britain have been scarred by the legacy of violence. History has been politicised and the truth has remained hidden too often. And this isn't historic. The damage continues. For families desperate to know the truth about what happened to their loved ones, the current adversarial litigation system is an abject failure. We just have to look at the success rates. Despite decades of information gathering, hundreds of millions of pounds spent in legal aid, it has been overwhelmingly unsuccessful either in bringing prosecutions and even less successful in securing convictions. So we've talked a lot this evening about justice, the hope of justice, access to justice, the rule of law. But justice is just a word unless it brings results. And with the passage of time and the complexities of Northern Ireland, I'm afraid justice has become just that, a word. And the only winners are the lawyers. It's failing for communities, unable to have their experiences of the Troubles properly heard and recorded. Feelings of isolation, disempowerment and conflict persist. And yes, Madam Deputy Speaker, it's also failing for veterans who, despite near universal failure of litigation, continue to live under the threatening shadow into their 70s and their 80s. And we've heard from the Right Honourable Member for the New Forest. It is the process that has now become the punishment, not the result of litigation. All these people have been and continue to be failed by the current system. So I, for my part, welcome the government's proposals to end adversarial legal proceedings as being the route to truth-finding. An independent commission for reconciliation and information recovery does have the potential to be more effective and will rightly focus on all deaths and serious injuries, and not just those brought into the litigation process, too often as a mechanism for extending division rather than achieving resolution and reconciliation. We need to remember in this House that of the 3,500 people who have been killed in the Troubles, 370 were killed by members of the security services. Overwhelmingly, it's the evidence of former terrorists, Republican and Unionist, that the families and others so desperately need to hear from. For reconciliation to take place, the truth must be supplied by every actor in this tragedy. The UK government will provide a statutory requirement for state bodies to provide full disclosure to the Commission, and I welcome that. But that transparency and openness needs to be the approach of all actors, not just of the United Kingdom government. So linking engagement and cooperation with the Commission to the possibility of immunity from prosecution could create an important incentive to unlock some of the shameful, untold stories of the Troubles, each one of which having the potential to provide answers to a grieving family. But I also recognise in the speech of the Right Honourable Member for Chingford and Woodford Green the suggestion that there may be opportunity to improve the bill by providing the alternative of not cooperating being full prosecution. And I think that's something we should properly explore as we seek to improve this bill. But, Madam Deputy Speaker, the same approach must also be adopted by the Irish government. Last year, it made a commitment to establish its own information recovery scheme. But what has happened to it? Families deserve to know the truth about what happened south of the border just as much as north of it. So, imperfect as this bill may be, I still welcome it, and I hope that the initial positioning in response to its publishing quickly gives way to collaborative working towards the shared vision that inspires it. My greatest concern relates to the consultation process prior to publishing, and I hope that the ministerial team will engage fully with members in this House across the divide and take on board their feedback during the legislative process. The status quo, as we've heard time and again tonight, is broken, and I commend the government for grasping this nettle, and I hope that we work collectively to improve this legislation through the committee stage.
Jim Shannon.
Thank you, Madam Chair. It's a pleasure to speak in this. I thought the Honourable Lady was going to get ahead of me there, but I'm very pleased that she was, by the way, but the day will be the other way round. I first of all declare an interest as a former member of the Ulster Defence Regiment and for 3 years, and also of the Territorial Army for 11.5 years, 14.5 years in total. I believe this is a very important piece of legislation. I have a number of issues with the detail of legislation, such as the fact that it appears that Section 37 allows cases already in the pipeline, such as current cases against soldiers and others, to continue on, which defeats the supposed purpose of this bill, which means that any investigations being undertaken need only the PPS to signal an intent to charge, and these will be exempt. So I wonder I'm anxious to understand how this will stop a repeat of Soldier F that could already be in the system. I have issues with the details, such as the fact that general and specific immunity are not explained fully and would appear to lend themselves to other uses. I have problems with other details within the bill. My colleague and honourable friend, the member for Belfast East, who, as we've come to expect in this House from him, queried and posed the questions with a greater ability than what I am ever able to do. The honourable member for Chingford and Woodford Green, he's not here, but he referred to his friend and Robert Narrick, who died, and he served with him and has been on his heart.
Deputy Speaker, on the subject of Robert Norrick, as was said by my honourable friend, right honourable friend earlier on, we think Captain Norrick died on the 15th of May. We don't know. There are people that know where his remains are. When I was the minister in Northern Ireland, people told me they knew, north and south of the border. Perhaps we might find the truth for my captain of C Company, the 1st Battalion Grenadiers.
Thank you for his intervention, and he very clearly outlines the case that he's a friend of the honourable gentleman as well, and we all understand that, as is the honourable and gallant member for Beckingham as well. But I just want to speak and
just once more. I didn't want the House to be misled, Madam Deputy Speaker. I was a guardsman. Captain Norrick was a captain, and in the Guards, you know where your position in life. However, I did spar with him in the gym a few times and gave him a couple of good digs.
Well, you served along together, and I think that's the important thing to put on record. I want to do something from a very different point of view and speak about the victims, because I think in the middle of all this debate, the honourable friend for East London Derry referred to it, but I think it's really important to focus on that and what to do now. So I just don't want to speak as Jim Shannon, MP for Strangford. I want to speak as the cousin of Kenneth Smith.
I'm grateful to the honourable friend for allowing me to intervene, and I think it is important for the House to recognise that sometimes politicians talk about how powerfully these things affect us, but I think it's fair to see that in the honourable member's contributions throughout the years, he has brought a great deal of personal empathy and emotion to these issues, Madam Deputy Speaker. So I make that intervention, and I will talk perhaps longer than you would normally permit in an intervention, if that's permissible. And I'll look round for a nod whenever the time is appropriate. But I do.
Order. I would just like to say that if the honourable gentleman would like me to come back to him after the honourable lady, I'm quite happy to do that if at any point that's what he feels.
My brother William and I used to go down to my cousin Kenneth's back in the 60s. My cousin Kenneth took us shooting, and we were introduced to country sports at a very early age, something that I love today, and I've introduced my son and my grandchild as well to it, so it's something that we instilled in us. Those are different days in the 60s, Madam Chair, and what they are today, and what they were in the Troubles. And I thank the honourable friend for intervening. I should have said that right away. But I do remember him with a real fondness. And Kenneth Smith and his Catholic friend, Roman Catholic friend, Daniel McCormick, were murdered on the 10th of December 1971, 50 and a half years ago. I remember that day like it was yesterday. I probably always will. I know it affected all our family up in Clary and Strabane where we lived. And Strabane, Clary is a wee small village outside it. We have absolutely no doubt, Madam Deputy Speaker, that the people who were involved in the murder of Kenneth and Daniel McCormick came from that village or were associated with that village. I couldn't name the names, but I'm not going to name them here. I don't think that's really important to do so, but I do feel that hurt. Daniel McCormick left a wife and 3 young children, got £3,500 from the Northern Ireland office as compensation for loss of her husband and a father to the children. How does that give us justice? It doesn't give me justice, Madam Deputy Speaker. I don't think it gives anybody in this House of justice. So what I see in this legislation, unfortunately, is a legislation that doesn't take into consideration the position of myself as a victim. It takes in the position of Daniel McCormick's wife and family either. So my mum and dad, my grandfather and grandfather, the family dispersed almost immediately within months in that area. I know that my cousin Joseph went to America, where he's been all his life, and marrying his wife and the children that they had. And my Aunt Isabel sold the farm. My grandmother grieved, as did my grandfather. My grandfather died of a broken heart. So that's the story of the victims, which we don't hear much about, but we should, because that's what's really important. That's what I want to talk about. I want to talk about the 4 UDR men killed in Ballydugan, because I speak as a man who loved to chat with John Birch, born in Ballywalter, one of the Ballydugan 4. I knew that I was there, not there, but I was aware of it. I was around about the time he was born. I remember Stephen Smart from Newton Ards very well. Him and his dad, Sammy, and I were best mates, good friends, you know. Michael Adams, a wee butcher from, he worked in a butcher shop when I had the business, and I knew him from that, and he always knew he was going to be a soldier, and he joined the territorials, which I was in at that time, and I remember that very well. So again, we had to bite back the tears when I learned that the £1,000 bomb at Ballydugan took their life and the life of Lance Corporal John Bradley, whose widow I spoke to recently as well. So again, victims, Madam Chair, nobody ever made accountable. The IRA did that and got away. So you understand what my honourable friend Harry Sullivan-Derry says when he says, if there's even a smidgen of a possibility of making them accountable, I want that for my constituents. I want that for the victims that I'm going to speak about. I speak as the MP for young John Birch, who's John Birch's son, who came to see me, telling me of the grandchildren that his dad would only meet in the next world. Asking me, could he ever expect to learn of who carried out the atrocity that robbed him of his childhood and his role model on that fateful day on the 9th of April, 32 years ago. Victims, Madam Deputy Speaker, 4 victims with their families, with their children, and this legislation, this bill, does not give them justice, does not deliver for them, and I feel incredibly annoyed. Stuart Montgomery, I knew his dad Billy very well. Billy and I were friends for many, many years. Stuart Montgomery was 2 weeks out of the police training college, killed in a bomb at Pomeroy, along with our police constable. Nobody ever made accountable, Madam Deputy Speaker. Justice? Not in this bill. Not for Stuart Montgomery. Not for them. Lexi Cummins, I mentioned him earlier on. Lexi Cummins was shot by an IRA man having his lunch in his wee mini car in Strabane. He's a member of the UDR. He was when the boys shot him, they got the fella, by the way. They made a slight mistake in the summons, which meant when he came to court in Oma, that the summons had to be rewritten, and that time he got out of the court, got on a bike and cleared off across the border. My honourable friend from East Londonderry knows the story only too well. That guy's a prominent politician with a Republican Party in Donegal at this time. So you understand, Madam Deputy Speaker, why I feel sore and why I feel aggrieved. Happy to give way.
And I say this in all humility to my honourable friend, who I have huge affection for, and you can see the emotion and the anguish written all over his face as he talks of his friends who've been victims in this conflict. And he wants that 1% chance, and that 2% chance of justice. But can I ask him, at what cost? Because I know he also feels that aspects of this process are deeply unfair. At what cost do we keep going down that rabbit hole to get the answers that I know he authentically, genuinely wants to find, but some of us feel on this side is not possible?
I thank Gilliam's done for giving way, but there is no price in justice. I'm trying very, maybe haphazardly, maybe not with the focus that I perhaps should, to put forward the case on behalf of the victims and why this legislation doesn't deliver that. And by the way, those people I mentioned, the 4 UDR men, my cousin Kenneth, Daniel McCormick, and Stuart Montgomery, 7 people, Madam Deputy Speaker, who served this country, who wore the uniform that the Honourable Gentleman wears, or did wear, and those people haven't got justice. And I feel annoyed. I was just thinking today about other ones. Abercorn comes to mind, an IRA atrocity against innocents who were brutalised and murdered and maimed forever. And the Darkley Hall massacre, where the people who were worshipping God were also murdered. And then, lastly, Le Mans. And I think of Le Mans because it's my constituency. The Honourable Gentleman who spoke, I thought spoke extremely well, and I think he encapsulated perhaps maybe what I'm trying to say, and perhaps maybe in my own broken form. But the Le Mans, where people were burnt alive, they were members of the Coley Club, the Kennel Coley Club. They weren't soldiers, but they were murdered, brutalised, destroyed. Their lives were changed forever. I can remember that day very, very well. So those victims, where's the justice for those victims within this legislation? I don't see it, and it grieves me to think about it. And of course, the person who was in charge of the IRA commander who was in charge and who was responsible for that bomb at Le Mans, it was a very prominent member of Sinn Féin. He just happens to be slightly retired now, but he's still there, you know. Yeah. I speak as someone who has watched investigation after investigation seem to focus on one narrative, on one viewpoint, that focused on 10% of the atrocities, leaving the 90% wondering why their pain and sorrow meant less. I tell you what, the pain for my constituents is no less than anybody else's pain, nor is mine either. Who had heard the cry of the ex-RUC, the ex-UDR, the ex-prison officer who has been re-traumatised by investigations as designed to specifically deemed and pursued by Republicans to justify the atrocities that were carried out. I speak as someone who understands very well the frustration of ex-soldiers being called to discuss an event of 50 years ago when they can't remember their shopping list for last week. I understand that. I understand it very well. I speak as someone in this chamber who has lived through the Troubles, who has had an intimate knowledge of the pain and despair caused to so many in Northern Ireland, regardless of their religion or political affiliation. But as my cousin Kenneth served alongside his Roman Catholic friend, they were best friends. One was in the UDR, one had left. The IRA killed more Roman Catholics in Northern Ireland than anybody else. Yeah. So you understand the victims, the way we feel, the pain we have, the soreness we have, and how we are with the things that we have in front of us. So I believe this, Madam Deputy Speaker, gives me the right to speak in this chamber with some authority when I say that this bill does not achieve the aims, this bill does not deliver justice, doesn't answer the anguish or the grief of families that I speak for or that I want to speak about. Not only does it draw a line under current cases, does it offer justice to my cousin Shelley Kilfillan, who my right honourable friend knows extremely well. She's involved with the victims group up in West Tyrone. She has mourned her brother for 50 and a half years. So many others, because their cases do not have a live investigation or a firm suspect that can be asked to give information in lieu of immunity. Those murders are well covered with their on-the-run letters. The gentleman who killed Alexei Cummins, he had an on-the-run letter. He got across the border. He's had a new life. Alexei never had a life after he was murdered in Strabane after all those years. So you can understand why we just feel a wee bit angry, a wee bit annoyed on behalf of my constituents and how they feel, and why this legislation for them does not deliver what it should. I'm quite happy to.
Thank you, Madam Deputy Speaker. I thank my honourable friend for giving way, and I'm sick in the stomach that murderers are apparently going to get away as a result of this bill. It really is the fly in the ointment of this bill. It's an imperfect bill, something that I fundamentally feel is wrong, that murderers get away with it. But I honestly now feel we have little choice, much as it makes me puke. Thank you, Madam Deputy Speaker.
Madam Speaker, I think we all like him. I probably love him. It's not a secret. I think he's a great gentleman, and I understand and respect his honesty. I have to say we have to disagree in this. The honourable gentleman will hopefully understand my point of view. I want to conclude, Madam Deputy Speaker. I'm sorry I went on a wee bit. I apologise for going over the time. Whilst I thank the members opposite for seeking to give a platform for us to move forward, and I think they have, but they haven't done it right. And I know in my life we don't get things perfect all the time. We don't always get it the way we want. But I think in this bill we get imperfection, and imperfection rules. And therefore, on behalf of my constituents, on behalf of my family who still grieve, then I would urge greater engagement with individual victims and better legislation, not this legislation before us today, better legislation to be put forward together, which puts the victim at its heart and which addresses the aim to prevent the current attempts to rewrite history, pitting the guilty as a warrior for justice against an oppressive state. The bill, in my opinion, and I believe of many in this side of the chamber, Madam Deputy Speaker, and there are many in this side of the chamber. I'm very pleased to see the honourable member in his place who have served in uniform in this side of the chamber, and as well, and we shouldn't decry people when there's people here who do the same thing. I believe this bill, in my opinion, achieves neither of these goals. With that in mind, I will always speak up, as I always have, Madam Deputy Speaker, for the victims. I'm going to always speak up for Raymond McCord's not here, but if he had been here, I'm speaking for Raymond McCord as well. I'm speaking for all those people who have lost loved ones, who grieve grievously today for those who have passed away, even though it might be 50 years ago, 32 years ago, 20 years ago, or longer, because that's what it's about. This legislation doesn't satisfy my constituents, it doesn't satisfy my family, and we want justice. I want that wee light of justice. I know when I burn the rubbish at home, man, and just a wee light. You know, the wee light that you, when you write the match, and all of a sudden it doesn't seem to do very much, but that wee light can burn the fire. And I think I want to see that wee light becoming a fire when I don't see this legislation being the way to do it. Thank you.
Claire Hanna.
Thank you very much, Madam Deputy Speaker. The legacy of the conflict is like a fog all around us. It affects politics in the everyday, and throughout this afternoon we've heard a few glimpses of stories, and I know members will know every time you meet a group, every different book you read, you hear a story that you haven't heard before, that was heartbreaking, and each one of them was senseless. It was a loss. It completely changed the future and changed the lives of those families, and each of them is deserving of justice. And it's very understandable that people say we need to move on in that sentiment, but nobody wants to move on more than victims and survivors. But unfortunately, this bill and the way that legacy has been approached over recent years won't let them do so. It is blandly declared as being about reconciliation, but in fact it's going to be a barrier to truth and a barrier to reconciliation. It is pretending to be about truth and reconciliation, and it's difficult for people to shake the belief that, again, like other major challenges facing us in Northern Ireland, this owes a lot more to placating parts of the party opposite than it does to a real good faith attempt to get information to victims and survivors and to aid societal healing. And in the face of opposition from I think every victims group, from academics, from legal experts, from international commentators, and without the express consent of any political party in Northern Ireland, for the government to present this legislation and to present it as a fait accompli without the normal engagement is an act of institutional hostility, and it is unwanted and it is unworkable. Ensuring the success of any legacy initiative requires independence, and that's crucial for the credibility. But unfortunately, this government isn't independent on legacy. State actors and agencies were party to the conflict. Many of their personnel were perpetrators, and while of course many served to the best of their ability and faithfully, in many cases it did collude with paramilitaries, and in direct conflict with the Stormont House Agreement, this bill places very expansive and very extravagant powers into the hands of the Secretary of State in a government that isn't trusted by a large number of people in Northern Ireland, and with a bill that does explicitly override devolution. But senior personnel will be appointed to this new body by the NIO and by the Secretary of State. Rules on immunity will be made by the Secretary of State. National security and other vetoes, which have for many years been used as thwarting mechanisms, will be in the hands and the whim of the Secretary of State. Persons responsible for oral history will be in the hands of the Secretary of State, as will the budget. And the purpose of this is to embed the control of the Secretary of State, and it is to embed control of the narrative and the outcomes. The command paper in 2020 was an explicit amnesty, and this is the same thing but in a less explicit way, but it's clear to everybody what it is. The approach is structured to make it routine and foolproof for perpetrators to get amnesty. Amnesty must be granted where a person has provided an account which is true to the best of their knowledge. That's a subjective test, and there's no test being proposed to test the actual truth of a perpetrator's account, and the perpetrator knows that the amnesty is available to them, and it must be granted if what they say, what they assert to be true, is so. And there needn't ever be any word about those who called the shots. The claim that prosecutions may follow for those who don't take part rings very hollow when no new investigative body or pathway for prosecution is created, and the fact that or the ability of the DPP to pursue prosecutions is theoretical, because if this bill passes they won't be able to. Members have glibly referenced things not being proven in court. They won't be able to be proven in court if this bill goes through. Members have also mentioned South Africa, but this is so far removed from South Africa, where victims provided impact statements, where victims could be present along with their lawyers who could cross-examine applicants. Under this bill, it's not even clear if victims' families will be notified if an amnesty is granted. And however much members do not want certain offences to be in the bill, it is very clear that sexual violence is going to be covered in this amnesty. We know there were people who conducted and covered up systematic sexual abuse within paramilitary organisations, and they too will be eligible for immunity under this bill. So it's very clear to everybody who this bill is for. It's not for the people who have carried the weight of the conflict for decades. It's for the people who have the most to hide. In the autumn just past, as a delegation of TDs and senators and MPs under the Oireachtas Good Friday Committee, one afternoon we met with a variety of different victims and survivors about a range of issues, and one thing that came out quite organically in a number of conversations I had that day is a pattern about the trauma that is compounded for bereaved people through the denigration of the victims by those who killed them. The daughters and sons of people who were murdered by the British Army in Ballymurphy in 1971 told us about the marginalisation and the shame that they faced for many years as allegedly the daughters and sons of IRA men and women. Paul Gallagher, who was paralysed aged 21 when the UFF took over his home to murder his neighbour, suffered the further indignity of the man believed to be responsible for that shooting, saying that he shot him because he was a provo, and he said that those words hurt more than the 6 bullets that entered his body in 1994. Columba McVeigh that afternoon, his brother, he was a teenage boy who was disappeared by the IRA, and his family still haven't been allowed the basic dignity of a body to bury. And he was made a known person by allegations that he was a collaborator, allegations by an organisation that we now know was riddled with informants and who thought that that was an acceptable thing to do to a teenage boy. But this bill waves through immunity for each of those killers, and people really need to give their heads a wobble if they think that those perpetrators are just going to go quietly and aren't going to use their new get-out-of-jail-free passes to firm up their very self-serving versions of the past. And as my honourable friend for Foyle explained very clearly, we have an example through the Independent Commission for the Location of Victims' Remains, which was established in 1999 to give some comfort to those families who have been left without a body to bury. And despite immunity, despite it being risk-free, only half of those cases have been solved. Alongside amnesty, this bill pulls down the shutters on the alternative pathways to justice and the existing patchwork mechanisms for dealing with the past, because, as I said, the architecture hasn't been put in place to do this properly. It has been weakened by refusal to implement judgments of the European Court of Human Rights. It's been weakened by delays in the provision, but it seems even those piecemeal provisions have brought forward too much truth for some people. And the Secretary of State's arbitrary diktat on Tuesday that did force dozens of families to try and race to issues proceedings, and it washed away years of good law and practice with a casual statement, not even made to this House, a table statement. It was yet another coach and horses, and families who have been promised in good faith by the legal system are now thwarted because their place in a queue over which they had no control is lost. Inquiries and inquests are far from an ideal method of dealing with these issues, but they have been delivering some outcomes for families and the wider society. Members across have used the Canova and John Boucher as some sort of an amulet in defence of this bill, but in fact it has advanced huge amounts of information to families about the IRA cover-up machine. Members have mentioned as well inquests in my constituency, the Sean Graham bookmakers killing when loyalist paramilitaries killed 5 civilians, Catholics, and it later emerged that one of the weapons used was part of a shipment of weapons organised by a military intelligence agent, and another weapon that was handed in to a barracks elsewhere in the constituency was ultimately handed back to those paramilitaries. This information hadn't been disclosed, and this issue about the cycle of re-investigations, they weren't investigated properly in the first place. Many victims never spoke to a police officer, and that's why these issues have come back up. Madam Speaker, oral history and the exploration of themes and patterns is also going to be mingled if this bill becomes law, and we're very clear that there isn't a pathway to justice for absolutely every family, but oral history has been a way of giving voice to victims and survivors and capturing some of the complexities of the conflict and understanding the deep and the tangled roots. But this bill denigrates that approach. It's using it as window dressing for what is impunity, and those who've waited for decades and had the shutters pulled down, are they going to now be sent to go to the library and read about things and for people who have been handpicked by the Secretary of State to tell their story? I just want to finish. Members have cynically used the failure over decades of successive governments to address this as an excuse to now get Northern Ireland done. But it's a consistent and recorded frustration of the SDLP that the needs of those who suffered the most have not been addressed, while perpetrators and politicians have gone on to a very bright future. In every single negotiation, and there have been 5 or 6 over the last 20 years, the offering and the outcomes for victims and survivors is watered down absolutely every time. And everybody knows that the Stormont House Agreement wasn't perfect, but it was an international bilateral arrangement. It had the support of most of the parties, I think all of the parties in this House, and that is no mean feat. But it hasn't delivered because it hasn't been actioned and it hasn't been allowed to be delivered. And instead, this bill, this interference in the justice system, undermines the rule of law and blocks all pathways to truth and to reconciliation. And deliberate fiction is being created today that this is about reconciliation, and it is clear that 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 is hollow. And the message is going out today, not that you will ever have to account anybody who has used violence for their political ends. The message is going out that in a number of decades, if you did this in a uniform, if you did this in a paramilitary organisation, then in a few years the record will be wiped clean. And that's an awful message to send to families, and it's an awful message to send into the future in our turbulent part of the world. I'll finish. The member for North Antrim referenced Dairy Girls, which isn't a sentence I ever thought I would say, but that very moving episode did show how living and breathing the values of the Good Friday Agreement are for all of us. But I will quote Erin and Michelle in their discussion. They said very clearly, none of this stuff is easy, but just because it's easy, it's not easy, isn't a reason. You can't keep closing the door to truth. Every conflict around the world will show the truth will out. People need to understand it's not going to go away. This bill won't let those victims and those survivors move on, and I urge you to change it.
Shadow Minister Tonya Antoniazzi.
Thank you, Madam Deputy Speaker. It's an honour to be able to close this debate on behalf of the opposition. And what I want to make clear here is that we are not opposing this bill for opposition's sake. This is a flawed and damaging piece of legislation which doesn't serve victims and survivors, doesn't heal the wounds of communities, doesn't allow Northern Ireland to move on. And we know and understand how challenging this is. For so many, to hear the emotion in the voice of the Honourable Member for Strangford really hits home. How his voice as a victim and the voices of the victims need to be heard is important. And as my honourable friend, the member for Rochdale, has said, this bill doesn't deliver the justice for victims or veterans, and many veterans are also victims. The bill as it is, as we have heard throughout this debate, demonstrates a woeful lack of understanding of the situation faced by families and communities affected by the Troubles, and an off-handedness towards groups in Northern Ireland, including the Northern Ireland Human Rights Commission, who have not even been consulted on these proposals. Victims and survivors often don't speak with one voice on these issues, but in this situation the government have miscalculated. And all the victims and survivor groups that we have heard from are singing from the same song sheet. It is the government that have misjudged the mood. Indeed, as the Honourable Member for Foyle has said, he can't find anyone apart from the benches opposite who want this bill to pass. And the Honourable Member for Belfast East, he spoke about those elected in Northern Ireland. They do not represent one single view on legacy. And so, when the Honourable Member for South West Wolverhampton attacked the Labour Party for not standing up for veterans, Madam Deputy Speaker, it was hurtful and frankly deplorable. I will.
Madam Deputy Speaker, I'm grateful for the intervention. The point I have made throughout this debate is one member of the Labour backbench spoke throughout the whole debate, the many hours we've been in here, and I think that's offensive, and it will be resonated throughout the veteran community that they have not put a debate across and they have not argued the point for veterans.
Thank you, Madam Deputy Speaker. I think that the Honourable Member from South West Wolverhampton really, what he needs to reflect on is this is not about us today. This is about the people in Northern Ireland, and this is the start of a legislative process where we will all be represented. It's not appropriate and very hurtful if we continue to be sedentary and chuntering on, and I would rather I were able to make progress. And the Honourable Member for Skipton and Ripon has displayed in his speech from the government benches the integrity and the understanding of the people of Northern Ireland, which is precisely why the government needs to reframe this bill. The government has said that they have learnt lessons from South Africa, but there are significant differences between the two processes, which will in our opinion, not solve problems, but in fact will cause problems in the future. Firstly, the independence of the entire process. The bill gives the Secretary of State sweeping powers from being able to appoint people to the Commission and over the process of the Commission. Let's just take this following paragraph from section 20, titled Determining a Request for Immunity. It says, the Immunity Requests Panel must take account of any guidance given by the Secretary of State when deciding in accordance with section 18(7) whether a person should be granted specific immunity from prosecution, general immunity from prosecution, or specific and general immunity from prosecution. The word must in that sentence is doing a lot of heavy lifting there. What it is saying is that the Secretary of State can make a judgment on whether a person be granted immunity in specific cases or even in general. And this is on top of the guidance the Secretary of State can give about whether conduct is possible criminal conduct. These are not judgments that any Secretary of State should be making. The government are leaving themselves wide open to legal challenges.